Okay, all right. Now to officially set sail for the day, it's my privilege to invite the captain of this incredible initiative, the driving force behind Maritime Shio itself, a woman whose leadership has transformed the tides for the women in maritime. Ms. Sanjan Sai Gupta, can I request you, ma'am, to come on stage once again?
Good morning once again, and I'm sorry for the delay we've had. So welcome to the very first AnchorCon. This right here is history in the making. When we began planning the Maritime Shio conference, we dreamt of a day that would go beyond inspiration, a day that would anchor our ideas into policy, into governance, into real change. Today, that dream takes form. AnchorCon is about one simple truth. If we want to move forward in the maritime world, we must strengthen what holds it steady: our frameworks, our standards, and our shared commitments to fairness and inclusion. Because the world is changing: decarbonization, digitization, diversification, the three big Ds. We can't navigate tomorrow's seas with yesterday's maps. I often think of an old ship captain I met once. He told me, "Ma'am, when you drop anchor, it's not to stop. It's to stay steady till you find your next direction." And that's what AnchorCon is about: steadiness with purpose. Today, as policymakers, industry leaders, and innovators, we're not just discussing rules, we're redefining the principles that will steer maritime governance into a future that is sustainable, digital, and inclusive. Let's talk about what truly matters, about giving every voice, every nation, every woman a place at the table, about ensuring that safety, equity, and sustainability are not just paragraphs in policy, but pillars of progress. AnchorCon begins today, but its impact will ripple far beyond this room. That is my hope. So let's dive deep. Let's anchor our vision, and let's make maritime governance the stronger it's ever been, not just for the industry, but for all the generations who will inherit our seas. Welcome to AnchorCon 2025. Let's begin this new voyage, anchored in purpose. Thank you.
Before we move ahead, we'd like to take a moment to extend our heartfelt gratitude to all our sponsors. We express gratitude to our platinum legal sponsor, Renata Partners, our gold legal sponsor, Ship Law CFZ LLE, our silver legal sponsor, Ascot and Fitch, and our legal excellence partner, Fitch & Co. We also extend our wonderful thanks to our session partners, Asia Legal and A&B Legal, our ticket partners, Binnacle Legal and Satchanam Legal, as well as our supporting partner, SCMA. Thank you for believing in this vision and for standing alongside Maritime Shio in championing diversity, motivation, and inclusion. Okay, now to set sail, we are honored to welcome a visionary leader in the global maritime industry. His work has shaped international cooperation for sustainable and intensive and inclusive shipping. Please join me all in welcoming Mr. Jose Mathical, Director, Technical Cooperation and Implementation Division of the International Maritime Organization. Sir, please may we welcome you on stage.
Good morning. Good to see you all, and it was very impressive to see a lot of women also in this first conference, Sanjam. Congratulations for getting this started in India. I just want to start with something. When I thought of law and ocean governance and also what IMO does was what came to my mind was something that happened a couple of years back. I think it was October 25th, a night when there was a fierce storm, in the Pacific side of Mexico. The visibility was almost zero, and the waves were so high. It's quite bad. And then came 4 Mayday signals from 4 ships saying ships are in distress, crew, in water, life is hanging, there are threats. There's no Coast Guard nearby. There's no Navy ship standing by. And there was a small vessel, I think forgot the name, it's Maya, and it was actually also in the same storm. It was not trained for any rescue at that time in the waters. They were not trained for any rescue, but they still took that signal and they responded. And they went for the rescue for this distressed vessels. It was really bad. It was blinding rains and monstrous waves, and they still navigated through that to reach this area. And they identified these ships. They actually saved this crew one by one, hauled them from the water, and it was quite bad, but they just got all of them live. 6 of them actually live. And so I told this story not to say the heroic act in the sea. It was actually. In fact, IMO recognized this by giving them the Bravery of the Sea Award last year to this captain. I think it's Jorge Fernando and his crew. They received the award for that bravery of saving lives. But it is not just about the bravery. In my view, it was also about the law. Because in the International Maritime Convention, this is specified that, when a ship is in distress, it's the duty of another ships to go and rescue them. So somewhere, someone had sat in a room like this and drafted a clause that actually obligated the master to go and help another ship. A clause that came out of compassion but enshrined in the law. And I'm saying this because that's, and actually it worked. It worked because in a week's time, one of the crew members sent a short note saying that, look, I'm alive today because somebody had believed that regulations or law is not just about some rules, it's also a responsibility. And thanks for making us believe in the law of the sea, the SAR Convention, and the SOLAS, so that we are trusting that because it worked. And that's the beauty. That's the beauty of what many of you do in this room. By drafting, and as lawyers, and I know who then, others also, some of them are at least connected, and you are not just, drafting a clause, but actually writing life-saving, in fact, lifesavers. So in the story, I think there's a lesson because, yes, we want to remain, connected as a maritime community, but the law allows us to be united in justice, and that's the beauty of it. And it's an amazing job that the maritime lawyers do, and drafting all this. It really, every regulation that we develop, every audits that we do, and every training that we do is actually has the potential to save lives, has the potential to preserve the environment, and actually ensures that we are united in justice. So when it comes to, that was just the story I wanted to say, and I do have a speech, but I'm not going to read all that speech. It's as I said, often without the law, the sea would be a chaos. And it is, our oceans, and it's borderless, and it's governed not by force, but by trust. And I think that's what Anchor Corn, I think the word anchor is almost about anchoring in trust. And you know, IMO, as many of you, I'm not sure how many in this room is familiar with the International Maritime Organization. I'm sure some of you are. You know, it stands as the legislative and the normative engine for international shipping. 176 member states, and you know, we do have a number of conventions that actually governs all this. We have the safety aspect covered by the SOLAS, the Load Line Convention, and the STCW, that for the training. For the environmental protection, we have the MARPOL, the London Convention and Protocol, the Ballast Convention, the Anti-Fouling Convention, and the Hong Kong Convention for ship recycling. We also have the liability and compensation and security-related conventions such as ISPS, and I know that some of the ports colleagues here are familiar with the ISPS code. These are not just legal, texts. They are living compacts of cooperation, uniting nations under one single principle, that the sea must remain safe, secure, and sustainable for all. Now, we are also covering some new legal frontiers. So the maritime domain is evolving faster than ever before. Now, we are working on the development of the MAS code for maritime autonomous surface ships, in redefining some of the terminologies in these conventions, such as understanding of master. What is the definition in an autonomous ships? Crew, responsibility, what does it mean? All these new definitions when we move towards autonomous shipping. The expansion of digitalization and cybersecurity framework. You know, we need to develop guidelines, and IMO is working on it, but it still calls for more robust legal clarity and global alignment in all these areas of security as well. And then you have this climate law and maritime law, and these need to be integrated. So, and that's where IMO is working on developing the GHG strategy, emission-related strategy, the carbon, the pricing mechanisms and the fuel standards. So there's a lot of work to be done, and the legal framework have to define all this. And we are doing that through the MARPOL Annex 6 amendments in IMO. The Hong Kong Convention, which is about the circular economy of the ship recycling, as Annex 6 tightens the control over emissions, our legal order is entering the new area, one that's safety, sustainability, and social responsibility. So law is no longer just a guardian of order. It is now an instrument of transformation, and it has the potential to transform. But let's be honest, the adoption is only the first step. Implementation remains the greatest challenge. We can draft all these fantastic conventions, but if you're not implementing it, there's no use, especially for the developing countries and the small islands. And we do audits, of the IMO member states. Every member state goes through an IMO mandatory audit to assess the standards and the gaps. One very common finding that comes out from many of these audits, in fact, almost, especially in the developing countries and the small islands, is the lack of the legal framework. So we have a long way to go to initiate these things with the legal framework first, and then building the pillars on top of this. So this is a common finding, and I think that's where we all need to work a lot more on this. And when it comes to the women in maritime, there's a lot of contribution that group can do as well. We are also initiating specific region-specific initiatives. Because of the challenge in the small islands in the Pacific, we are starting a project to help them to develop the legislative framework in the Pacific Island states. We are going to Caribbean for the same reasons, to help the island states to develop legal framework. We have a beautiful institute, IMLI. I don't know how many of you heard about this, International Maritime Law Institute. That's in Malta, and that is established by IMO. Actually, an Indian Secretary General established it, looking into that future, Sir Srivastava. It is actually training maritime leaders And they are becoming leaders in the respective countries when they go back. So if any of the prospective lawyers here wanting to get a bit of a training in IMLI, please do look for the opportunity because it's fantastic in terms of networking as well. So I'm not going to talk too much, and I think I've covered most of the points. I know we are running short of time, but I just want to highlight one aspect, the inclusivity and the women inclusion, law with a human face. And I know that we have gathered under the Maritime SHIO umbrella, and it is a reminder that diversity is not a footnote, it is a foundation. Yeah, and I'm so happy to see so many women colleagues attending this law-related conference. It is a foundation, diversity. Yeah, women have always been part of the maritime history, from the ship owners and pioneers in admiralty law to the new generation of legal experts shaping international frameworks, and some of you are here. At IMO, we see women lawyers, negotiators, and scholars leading, delegations. A number of women, are leading the delegation from the countries. They are drafting treaties and chairing committees. In fact, we made a kind of an internal policy that the committee should have the chair of the committee should have a bit of a balance, not just the men. So we are looking for the diversity in IMO. IMO has a Women in Maritime program, which you may be aware of. And in fact, I was just telling Sanjam and others, Secretary General and myself and other directors, we now refuse to attend any panels if there is no women. And we plainly say no. Yeah, and I think we need to do, I hope many of you can actually also probably practice that, that you have any other opportunity, insist on that. No, we are not coming unless there is diversity. So we need to walk the talk. So, so again, let me conclude this. I know we are running short of time, but I really see the great value the law communities are bringing to maritime, the safety, the governance of oceans, and especially the involvement of women and the women leaders in making sure the oceans are governed better. So thank you very much for IMO and Sanjam inviting IMO to be here, and it's a fantastic initiative. I know it's the first step, but you gave it the start, just like you gave it for Maritime CEO, and it will only be successful. Thank you very much.
Thank you, Dr. Mathikal, for steering us towards a more inclusive and responsible maritime future. Now we extend our warm welcome to Mr. Thomas Kazakos, Secretary, International Chamber of Shipping, a respected global maritime leader whose contributions continue to strengthen the collaborations of the shipping industry. Mr. Kazakos, please may we welcome you on stage.
Ladies and gentlemen, learned friends, if I may use my background in education, and of course, inspirational Sanjay. It's a great pleasure to be here today, and how do you match a speech like that before? But I do start with an apology because some of the things I'm going to say is part of what I've said yesterday, of course, at the Maritime SHIO conference. But I do believe, like you also said, Jose, that events like this are very important for our industry. So yesterday at the Maritime SHIO conference, we spoke about the importance of people in driving the industry forward. Today, I was asked to go a bit deeper, and I would like to speak how we protect, support, and empower the very people that keep the world moving. As all of you, I'm sure, know, close to 2 million seafarers, several more than 75,000 ocean-going vessels worldwide. They are the hidden workforce that powers the global economy. Every day they move goods worth over 14 trillion US dollars. This is about 90% of the world trade. Without them, global commerce will come to a standstill. On their behalf, we saw their commitment very much during the pandemic. Seafarers worked through uncertainty and hardship. They deliver food, medicine, and essential supplies to every corner of the world. Their professionals encourage reminded us all that shipping is not just about logistics, it's about humanity. Seafarer welfare, therefore, must always come first. When we speak about sustainability, we must include the welfare of the people behind the ships. We must therefore redefine what it means to have a career at sea. Our seafarers' huge contribution to international trade and everyday life must be recognized. They must be treated as professionals, not as commodities. And they should be offered the growth opportunities and the chance to move between the sea career and, of course, later on, shore careers. The human-centered approach is essential if we are to solve the growing workforce shortage. Our industry is estimated to need around 90,000 additional seafarers by 2026. We cannot fill that gap unless people see seafaring as an attractive, respected, and rewarding profession. Despite our efforts to change this, many young people still do not know what a career at sea offers. Unless they have a family connection, they seldom feel that maritime world is somewhere distant from them. So we therefore must continue our efforts to change that. We must continue going to schools, speak to students, share what industry can offer. Seafaring is not just a job. It is a career that builds character, teaches resilience, and opens doors to a global community. This is something that is well known in India. According to our own Seafarer Workforce Report of 2021, India is a leading supplier of seafarers, especially for officers. We must continue to support the wonderful maritime institutions that are providing the training and education to the future generations of seafarers. Governments, unions, and employers must enhance their joint efforts to create career paths that reflect the reality of modern life. A person's journey may not always remain at sea. There must be opportunities to move ashore, to grow, and use their seafaring experience in other areas. This is how we attract and retain talent, and it is how we compete with other industries that are also searching for skilled, motivated workforce. Redefining, therefore, the social attraction of working in shipping is not a luxury, it's a necessity. Diversity is also key to building the workforce of the future. We've covered that yesterday, but we will continue to do it at every opportunity we get. Shipping must be open to everyone, regardless of gender, race, faith, or orientation. A diverse workforce brings creativity, innovation, and strength. It also reflects the global nature of our industry. By doing this, companies can access a wider pool of potential employees. More than half of the population are women, after all, and most of the times better educated and more brainy than us. And by being inclusive, we can create a positive working environment that people want to be part of. The ICS is working hard to protect the rights and dignity of those who serve at sea. We know that seafarers face risks that go far beyond storms and rough seas. Too often they face legal and political challenges that threaten their liberty and well-being. We always say that 90% of global trade moves by sea. Yet, when a ship is involved in an incident or alleged crime, it is often the seafarers who suffer first. Many are detained unfairly or held for long periods while investigations drag on. These detentions often have no basis in law and can destroy lives and families. As ICS, this for us is purely unacceptable. Seafarers must not be scapegoats. They must be treated fairly, with respect for their human rights and their role as professionals. ICS has worked closely with the IMO and the ILO to change this. Together, we have developed the guidelines on fair treatment of seafarers detained in connection with alleged crimes. These guidelines were approved earlier this year. They are an important step forward. These guidelines make it clear that seafarers have the right to legal representation, to translators, and to due process. Detention must be lawful and no longer than necessary. They call on governments to ensure that justice is fair, swift, and proportionate. We must now encourage all jurisdictions to adapt and implement these principles, because fair treatment should not be the exception, but it should be the rule. Beyond policy matters, we are creating space for honest discussion. Earlier this year, ICS, IMO, ILO, and the ITF held a major symposium in London. That was on my first day when I took off on 16th of June. The event brought together governments, unions, and industry leaders, but most importantly, gave the platform to seafarers who have experienced unjust detention. Their stories were powerful and personal. They remind us that the issue is not abstract. It affects real people and real families. The discussions revealed that many judicial systems are simply not equipped to handle maritime cases effectively. Political pressures often play a role, especially when accidents occur near a coastline. This must change. We need stronger coordination between governments and the industry so that investigations are handled quickly and fairly, allowing innocent seafarers to return home. At the same time, ICS continues to address the issue of seafarer abandonment. The situation remains serious. Only last year, we have more than 300 cases. Each case represents human suffering. Each one damages our reputation and undermines trust in our industry. This is why ICS is chairing a dedicated IMO task force to review and update the IMO-ILO abandonment database. The aim is to improve data accuracy and make sure that cases are handled swiftly. Better reporting will mean faster action, stronger accountability, and greater protection for those affected. We must also look forward. The future of shipping will bring new challenges. Decarbonization, automation, cybersecurity risk, and climate change will reshape how we operate today. But one thing must remain constant. Seafarers must be part of the solution. The Maritime Just Transition Task Force is a vital part of this effort. It brings together industry and international organizations to ensure that seafarers are trained and ready for the technologies of tomorrow. As new fuels and systems emerge, safety and competence will be essential. Training is not an optional. It is a foundation of progress. This is why, as ICS, we hosted in 2023 the Seafarer 2050 Summit in Manila. The summit focused on what the future seafarer will need. It looked at training, education, welfare, and recruitment. It also explored how seafarers can contribute to national economic development in a report commissioned by ICS by the Institute of the Americas. The report highlighted the significant role seafarers have on national economies due to their significant contributions to economic activity, trade, employment, and expertise in various maritime-related sectors, something that India is already benefiting from and is well positioned to develop even further. The main message from the Manila Summit was clear. Collaboration and investment are essential. We must work together to ensure that our workforce is ready for the challenges of the next generation. We also need data. Data that proves that the value of seafarers to national economy. Data that shows why supporting maritime training is not only good for the industry, but also for the national growth. ICS continue to call on governments and industry partners to collect and share this information. Evidence will help us make a stronger case for investing in people. The success of shipping depends on the strength of cooperation. States, ship owners, and seafarers must continue to act together. When we act in unity, we achieve stability. When we act in isolation, we create uncertainty. This is why ICS will continue to champion dialogue between all stakeholders. It is how we will maintain trust, uphold welfare, and build a sustainable maritime future. Ladies and gentlemen, seafarers are the lifeblood of our industry. They keep trade flowing, economies stable, and communities connected. We owe them respect, protection, and opportunity. By ensuring them fair treatment and by investing in their education, we will not only safeguard our workforce, we will also secure the future of global trade. Let us make sure that the next generation sees seafaring not as a hardship, but as a calling, not as a risk, but as an opportunity, not as an afterthought, but as a proud profession at the heart of global economy. And with these few notes, I congratulate once again Sanjam for making this a reality, together with the one you did the last few days, and I wish you all the very best for the future. Thank you for inviting us.
Thank you, Mr. Kazakos, for the very insightful speech. May I once again request Dr. Jose Mathical and Mr. Thomas Kazakos to come up on stage, sirs, as we present you with small tokens of appreciation, please. All right, now before we proceed, we have a little bit of fun around before we rack our brains with the panels. The organizers have kindly shared with us a highlight video of the past 2 days of the Maritime SHIO conference. So let's have a look while the video is put on.
We are from the Philippines, we are from Indonesia, and also we are from Japan.
maritime world isn't just watching us, it's waiting for us. Waiting for leaders who don't just navigate ships, but navigate the future. Because we are the CEOs who refuse to stay anchored when the horizon calls. Thank you for being part of this journey.
Okay, that was a nice reliving of the past 2 days. Time to dive into the fine print and quite literally, because our next panel unpacks the complexities of international shipping contracts, dispute avoidance, and resolution. Please join me in welcoming our esteemed moderator, Mr. Shiv Iyer, Managing Partner, Renata Partners India, along with the expert panelists, Ms. Magdalene Chu, Director, Asia Legal LLC Singapore, Mr. Kaushik Sachanam Legal, Ms. Jimmy John, Advocate, Accredited Arbitrator and Mediator, India, and Mr. Ravi P. Javani, Partner, Fichte and Co. Legal, UAE.
Hello. Hi. Good morning, and thank you very much. Uh, as introduction bit, thanks to Ankita, thanks for introducing us. And for legal side, very important factor in the growth of shipping. We have been all factors in different parts of the world, and thanks to them to be in this platform. And Mandeline, I have known her for some time. So Chanam again, I have been, we have not worked together, but he has his own firm and he is a practicing maritime lawyer. Jimmy again, very old friend, senior to me, been in the industry now presently practicing from Goa. Ravi and me go back very long time because we have worked together also. I will let them introduce themselves briefly and their firm where they are today. It's nice to see that we are in a place today to speak where we are all working together in this industry and we have seen a bit of this. And thereafter, we'll make it a bit interesting for all of them as to how each jurisdiction deals with the resolution bit and the avoidance bit. But Mandeline, with you starting as to, would you like to?
Hello. Good morning, everyone. Sanjam, thank you for the invitation, and good morning to my fellow panelists. My name is Magdalene, and I'm a maritime lawyer from Singapore. I am a co-founder of a Singapore law firm called Asia Legal LLC. I'm also a qualified arbitrator and a qualified mediator. I also sit on the Singapore Chamber of Maritime Arbitration panel and also on the admissions committee. And I'm also known Sanjam forever because I was ex-president of Vista Singapore.
Hello, my name is Kaushik Sachanam. I'm the managing partner of Sachanam Legal. It's a maritime and trade practice based out of Mumbai. We look at both dry and wet matters of shipping, and we work across the country. Thank you.
I think it's almost afternoon, so good day, everybody. My name is Jimmy John. I am a maritime lawyer as well as a general lawyer because now I'm based out of Goa, and we can't have a niche practice of only any particular area in Goa. So I do undertake all types of commercial contract cases. I'm also a qualified arbitrator and a mediator, court-certified mediator as well. And presently, I am the president of Vista India. That's how I'm in touch with Sanjam. And that's about it from me. So over to Ravi.
Yep, thanks.
Hi, good morning, good afternoon, mix of both. My name is Ravi Javani. I'm from Dubai. I and Shiv have been working with each other for a very long time. It's been about 2.5 decades. Sanjam, thank you very much for the lovely invite. I belong to a firm called Fitch & Co. We specialize in shipping. The firm's primary focus has been to deal with maritime matters. We are one of the prominent maritime law firms of the UAE, and very happy to share our thoughts and advices in this forum. Thank you once again, Sanjam.
Thank you guys, thank you very much. And it's good to know that we have 3 core forums where a lot of Indians have commercial business and other side. And we constantly have interaction in different areas and interconnected way of working there. Magdalene, and to everyone, what would you guys personally, in the sense for a dispute avoidance with your client perspective, what are the suggestions that you usually give with respect to each of the jurisdictions, in the sense because you have different problems at different jurisdictions? I would like each of you to share your bits so that everyone is aware as to how things are managed or advised by you, client perspective, as well as the trends with respect to the courts or the tribunals which are going on presently.
Okay, I think dispute avoidance starts with your contract and careful drafting of the contract. Of course, there are the obvious things to look out for. For example, know your contracting party. I recently am currently doing a dispute, for example, where the client used the BIMCO form, which provides for arbitration, Singapore law and arbitration, but he very cleverly put in the box Singapore court, thinking that it will cost less, which sometimes can be the case in Singapore, and be more convenient. But what he doesn't understand, and this is where you need to think more carefully about this thing, is because his counterparties in China, the enforcement of an arbitral award is much easier in China than the enforcement of a Singapore court judgment. So it starts from little things like that as a non-lawyer you may not know, but it's knowing your counterparty and then applying that towards thinking potentially how I would have to resolve disputes with this counterparty or enforce such disputes. So that's one area.
Right, thank you very much.
Dispute avoidance and dispute resolution mean different things for lawyers and clients. If you were to ask a client what they mean by dispute resolution or dispute avoidance, 9 times out of 10, they would tell you this much: give me a resolution without resorting to arbitration and litigation. They are driven by this ideal for primarily 3 reasons. To ensure a continuing business relationship with a counterparty, disputes break that relationship, and they do not want that. Number 2, to avoid the uncertainties of litigation, arbitration, and recovery. And number 3 is not to spend on external legal counsel. It's bad news for all of us sitting on this panel. But having said that, from my experience, when I see a client overemphasize on dispute avoidance, at a time when a dispute arises, the client commits certain critical errors. And I will just highlight 3 of them, and my co-panelists can take over. They are: number 1, the client knowingly or unknowingly concedes critical positions with a hope to achieve a resolution. Number 2, they do not effectively communicate their position in a non-accusatorial manner. At the end of the day, if you desire your counterparty to agree to a particular position, you should be in a position to effectively communicate it. Otherwise, the entire process is a futile exercise. And number 3, to engage external legal when the file has been mutilated beyond recognition. These are the fundamental aspects when I look at dispute avoidance or dispute resolution from a client perspective, and where I see certain lacunas in their approach.
Right. Thank you. Thank you very much. Jimmy, specifically with respect to, as you are now practicing or doing a lot of arbitration, what is your way of looking at things when you want to try a party who is before you? How do you promote it to get into consensus or to resolving their,
Thank you, Shiv.
avoiding entering
Yeah,
into a...
yeah. So I believe as long as there's life, there cannot be 100% dispute avoidance. But of course, disputes can be curtailed to a certain extent. And like how Magdalene and Kaushik has mentioned, contract drafting is the basis for everything. So one could have something like a notice and escalation clause, wherein if there is even a whisper of a dispute, the parties can go into negotiations and mediations. In fact, the statutory enactments also are pro mediation and negotiation and opposed to litigation and arbitration. So for example, we have the Commercial Courts Act, where the mediation is a prerequisite before you file anything in the commercial courts. So the trend is basically to avoid litigation and arbitration, like how Kaushik said, bad news for us. But yeah, in order to avoid the overload of cases that is bombarding the courts these days, especially the Indian courts, one should, I believe, engage in alternative mechanisms and include such clauses in the draft so that it doesn't reach the state of arbitration or litigation.
Right.
I don't think I, as a lawyer, should say that, but yeah, why not?
Thank you, Jimmy. Ravi, from your side, how do you usually, because UAE is a very versatile jurisdiction in a lot of ways, how do you deal with these issues when you're advising to the clients, whether it is X, where your clients intend to take disputes to, or they don't want to take a dispute where the ship, exactly, this is the...
So the way how it works is this. Everybody loves to have wonderful contracts. The contracts are available on ChatGPT, on Google, is fine. The reference what has been made is with regards to, in shipping parlance, the reference gets made that refer to GenCon for rest of the terms.
Right.
Where GenCon is a very standard, universally known contract. The difficulty happens in the element of recap, when the recap happens through the certain medias like WhatsApp exchanges. So the earlier trend, what we used to have in shipping for the fixture notes, has now become much more smaller on WhatsApp exchanges. And that creates a huge amount of disconnection between what has been said and what is received and what is perceived. More so, the Gen Z element of using the emojis are creating a huge amount of disruption in understanding that today are we using words anymore, or we are using thumbs up, using heart emojis in an actual contract which is going forward, but rest of the terms the GenCon has to look forward. So the difficulty what happens in UAE is that, unlike the countries representative who are on this panel, UAE is a civil law country. So the precedence does not apply.
Correct.
Unlike in India, UK, Singapore, where you have the law of precedence, if you have a Supreme Court judgment, everybody follows. UAE, that is not the case. Every case is dealt on its own merits. So it becomes very hard when a client comes to ask that, oh, I'm fallen in trouble because I meant something, something else has come into picture, or something else has been perceived. How do we now get out of it?
Correct.
And there is no clear answer to this. So all we tell the clients over and over again, that you may have the Gen Z elements with regards to whatever it is, still go a bit traditional way of putting on email exactly. Open up what you really mean.
Right.
Like if you recollect, the simple shipping terms like MOLO, more or less owner's option, CHLOO, more or less the charter's option, right? 5% MOLO, 5% this. But those are accepted abbreviations. The emojis and are not accepted as of now. Yes. So those are the elements. It becomes very hard then to approach the court, and the court says that, oh, is this a love fight? Because he sees the color copy of the heart, and it's not a love fight, it's a contractual dispute what has happened. So that's the problem what happens in that part of the world. So what we always ensure that if you do not want to have UAE as a jurisdiction, you want to have UK or India or Singapore, it's fine. Why? Because there the in-depth interpretation could be seen because there are precedences in place.
Correct.
But unfortunately in UAE, that's a problem what everybody faces. And when you have to get that translated into Arabic, becomes a bit more of an issue with regards to explaining to the court as to the intention of the party. The other thing, which I'll quickly touch upon, is, and I'll take not more than 5 seconds, all other countries, like the common law countries, the lawyers enjoy the role of arguing in the court. UAE and Middle East countries, civil law countries, it is advocacy by paper. Lawyers do not get an opportunity to explain. So how much emotions are you going to bring on paper when the evidence speaks something else? So that's a bit of an issue. Emojis, especially yes, when you have that. So these are the live elements which are happened, which have created a lot of trauma in the industry as to what exactly is anticipated and perceived.
No, I understand, because usually the clients who also, these are the problems which we also face. But similarly for India also, we have our own issues, because we have federal, we have our high courts passing different country judgments to each other. We have this constant, but yes, certainty-wise, there are a lot of precedents we can rely on, etc. But Singapore is beautifully groomed.
In fact, I just wanted to mention about, when you mentioned about emojis, India does not have a definite framework for emojis, but the WhatsApp messages, they are considered as virtual verbal communication. So they are sort of categorized and accepted form, provided they are authenticated by metadata certification. So we have that aspect, but not emojis as yet.
So mediation, like we said, like Jimmy correctly pointed out, is a very good thing which is brought in under the Commercial Courts Act by India to avoid any unnecessary disputes. Some courts are very serious about it, and they are taking steps to ensure that people don't go under frivolous litigations, etc. And especially for a jurisdiction like India, I think it's a rightful thing what has been come through. I think Singapore, if you would like to explain how.
Thanks. In Singapore, there is a very strong and clear trend towards mediation as the first stop when you have a dispute, before you go to litigation or arbitration. In fact, last year the new rules of court were introduced, and it very specifically says now that you have a duty as a lawyer to advise your clients to try to settle, and you have to demonstrate in the initial filing that you have to state whether you have tried settlement, and if you haven't, why. And this is now embedded in the new rules of court. So these are the court procedures before you even start your writ of summons. Also, there is the Singapore Convention, UN Convention on Mediation. And I won't go into too much detail, but the idea is the idea is that the Singapore Convention on Mediation will be like the New York Convention when it comes to enforcement of mediation settlement agreements, the same way that you are able to enforce arbitral awards in various jurisdictions. So if your jurisdiction and your country is a signatory to the Singapore Convention, then you'll pass also into force in your jurisdiction, and it will become that much easier to enforce that mediation agreement. So the trend is very strong. On the practical level, I'm not sure how many here are clients and how many here are lawyers, but a few years back, the Singapore Mediation Center grabbed a whole bunch of shipping maritime lawyers and put them through a mediation course. The goal is twofold from what I understand. Number one, to show you that it is not detrimental to your practice. The rise of mediation is not detrimental to your practice. You can still, a happy client is a happy lawyer, and he'll come back again because you solved his problem for him.
True. No, that's a very encouraging thing, in a way that I've seen Singapore growing from a brilliant arbitration and a mediation center, and they focus a lot on mediation. And I think we are also following, India also is following quite a bit of those steps to ensure that we do mediation at the first limb, try to avoid disputes. Would you like to add your bits about?
I mean, in the Indian context, those statutes says for commercial suits, you give an attempt at mediation. In the reality of the way it works, I really don't see many clients taking a proactive step in initiating mediation and seeing through that process. So there is a gap between what is contemplated and how the market is reacting. And even when you have statutory bodies providing for mediation as a method to resolve disputes, I don't see a genuine effort taking place between both the parties uh, to see through that process. Rather, it is a pro forma effort to say that we tried, we spoke, and I don't think we're going to be able to bridge this gap. So I see a gap between what the law contemplates and how it is implemented, and also taken seriously by the litigants.
I, uh, I agree qua the clients, but I believe it's partially our mistakes as lawyers that we should encourage parties also to see through the merits and demerits of the case and not only think about our commercial reasons and kind of advise them as to how to focus to resolve it. I think Singapore has been achieving that. Also, Singapore reason is because if you go to arbitrate, then the client is, I think the pockets will tear and then you can't, it's too deep inside.
Yeah, you need big pockets. Which I'll just give you one personal example,
Yes.
if you don't mind. Now, you wouldn't think a collision claim or collision dispute could be mediated.
Right.
But I actually have, I've been lead counsel in a collision trial a few years back, and we went for mediation before the trial, just before the trial, before ex-master mariner become a lawyer. So he understood the rules of the sea plus the rules of the law. Unfortunately, we didn't settle before trial, but then what happened was, after the trial, and the judge found it was 50-50, both sides, of course, appealed because it's 50-50. You have a 50-50 chance. We went for mediation again before the hearing of the Court of Appeal, and we settled. So even after your trial, even after your judgment, it's still open for you
Open.
to, explore mediation.
Thank you. Thank you very much. Would like
If
to
I
add?
may add, if mediation is to be taken proactively, at least by Indian entities, one amendment which could be brought into legislation, or rather courts take a proactive steps in awarding full legal costs in favor of the succeeding party. Because right now what happens is courts and tribunals are very reluctant to award legal costs. They somehow look at it as a very guilty exercise.
I agree.
And if we have a situation where courts and arbitral tribunals are willing to say the succeeding party will be entitled to full legal costs, then I feel there will be more of an incentive for mediation by the parties to be taken seriously, because nobody wants to pay full legal costs. Right now we get courts will award costs after 10 Supreme Court hearings, maybe around $10,000. And each senior counsel is charging $10,000 to $15,000 per hearing. So it is peanuts. An appeal bench will award 2 lakhs costs, and legal fees of senior counsel will be around $50,000 to $60,000. That is excluding solicitors' fees and junior counsel fees. So I think where tribunals and courts take an aggressive stand in awarding costs, you will see clients being more open to it rather than litigating on a hunch or on a chance, or litigate to try to achieve a settlement at a later date.
Now, I think cost-wise, these things keep coming up, and I agree that it is important that a bit of deterrent has to be put on a party to.
If I may
please,
add,
please, please.
all right. We do not have anything, any enactment like how we have in Singapore mandating the lawyers to suggest mediation, but post the Mediation Act, the courts are mandated
Yes.
to refer the disputes to mediation in case they feel that there is any iota of a resolution or
Correct,
of mediation.
correct,
So they are mandated to refer the matters to, of course, court-certified mediators, and those proceedings are taken care of.
Correct.
So the parties do not have to.
And the cost of that
expedite the
mediation is very
exactly,
less, extremely less.
So the courts basically are pro mediation, so they are making efforts, but like how you said, and how you also mentioned, the lawyers are at fault because we see that, of course, it's ours is per day hearing, or it's like per hour, our billings, right? So you do see the trend in lawyers as to not to, advise clients towards mediation. Yes, of course, unless if they have reached about maybe 5-6 years and they are like, okay, they have, earned enough, they say like, okay, let's try and get into mediation. But yeah, we as lawyers have to make an effort to consider this option as well in order to restrict the disputes that is happening in the courts.
If I may add, apart from what lawyers may or may not recommend, the psyche of most corporate entities in India is they are not averse to litigation. In the sense they understand how it works, of the time factor, so they don't mind playing the waiting game. More than the lawyers advising to go for mediation or a matter of fees, clients themselves understand that let's wait it out and fight it and see what happens. So I think it goes both ways.
Yeah, you'd be surprised to know that there are more corporates who want to go into mediation now as opposed to litigation.
But that is strategy. How to use it, people are using it as a strategy. For one side, it may be beneficial, for the other may not be. But on a long run, if like people want to invest, people want to see results. That's how we see. Has to faster way to dispute resolution, faster way of how the awards can be enforced, how we can move forward. I think that's the way we should be, and we should encourage our judiciary and other things is what my view is. Ravi, would you like to give a overview on the UAE side, how they are?
Oh yes, UAE is much better in this terms of this. To start with, the case is finished. The first instance, there are 3 instances. First instance, appeal and Supreme Court. Right from the inception of the case to Supreme Court, you're looking at maximum 15 months. And that's maximum. Probably within 1 year, you would have covered all 3 stages. First instance goes in 6 months, full-fledged, very fast. The judges have a mandate to end the case. Experts get appointed immediately. Yes, the element of mediation, what the courts do, in order not to waste time, what they do is, the moment the case gets filed, the matter actually gets registered with the settlement committee, which is the mediation.
Right.
If none of the parties turn up, if the settlement is not reached in that first hearing, matter straight goes to court, no wastage of time.
Okay.
That's the reason why it is super fast. UAE has, over the period of time, has done a brilliant job in ensuring that the judicial system, you have to understand UAE has got a huge amount of investments that keep pouring in. There's a global investments coming in. UAE likes to be the tallest, the biggest, and they have ensured that the best of the people, the best of the shipping industry people have their presence in our part of the world. And the best way to do that is to ensure your judicial system is kept on top notch so that people feel comfortable in coming there. And that's what UAE has done. Being a civil law country, they also have a common law perspective as well. So there is a very fine balance maintained over there.
Right. Thank you, Ravi. Let's shift a bit from the mediation bit. Let's see the dispute resolution in a different angle, which is the arbitration and the courts. What happens in each of the jurisdictions with respect to the arbitration? I'm sure Singapore has contributed a bit. India, I think, has been pushing. There are quite good commercial men now. There also, I've had instances where arbitrations kind of finish within 8 months, and they are consciously, some of them are actually trying to finish it off. Some get delayed, I'm not saying. It's equal. If each of you can contribute a bit as to how the each jurisdictions have grown up, improved, and the mechanism presently, it will help all of us.
Okay, Singapore is very pro-arbitration. Singapore as a venue of arbitration has been included in the BIMCO standard formats for quite a few years already. So London, Singapore, New York, and Hong Kong. So therefore, we see a lot of arbitration disputes in shipping contracts in Singapore. The courts take a very non-interference approach. So there is no right of appeal. It's only the New York Convention grounds to set aside, meaning breach of natural justice or the incapacity of one of the parties or something not right in the constitution of the tribunal. So very limited grounds. The courts of course see a lot of attempts to set aside awards on natural justice breaches because as a backdoor way to appeal the award. But majority of these setting aside applications do not succeed unless it's very clear that some injustice has been done. In Singapore, we have SCMA, Singapore Chamber of Maritime Arbitration, specifically for maritime-related disputes, but not limited to maritime-related disputes. It's a non-institutional arbitration rules, which means that you can just say in your clause, SCMA rules to apply for addition. They don't charge an institutional fee, they don't charge filing fees, they don't have an admin fee, they don't have a fund holding fee. So, you know, I always recommend to my clients choose SCMA rules for that reason.
Right.
Yeah. They also now have introduced recently the expedited procedure for any claims below US dollars 300,000. Yeah, and so it's documents only. 21 days after your case statements are filed, the award is supposed to come out.
Right. It's very good, actually. It's been.
Well, on the arbitration front, first, if you're looking at maritime arbitrations in India, you would find Indian public sector undertakings such as Indian Oil Corporation, ONGC, Steel Authority of India, mandating that arbitration is to be held in India, most probably under Indian Council of Arbitration rules. That would be on the maritime front, because they are the ones who have their long-term stems and contract of affreightments, or on the spot market. If you look at the arbitration, how it is conducted, the Arbitration Act mandates the arbitration to be wrapped up in 2 years, or the parties have to go to the court to seek an extension. So this statutory enactment has helped arbitrators in wrapping up arbitration in 2 years' time. And we have had arbitrations where arbitrators have ratcheted up in 18 months and 20 months because arbitrators do not like parties going to the court and seeking an extension of the mandate because it reflects poorly on them that they have not been able to manage the schedule. So that's an improvement, and courts are more open to passing interim measures orders pending arbitration, and also interim measures or disclosures of assets pending enforcement of foreign arbitration awards as well. Previously, you had to get your award recognized as a decree of a court and then go into execution. Now courts are more reluctant to go into the issues of securing the award amount pending enforcement of the award.
Correct. It's actually quite good developments through the acts and other stuff which have come in, which allows, including the Admiralty Act, which allows you to secure for enforcement, etc. So India has kind of moved forward with judgments also, where it was very easy to challenge. The only thing what we have is the procedural delay, which also we are working towards it. And Jimmy, if you would like to say a few things on.
In fact, India's ambition to be recognized as a credible arbitration hub has ensured that measures such as limited court interference and greater respect for party autonomy are considered. In fact, they are trying to be incorporated into the statutory enactment. In fact, the draft arbitration amendment bill of 2024, it's still under review, but it is planning to adopt these measures.
Right.
Limited court intervention. And then, of course, despite the absence of such enactment, the Indian courts have always reinforced the pro-enforcement stance, as well as greater respect for party autonomy. We have the Gayatri Balasamy case, as well as the Glencore International case, you know, which talks about if there is an valid arbitration clause, issues such as jurisdiction and waiver are to be left to the arbitral tribunal as opposed to the courts. Similarly, the limited court interference. Now, enforceability can be challenged only if it violates the public policy.
True.
And the 2015 Amendment Act has very significantly narrowed the interpretation of what public policy means. Basically, it only is violation of fundamental laws of Indian policy or if it is obtained by fraud. So in order to ensure the credibility of India as an arbitration hub, so we are taking a pro-arbitration stance, and we do have a lot of agreements like how Kaushik has mentioned with respect to ONGC and government contracts, which will include the arbitration clause. And it does include the arbitration clause. And with India leaning towards, pro-arbitration, we are hoping that India becomes the next
I think there is
arbitration hub,
positive changes in a lot of way. And as I said, even the commercial arbitrators are very sound about these things, and they are trying to push things to ensure that we kind of finish arbitrations quickly, etc. Ravi, would you like to say a few things from your side of the world?
UAE favors arbitration a lot.
Correct.
Now, very obviously, SIAC Singapore Arbitration Center, CMA, Singapore Arbitration Centers are very prominently known. UAE is also coming up and have already established DIAC, that is Dubai International Arbitration Center. And it's surprising to see that how many people are actually referring now DIAC in their shipping contracts. Now, it may not be the traditional shift from the LMAA or SAIC with regards to charter parties. But what you get to see is among the traders who trade, who have nothing to do with the charter parties, who are the sell and purchase contracts, and the charter party is going to come later, a lot of their clauses are now related to Dubai International Arbitration Center.
Very good.
Because Dubai is becoming a trading hub. Especially, the dream of Dubai was always connecting east with the west. And that's exactly what you can see today, that the arbitration centers are doing phenomenally very well. Now, with regards to the court proceedings, the moment there is an arbitration clause, the courts do not want to interfere.
Oh, amazing.
The similar approach like how even Singapore has got, non-interference. The court will just not interfere unless it can be proven that that arbitration has got a flaw in it, there's an ambiguity in it, there is a problem with regards to the clause, then the courts will get into the interpretation. But if the clause is clear, the courts do not want to interfere. In fact, the courts themselves promote. The catch in that part of the world is, there's something called ad hoc, which we all have in our part of the world.
Right.
UAE does not have the element of ad hoc. So when there's an ad hoc, not a non-institutional arbitration, then the courts needs to be approached in order to appoint arbitrators. Now that process, a person who not only reads English but understands English from the courts panel can become a bit of a dicey element.
Okay.
And this is where the local law understanding, the understanding at the time of negotiation matters a lot.
Right.
That how do you place that code? It's a very simple statement you would have seen, and I'm sure everybody would have seen. In normal charter parties, fixture note, how you have GA stroke ARB, London, English laws, full stop. It's understood what is the rest.
Correct.
Instead of London, put Singapore, it's understood. Singapore law, if I'm not mistaken, actually says that if the, by default, SCMA or SIAC will take the jurisdiction if the arbitration is in Singapore. But in UAE, that's not the case. So if you have ARB as DXB Dubai, the short forms, or AUH for Abu Dhabi, or SHJ, English laws, big trouble in that clause because now ad hoc does not exist. So you have to approach the court. So you see, those are the elements. The fine-tuning needs to be understood well in advance.
So takeaway for the clients is basically ensure your clauses are proper and in order, and you agree to the
Reach
law.
out to your lawyers.
Now we come to the court process. Any jurisdiction as to how we, for example, the arrest, which is each jurisdiction are favorable, arrest favorable countries we are. At the same time, resolution or securing, how we secure our claims and how we take it forward from there to the end result. I would like to hear from you guys how to each country, how do we deal with it? If you would like with Singapore first.
Okay, Singapore is popular, although not easy, jurisdiction to arrest ships as security for your pending arbitration. you do not actually have to show that you've commenced the arbitration. You just have to show that, say that you intend to.
Right.
Yeah. And the ship has to be within port limits. The country is so small, the port limits is not quite the same as the territorial limits. So quite often the ships will bunker OPL, so then you have a problem, you cannot arrest. Within port limits, the grounds for arrest are quite standard, quite in line with the arrest convention, although we are not signatory to the arrest convention. You can arrest also for maritime liens. One unique aspect, though, is the duty to provide full and frank disclosure to the court when you are applying ex parte for the arrest warrant, which means that you have to disclose to the court at that point in time not only facts that are in your favor, but facts that are potentially not in your favor when it comes to its relevance to, say, the beneficial ownership of the ship. So if you knew that, you know, maybe beneficial ownership passed or there was some change or doubt, you have to disclose to the court, even though it's an ex parte application, when you apply for the warrant of arrest. This has developed over more than 10 years, this line of cases, and the courts say that you can actually set aside an arrest even though you have jurisdiction, but you breach this duty of full and frank disclosure. When I started practice as a baby lawyer, the arrest affidavit in support of the application was 5 pages. It is now, you know, 50 to 150 pages because of this.
Which is very good. Yeah, Kaushik.
In terms of arrest of ships, India follows the Arrest Convention in determining maritime claims and the Lien Convention determining the liens. The court recognizes the power to arrest a vessel pending arbitration, but the lacuna in the Indian jurisdiction is we do not have a statutory enactment recognizing the power of the court to arrest a vessel for an arbitration clause. So the courts have devised a procedure wherein which you can sustain an order of arrest for an arbitration proceeding outside India or within India. So generally it is advisable for parties to make it clear for what purpose they are arresting a vessel, so there is no confusion as to what is the finality of the proceedings for which you have filed them in India. So that is one thing. A recent enactment to the Merchant Shipping Act allows the government to directly intervene in the event of a maritime casualty, and all the expenses incurred by the government using all its instruments will be treated as a priority lien just below the crew wages but above the mortgagees. So the government has taken this proactive step in dealing with casualty management and expenses. So they have taken a priority just below the crew wages. So that's a recent development. As regards beneficial ownership, it's a bit of a Pandora's box. Some courts are allowing it, some courts have not. When they allow it, they take the easy way out, saying that the issues as to ownership will be determined at the stage of trial. Right now, we feel a prima facie case has been established, which in my view, especially in beneficial ownership, arrest should not be done, but courts have taken the easy way out. We have not gone to the South African extent of associated ownership arrest. So in terms of arrests of vessels, that is where we are.
Thank you. Jimmy, quickly to shorten this, I think... No, I'm not shortening the... What I'm saying is, a bit more to add on to this. So there are parties who are in arbitration, like he said, parties who are in court for securing their claim may not be qua the arbitration, but qua the suit. So India has a system by which you have to file the complete proceedings in the court, even though you have an arbitration clause. Then you come forward and then you file a section 45 and say, okay, I have an arbitration clause, which gives right to either of the parties. What I'm asking you is, isn't it better that we go to the arbitrator and get our claim secured? Or is it better to go to an admiralty court and secure and then go to arbitration? Just a quick one.
In fact, under the Admiralty Act 2017, we can arrest the vessel to secure an arbitral award. So I think it would be better to go to the court in order to secure the arbitral award, to secure, to arrest the vessel, and because the procedures is already set.
Right.
So we can ensure that when an award is passed, at least we have an asset to be executed.
Right.
Yeah?
If I may add, I don't think an arbitrator would have the power to detain a vessel. It's more of a judicial process.
No, I'm not on the judicial process. I mean the way of securing, which is under 17, which are... Sorry, Ravi, if you can...
So some time ago, I just said that UAE likes to be the tallest and the biggest, right? So with regards to the arrest, we merged the 1958 and 99 convention, and we have more lists where you can arrest the vessels.
Like we used to have.
Where even 99 convention legislators were shocked that how the hell did you come up with all these names? And we wanted to put, you throw it in, we want to arrest everything in. But having said that, arrest is now very, you can say, lucrative.
Relatively easy.
Very relatively easy, very lucrative for lawyers in UAE. But at the same time, there is an element with regards to the substantive proceedings. Now, unlike, again, in the common law system where you have action in rem, right? UAE does not know that, the concept of action in rem. So the arrest of the vessel is actually considered as a precautionary security.
Okay.
Which means you have to file substantive proceedings thereafter. Now, two issues over there, or rather three issues. Number one, parties have agreed to UAE jurisdiction, fair enough, substantive proceedings before UAE. Parties have agreed to arbitration, so you have now the third step of arbitration, be it Singapore, London, Dubai, and then inform the substantive court of UAE, please put the matter on hold. You have to prove that the arbitration has been initiated, which is very easy in Singapore or in London because it's only one notice of arbitration by laws. Here comes the third issue where there is a high court or a court jurisdiction outside the country. Because after arrest, you have only 5 days to initiate substantive and to inform the court that I have already initiated outside. Now, if it's a court proceedings, the documents have to come through the diplomatic channels. Because there is no bilateral. UAE has got bilateral treaties mostly with the GCC countries, not with the rest of the world. So that's where the recognition, if you have initiated, let's say for the sake of example, Malaysia, if you initiated a case in Malaysia, for UAE to recognize that the substantive proceedings have been initiated, the Malaysian court proceedings papers have to be translated, routed through the diplomatic channels, which cannot happen in 5 days. So that is a third element which is an issue.
This is actually interesting. I was also not aware about it. Thanks for informing us about it. As we now have only about 4.5 minutes, if anybody has any interesting questions to raise on these interesting lawyers, not me, please. Yeah, Paul. I think somebody should pass the mic to him.
First of all, thank you, moderator, and for the excellent panelists for a very interesting discussion. I'll ask a question, but first an observation. It's long been held that mediation will never work unless the judiciary and government are behind it, and that's why it works in Singapore. Lawyers notoriously regard it as eating into their rice bucket, and lawyers need to grow up and understand that it's a fantastic way to bond with your client, to sit through a successful mediation. And lawyers need to understand that if they're going to advise on mediation, they ought to know about it and know that the skills that are adopted by professional mediators are very different from those that lawyers use. Lawyers should not automatically believe that they're great mediators simply because they've been handling disputes. In fact, it requires a completely different skill set. Lawyers can bridge that and are very good at parts of mediation, but parts of mediation, and I'm talking from my own experience, having to rewire myself, you know, you need to be humble and you need to dig into it, and we need to encourage parties. Now, that's my observation. My question is this. There is such a concept of ARB, Med, ARB. And that seems to me to be a win-win situation, and I'm surprised none of the panelists have actually mentioned it or mentioned offering that to their clients. It's a total win-win. You can't have mediation without agreement, so put it in your arbitration clause and you've got the agreement. But can I just say Singapore's gone one step further. It's actually got SICC, Med, SICC. So that's court, Med, court, but it's an international court. Those are just a few observations. I am passionate about mediation, and I'm very pleased to see that panelists too are passionate about it. And I think we need to advise our clients about mediation properly. Thank you. But can I just have a comment about ARB, Med, ARB? What the panelists think about that as a concept?
Right.
Thank you.
If you guys would like to answer, because I think, Paul, I agree with you. It's consciously our jobs to get it done.
If I may, India has not developed to that extent to include, or the lawyers have not developed to that extent to include the clause ARB, Med, ARB, which is a wonderful initiative actually, because we don't have, the Mediation Act has come into force only in 2023.
Correct.
And under that act, the court is mandated to refer everything to mediation, right? So the clauses, I mean, the lawyers have not yet been trained in order to think in that aspect, in order to include it in the contractual clauses, as one of the contractual clauses. So hopefully, but the Supreme Court in India, under the aegis of the mediation committee, trains lawyers as mediators, and they become then the court-certified mediators, and they are assigned the cases from to the courts. But otherwise, privately, we don't have mediators, or they are not entitled to take, or they are not allowed to take cases.
So the intention of the government is towards the mediation.
Right.
They have taken steps towards that. And I think consciously we are also moving to the fact that we do not want to lead unnecessary arbitrations ahead. We will try and resolve it. And they are consciously moving towards, so including the Arbitration Act when it came, like Kaushik mentioned, there's a deadline which is fixed, and it puts the onus on the arbitrator to finish it in a particular time. So these are the steps which have been taken on the India side of it. Singapore has been far ahead and positive about things in moving and taking steps. And I'm sure UAE has always been...
And the fact that we are just growing as an arbitration hub, mediation is sort of taking a back seat, and it has only been relegated to the courts as of now.
Yes. Yeah. I hope. Anyone else would like to ask? Yes, please. Can someone pass the mic?
Hello, I'm a J.S. Rawat advocate. I'm an advocate in the Supreme Court. Now, my experience is that the arbitration has become another sort of a litigation in India. Now, so far you said that the mediation in India is since last 20 years back. Now, most of the mediation in India is a court-monitored mediation. Now, I want to know from Singapore panelists that how the institutional mediation is successful in Singapore or not in India, because in mediation in India is lost more than 20 years. So in India, only the court-monitored mediation is conducted, not a private mediation, not an institutional mediations. Now, so far the Mediation Act is concerned, even that Mediation Council has not been constituted by the government, so that even the expert mediator cannot do a private mediations. So I want to know that how institutional mediation is working in Singapore.
Thank you for the question. It's a mindset change. And they have approached it from the mindset of the advocates and advisors and the mindset of the clients and disputants. So, as I said, they grabbed, like literally grabbed, a bunch of maritime disputes lawyers and made them learn about mediation so that you understand it, you are actually a trained mediator, and you understand that it's a different set of skills and the benefits. From the client's perspective, The persuasion point is going back to what was said previously, it preserves the relationship. So when you're in a dispute with a counterparty where your relationship is important to you, this is the selling point of mediation. And as my fellow panelist Ravi also said, hopefully it also deals with the emotions behind a dispute, not just the paper, which you can win the trial, but your emotions may not get that airing which it will get in a mediation setting. So it's a holistic approach, I would say.
Thank you very much, and thank you to my fellow friends, and thank you very much for this insightful panel discussions that we had. I think I learned a lot also from here, and thank you very much to everyone. I'm sorry, time's up. If any questions, you may please pose it to them, not to me. Thanks a lot.
That was an absolute masterclass. Please may we request you to remain on stage as we present small tokens of appreciation. I also kindly invite Dr. Joanna from Maersk Training to please felicitate the moderator and the panelists. Thank you, everyone. Now we break for lunch, but please don't drift too far. We'll be recommencing back at 1:30 with a lot of more interesting rounds and sessions. Hello everyone, we are going to start in the next 2 minutes. Can we request all of you to come ahead please and take your seats? Welcome back, everyone. Up next is a fireside chat tackling some of the biggest questions in the maritime insurance, liability, and environmental accountability. Please join me in welcoming our moderator, Ms. Adele Marina Rizzo, Head of Commercial RB, British Marine UK, and the distinguished speakers, Mr. Rujdi Malouf, International Arbitrator, Malouf Arbitration, Singapore, Ms. Ana Clara, Senior Legal Counsel, and Vista Brazil founding member.
Good afternoon, everyone, and welcome to our fireside chat. My name is Adele Marina Rizzo. I am the head of commercial at RB British Marine UK, a shipowning company operating in dry bulk sector. It's a pleasure for me to moderate this session today, and I take the opportunity to thank Mrs. Sanjam Gupta and her valuable team for inviting me and offering me the opportunity to connect with such an outstanding group of professionals. I'm delighted to be joined by Ana Clara Nascimento and Richidi Malouf. I will leave them individually to introduce themselves. First, Ana Clara.
Hello. Good afternoon, everybody. Nice to meet you all. I'm Ana Clara Nascimento. I am founding member of Vista Brazil and senior legal counsel of an oil and gas company. And I really appreciate the opportunity to be here.
Hello, my name is Rushdie Malouf. I am an independent arbitrator. Before becoming an independent arbitrator 2 years ago, I was working in the LNG industry. I'm a qualified solicitor in England and Wales and Ireland. And I worked in-house in the LNG industry, and I also worked in a commercial capacity, my last role being an executive role in an LNG company in Singapore. I will be focusing on FM issues when it will be my turn.
Thank you. Together, we will discuss how risk is structured, insured, and from contract drafting to real-world operations. Let's kick off with Ana Clara. In every international shipping contract, the way parties address liability remain a central issue. However, the approach to contractual liability can differ significantly between civil law and common law system. From Ana Clara, from your perspective, how do these two legal frameworks shape the understanding of a contractual liability, and how do such differences influence the allocation of risk throughout the maritime chain?
Thank you for your question. Well, I think it's really important to differentiate both legal system. The civil law, usually it's a codified system, so you probably have specifically in the legislation what is acceptable or what is allowed to have in a contract in terms of allocation of liability. And on the other side, the common law usually is uncodified, but doesn't mean that there are no rules. They are mainly focused on the case law, and they have a very big history background on how those clauses they are interpreted in that legal system, such as in England. So there are some concepts, for example, that we will talk a little bit about this later, for example, the knock for knock and the fault-based regime. There are some countries, some jurisdictions that they have only the concept of fault-based regime as a rule. So whenever you introduce a new concept that probably is most likely used in common law, it could have some kind of be strange for the courts. It will be something new. And the interpretation, when you have a claim, if you have a governing law, for example, in Brazil, which is civil law, you could face some issues and some challenges how to interpret that specific allocation of liability that, for example, in English law would be completely acceptable. So in my view, it's really important when you have an agreement, we have a charter party or any other type of shipping contract, you need to know what is the governing law, if that allocation of liability is compatible with that specific law, or if there are any restrictions that you need to be careful about.
Yeah. Second question. How do you see the usual allocation of risk? And do you observe more balanced and collaborative approach, or the Eastern industry still tend to have a very rigid a defensive
Well, actually,
adopt?
yeah, sorry. Well, actually, I think it really depends on the type of shipping contract we are talking about as well, because you can have cargo owner with a ship owner. You can have a contract between the oil and gas operator and a ship owner with a supply vessel. So you have different standards. So for example, for Binco is very well known and is very traditional for international industry. So whenever you have a Binco standard template on the table for international contracts, typically it's much easier to negotiate and you don't waste a lot of time because the industry already set those standards. So you shouldn't have many problems with that. But on the other side, if you have a negotiation that a party is trying to impose their own terms and conditions and it's not aligned with the best industry practices, probably you could see some imbalance on this. So in my view, in relation specifically to allocation of liability, the knock for knock says the concept is that the other party will be exempted from the liability of your damages to your own personnel, your own property, consequential losses. But it's interesting that even in common law systems, you have some countries that deals with that differently. So for example, English law, you could have this type of clause without many carve-outs. It's basically saying that you will not be liable for damages to my personnel and my property, regardless the cause, even negligence, and this would be acceptable. However, there are some other countries, for example, Brazil, I have seen some case law in US and Norway as well, that there are some restrictions when it comes to willful misconduct. And also there are some discussions in case of gross negligence. So even though that you may have this provision that doesn't carve out willful misconduct and gross negligence, depending on the governing law, you could be exposed to that clause being challenged in courts. So I think it really depends how the parties they are willing to have that business if they are aware of those potential gaps and fragilities.
Yeah. And we come to a very big topic, insurance. So how do you see, how important, from your point of view, is the insurance to manage the risk?
So, sure. Well, in the shipping industry, everybody knows there are a lot of risks involved.
Yeah.
The vessel, potential pollution, people, personnel, so environment. And so there are a lot of risks involved just because the vessel is shipping. So even when you're loading, unloading, so I think the most important thing is the company, it needs to be aligned, not only legal but commercial operations and insurance. Everybody needs to be on the same page because the legal cannot give you the best advice if they don't know exactly the operation. And the same applies to a shipbroker, insurance broker, I'm sorry. So if the insurance broker doesn't know exactly the operation and the gaps and exposures, it will not be able to verify what kind of coverage you should have, what kind of policies you should have. So there are some risks that you need to add to your coverage. For example, you can have more risks or loss of hire or increase some limit of the indemnification. And of course, be part of a P&I club that is renowned, like IG P&I club. So those kind of measures, it mitigates your risks. But also, I think is really, really important when we are talking about the allocation of liability is that the liability indemnities, if you have the knock for knock, for example, you need to make sure that the clause that address insurance, there is a waiver of subrogation, because otherwise it doesn't make sense. So just an example so people can understand. If I have a contract with Rashid and we agree that my personnel and my property is on me, and even if it happens something with my personnel that he caused, I will not claim against him. But why am I accepting this? One, because the industry is working like this and we would avoid litigation, infinite litigation. But the second thing is I can have insurance to cover this risk. So it's something predictable and you can have a price. So it's much more practical, even for commercial wise. So as soon as I have this insurance coverage, the insurance company, the event may happen, they will pay, and then it's legal that they will, as soon as they pay, they will step on their shoes, on my shoes, to try to recover this loss. So they would go after the one who caused. So imagine that I forgot to tell my insurance company that I had a knock for knock with him, and then something happens, they pay, and they go after him. And he will say, well, but I agree with Anna. She wouldn't go after me, so it doesn't make sense that you, as subrogation rights, go after me now. So those kind of things would avoid a lot of gaps and miscommunication. This is one of them, and making sure you have the insurance coverage for the risks that are aligned with the operations.
Thank you. Thank you for your intervention. And let's step to Richie. Even with the strong clauses, environmental and insurance frameworks, there are moments when events move entirely behind control, when true test of risk management begins. Reaching force majeure is well known in the shipping industry and in international trade. Is there a standard concept of force majeure?
Thank you. I mentioned earlier that I had been involved in different aspects of the LNG industry before becoming an arbitrator. And in all these roles, I have come across force majeure, but in different ways. And in talking to you about force majeure today, I want to cover those different areas, how you see them as an arbitrator, how you see them as an operation person, or how you see them as a contracts draftsman, because they have to come together at some point. Force majeure is the point where there's a collision between reality and your contract. And it's important to understand what it is, because we have all heard about it. We have probably all been exposed to force majeure situation through our work, but I don't think it's very clear to anyone in particular what it means. And it's not because anyone is particularly ignorant, but it's because there is no single idea of what force majeure is.
That's why we made the very basic question.
Yeah. And I would say we can probably define a concept of force majeure, and I will do that in a minute. But before getting there, we have to understand that there are two conceptions of force majeure. There is the civil law and the common law conception. And the civil law conception is a statutory mechanism that does not only apply to contract, it applies to civil responsibility as well. And it is there for certain reasons, and it is drafted in a certain way. And I did some research comparing several civil law jurisdictions and found that it had a different definition and different effect under each law. Then the common law tradition is really radically different in the sense that common law and English law has known force majeure since the 19th century, but the English judges have never accepted to define the term common law in the case law. And they have always held that force majeure is a mechanism in your contract, and it is as defined in the contract. If you mention force majeure in your contract and do not define it, the judge will not give effect to the force majeure because there is no English concept of force majeure. So these are our two traditions, but can we see some commonalities? I think the COVID FM issues, which everybody has been aware of, have shown something interesting. In civil law countries where people have relied on the law to excuse themselves from COVID circumstances, there is a tendency to reject that. Why? Because parties have not chosen FM in a civil law country if they haven't put it in their contract. But in a common law contract, of course it depends on the case, but there is no reason not to give effect to the FM clause. And generally, the FM clause will be effective if it's drafted properly and implemented properly. And so where does it live in terms of concept of force majeure? What does it do? And this is, I think the best way to understand it is to think about what it does and not how you define it. What it does is introduce something in your contract which is to tell you what will happen in case of unforeseeability. In the same way as knock for knock will tell you, okay, if there is damage, we are going to decide that everybody bears his own damage. This is the best way to manage having 10 companies working on a project in the same site, for example. In the case of force majeure, two parties will decide that if certain things which I have not foreseen and which are not foreseeable take place, it will have a certain consequence, which the contract will spell out. So this is, for me, the concept of force majeure.
Let's go to a more specific question. So what are the factors that most often determine whether a force majeure clause actually holds in the charter party disputes?
Well, I don't want to focus too much on the charter party dispute.
Okay.
Because there is a specificity of shipping law in relation to force majeure. Force majeure is very important in the trade contracts, and it will always be there because it's going to be the most common disruption. In my career in the LNG industry, I was exposed directly to 6 force majeure situations, and none of them went to disputes. None of them resulted in any arbitration. But this is, when things go wrong, this is what's going to happen first. There's going to be a force majeure situation. Sometimes there will be a clear force majeure situation and no declaration of force majeure. I will come to that later. So in the charter party, you also have the Hague-Visby rules or similar general exclusions that will allow you to plan for those unforeseen consequences. And these will have to work with the force majeure. Now, in terms of structure, if you are going to put a force majeure clause in your contract, you have to think about certain elements that need to be there. And these elements are there because they are the nature of the clause. So what the clause does is something happens, you cannot perform. You cannot perform, you have promised to perform, therefore you are in breach. But you have agreed that if this unforeseen circumstance event takes place, you will no longer be liable for the breach. Therefore, your clause has to define the event and explain how you will be able to assert that you are not, you are to be excused for not performing. And this is where the notice is very important. And that's why the drafting of the clause is extremely important. I mean, BIMCO has drafted a model force majeure clause in 2022.
We deal every day as ship owning.
Yeah.
Voyage charter.
So there are certain elements in a well-drafted clause, but don't always expect the clause to be well-drafted. You will see in some, I've seen in a Russian contract a force majeure clause that would not follow any of the important facts. But the notice obligation will always be there because that's how you will implement the clause.
Yeah.
You may also have the consequences of prolonged force majeure and some termination provision if the force majeure goes on for a long time. But I would say the good practice is always to use a model when you're implementing a clause.
If I may add something. No, it's something interesting because you said unforeseeable. But for example, in Brazil, it's even more important that it's unavoidable. Because sometimes you can foresee. Yeah. For example, it's already happening. So there is COVID, always about to happen, but there's nothing you can do about it, so it's still considered a force majeure. But I think it's a civil law country, and the concept is very broad. They say it's unforeseeable or unavoidable. There are some concepts that, depending on the case, even if it is not written, they can try to expand the event because it's totally new, but it would fit on that concept. So this is, I think this is the main thing in the force majeure when you have a civil law jurisdiction and common law. And civil law is usually much more broad.
Can I say something? I absolutely agree with you. The unavoidability goes to the fact that you could not, that the event prevented you from performing. And this is part of the notice. And the important thing to understand about the notice is that if you have been affected with force majeure, you have to prove it. So you have to explain how those events justify that you have not performed your contractual obligations.
When force majeure is invoked, does it still have the power to suspend or redistribute responsibility, or it's a practical effect?
The relation between the FM clause and responsibility will revolve around the actual wording. One way to look at it is that you are still in breach, but you can be excused. A pure exclusion clause will say that you have no responsibility for certain things. Force majeure says that you will not suffer the consequences of your breach. That's conceptually. The way it's drafted will not be as clear as that. But the important thing in terms of effectiveness of the force majeure clause is to realize that a force majeure event is not an objective event taking place outside. The force majeure event is relative to the relation you have with the other party. It's relative in many ways. It's relative because the factors have affected you, even though they are objective factors and they have affected other people, but they have affected you in a unique way. And it's relative because when they affected you, you reacted in a certain way, and that way may disqualify you from being able to exonerate your responsibility. Okay. Because you have a duty of care. You have a duty of, in LNG contracts, it's customary to make the invocation of force majeure subject to a standard of reasonable and prudent operator, for example.
The same applies for insurance. The duty of care, mitigate the losses.
in your opinion, how does force majeure interact with the liability insurance and environmental exposure? And how this intersection is managed commonly today?
That's.
Sorry.
I mean, I'm going to use a lawyer card. I would say it depends. but the important thing is to look at your particular situation in a constellation of contracts and legal relations and understand that these are connected, but they are not necessarily coherent. So, for example, you can have a chain of contracts in a back-to-back cargo sale, for example, but in LNG, every two companies will have a unique contract to do back-to-back sale. So you have one company selling the cargo to another company, and that company sells it to another company, and that company sells it to another company. But the cargo is going to be picked up in one place and delivered in one place. It's not going to be, it's going to be only one delivery. But each contract will be different. So a force majeure event, the delivery does not take place, and it may very well be that some contracts will allow an excuse for a party and some will not. And somebody may end up, having to pay for everything. So it's very difficult to structure your transaction in a way that's foolproof because you have all those factors and all those different companies.
Good. I have one last questions for you, and is I guess very interesting from my point of view. What are the key issues to be aware of when a force majeure situation occurs from the point of view of an arbitrator?
Yeah.
Because he's giving us an instruction how to move.
I really have the chance of having been involved in force majeure at a purely operational level when I wasn't even in the legal function, and to look at force majeure from the point of view of a dispute. In the past 2 years, 60% of my disputes are raising force majeure issues. But when I was working in a more operational capacity, I realized one important thing which I didn't understand when I was drafting contracts. When a force majeure situation occurs, it's a problem in the operations. And when a problem in the operation happens, the operation people are talking to each other. And they are not necessarily senior managers, and they do not necessarily have a reporting obligation about every small operational incident. So, force majeure situation, what happens? One company is going to talk to the other company, manager level, saying, this happened, we have a problem, we're not sure we can deliver, etc. A discussion will start, and at that point of time, depending on the company culture and regulation, it may very well be that for several days, you're going to have two junior managers talking about an issue that's actually very serious because it may result in the failure to deliver a very high value cargo. And they will exchange messages in writing, not only speaking, and they will try to resolve the issue. And it's their role. They're completely in their role trying to resolve the issue. If they do not manage to resolve the issue, the next step is going to be involving the commercial people who are behind the transaction. At that point, unless the company culture dictates it, you still don't have a lawyer in the mix. The business people are going to start to talk and find a way around the issue. So typically in LNG, you can't deliver this cargo. Okay, you deliver me a cargo next month, and I will try to find another place to deliver this cargo. It happens, especially when you're dealing with very big buyers.
Yeah.
Okay. If everything is resolved at this point, they will sign the paperwork, and the issue will be done. And honestly, I've been involved in 6 force majeure issues, and none of them resulted in a dispute. They were all always resolved. But if you can't resolve it at that point, and it's going to be a claim, then the legal team is going to come in. When the legal team comes in, and there's already been several days of communication, the legal manager is going to take the contract and look at the clause, and the clause will say, notice has to have these elements. And we look at the communication and see that most of the time, unless there was very knowledgeable people involved, notice requirements have not been fulfilled. This is most cases, it's most cases. So they haven't been fulfilled, and worse, in the course of the discussion between the working level, a number of admissions have been made. Yeah. And sometimes they're not even genuine admission. It's just trying to show good faith in the discussion, saying, yeah, I understand, we accept that. But no, you don't accept it, but you've written we accept that because that's a way of speaking, and you've already made the admission. So in practice, the really important thing to understand is that FM in international trade starts as an operational problem involving operational managers. And if you want to catch the situation before damage is done, the system has to take this into account and ensure that when an issue happens, it is flagged so that there is no problem in notices, admissions, and which we're going to come down the line at the point of the dispute when you're going to be in arbitration or in court, and all this message will come up and undermine your position, even though you were in a good faith and in a good position.
I would like to have also Ana Clara vision as a
No, just to add very
counsel.
quickly, I completely agree with everything you said. And as soon as a potential force majeure happens, it's really important to reach out to legal and read the contract, because sometimes you will lose for the formality. There is notice, but this notice needs to be in writing to that specific email. And if you don't do that, you didn't notify. So, but I talked to the manager, but he's not the legal he's not the representative. It should be in writing. Those kind of things are silly, but it makes a huge difference in the end. And also, I think a good tip for everybody in every case, for any potential disputes that can happen. Sometimes we don't want to, but keep records of everything, emails, and track them. So whenever, if you need to use them, you have proof enough to say, no, I did everything that I had to do. And even though that I didn't notify, maybe you can construe to say, but no, I notified by email and he responded, so he knew. So there are some ways to turn around the formality, but you need to be with a lot of records and documents to make your defense easier for the lawyers. Thank you.
So, thank you, Ana Clara. Thank you, Richidi, for your insight. Very helpful. And thank you, everybody, for your time. It's clear that managing risk in shipping is not just about writing contracts. It's a kind of a discipline, and it's also about how operators respond to the reality. Yeah? Thank you.
Thought-provoking session. Please, may I request the moderator and the panelists to remain on stage so that we can present you with small tokens of appreciation. Thank you. Our next discussion zeroes in on one of the most dynamic challenges that probably the shipping industry is facing today, which is managing legal risk in a world full of sanctions, CSG mandates, and constant regulatory change. Please welcome our moderator, Ms. Monica Kohli, Senior Lawyer, President, Vista UK, and Chairperson of the Indian Maritime Association UK, along with our esteemed panelists, Mr. Chetan Sharma, Legal Counsel, PSA India, Captain Deepak Mandojo, Manager, Legal and Vessel Registrations, Navitera Consultants India, Ms. Amsha Gengan, Advocate and President, Vista South Africa, and Ms. Kate Badley, Partner, Preston Turnbull, LLP, London. Please may we welcome all of you on stage.
Good afternoon, everyone. So I know all of you have had a good lunch. And are we good to start? So one of the things we like to do is just pick on people in the audience, also ask questions. So I hope you all pay attention and, keep a little bit of an eye. We're all very excited about ESG, of course, sanctions. So a bit about our panel. Our topic is up here. Legal risk in an era of sanctions, ESG mandates, and regulations. So first of all of you are in shipping, have any of you faced any sanctions issues? Hands up if any of you have. Okay, just 5 of you. So that's not too bad. But regulatory changes impacted anybody? Yes, of course. Who likes lawyers? Okay, so I just thought we'd start. I know we're not very loved. I know we're loss leaders in most of our companies, but believe me, we are the most important people. So let me introduce you to who's important in their companies. My really, really interesting panel. Let me start with Chetan Sharma. Chetan, do you want to introduce yourself? Tell us who we are. You are.
Thank you, Monica. Very good afternoon to you and my fellow panelists and the distinguished guests. Yeah. So I'm Chetan Sharma. I'm legal counsel with PSA India. I started my career as an active litigator in Delhi. And after a few years, I moved to Kuwait, where I was heading a foreign division of a law firm. And thereafter, I finally came back to the home country and now with PSA for 2.5 years. I manage the corporate, commercial, and transactional practices for PSA entities in India.
Thank you very much. Captain Deepak Manchu, do you want to introduce yourself and your company?
Hi, Monica. Thank you very much. So, this is Captain Deepak Mantoju, and I was a seafarer before. I have worked on board for almost 14 years, and I've quit sailing around 1.5 years back, and have joined Navitera Consultants. We are basically dealing with the flag states. We align with flag states. We are deputy registrars, legal registrars for the flags. And we assist our owners and managers to register their vessels and maintain compliance as per the flag standards. Apart from that, we are also into offshore engineering. We provide complete offshore solutions, detailed engineering, and ship design as well. We are into inspections as well. So we have a lot of different verticals. If I keep talking, it will be 40 minutes will be over. So anyhow, that was a brief about my company. Thank you.
Thank you, Deepak. So the more you do, the more regulations impact you. So that's what we expect from you. And we also hear from Kate, who spent a lot of time preparing for this panel because she's known for weeks. Kate, you want to introduce yourself?
What Monica means is that I joined about 2 hours ago, so I'm very happy to be here. My name's Kate Baddeley. I'm a partner at Preston Turnbull. We're a London-based shipping specialist law firm. We do all sorts of litigation, but I happen to head up the sanctions team, so it was a fortuitous gap in the lineup. So a pleasure to be here.
Thank you, Kate. And last, but definitely not least, the person who's traveled the longest distance to be here with all of us today. Amsha, you want to introduce yourself?
Thank you, Monica. Good afternoon, ladies and gentlemen. My name is Amsha Gengan, and I think I would be remiss if I didn't say where I come from, because even Sanjam has mentioned that on my bio, that I'm coming here with all my African experience. So I'm a South African-based advocate, and my experience does lie from Cape to Cairo. I love to be at Maritime SHIO. This is my third one in person. Mumbai is always on my diary every November. Well, this year, October. It's good to be here and on this panel.
Thank you very much, Amsha. Yeah, it's great to be here, and what a wonderful job Sanjam has done again with Maritime SHIO and now LegalCon or AnchorCon that we are in today. Hopefully an annual event. We're talking sanctions, but I thought rather than jump in, let's go back a bit and talk about what are sanctions exactly and how do they impact India. Based in the UK, we hear about EU sanctions, US sanctions, but how does it impact India? And to give us a bit of an insight, Chetan, can I ask you to start with that?
Sure. Thank you, Monica. So before we even move to sanctions from an Indian context, as we saw, I think just maybe a couple of hands up there when Monica asked the question regarding sanctions, and I saw some of them were not Indians, it seems. It's not a very common practice, it's not a very common topic which we discuss in India. And not all the law firms, in fact, even the top tier ones have a dedicated sanctions practice. So it's very important for us to start with understanding what are sanctions. To put it very simply, sanctions are primarily restrictions or legal restrictions put in by international bodies and countries such as the US, the UN, EU, UK, on various other countries, entities, and individuals to punish or pressurize them to follow international norms. I think this is very simply put. So that's what the sanctions is. Well, does India follow a sanctions regime, an autonomous sanctions regime like the other nations? No. India doesn't follow any direct and autonomous sanctions regime. However, we do follow UN Security Council's sanctions, and also occasionally some of the sanctions are directed precisely on economic or diplomatic front. As you would know, there was earlier this year an unfortunate incident of a terror attack in Pahalgam, and thereafter India imposed unilateral sanctions on Pakistan, not just on goods originating from Pakistan, but all kind of imports, exports. Vessels, Pakistan flagged vessels were not allowed entry. Even till date, they are not allowed entry to any of the Indian ports. So these are the restrictions which India do put in place, along with, say, following RBI circulars or DGFT or customs sanctions. Now, when we talk about sanctions, and as it's not a very common topic, what are the best practices we do follow? So I come from PSA, which is a terminal service operator, and we do have a very dedicated compliance and sanctions team globally. And now what we do is, I think the first step in sanctions and compliance is to do proper KYC, due diligence. So whether you're onboarding your customers, whether they're suppliers, whether they're vendors, you need to have extensive KYC forms in place. Then there has to be a process internally of how those KYC forms can be, and their answers can be interpreted. So we have a checkbox list, which all the say people who are working on KYC forms, they have to tick. And if there is any answer in affirmative, they have to reach out to the concerned legal counsel. So that's the first step. Then there are trainings which help, not just say, and when sanctioned, it's not just legal or compliance, it's operations, it's IT, it's your sales, it's your commercial team, procurement team. Everyone has to be involved in that. They need to be trained on that. Thereafter, you need to have your proper, say, contractual safeguards in place, like the reps and warranties, where you're taking the reps and warranties from your customers, because us being a terminal service provider, we never really know what kind of, say, cargo or the good is in the container. So, it comes to us, and then, maybe the customs will scan it, but to ensure that, there are no sanctioned goods there, the origin of the goods is not from a sanctioned country, we need to ensure that we take all those reps and warranties in the contract. So that's another thing which we do, and most of the, I think, the similar operations they do in India. At the same time, I think it's also important to follow, the international sanctions regime, and you can't do it by sitting in India easily. So you need to be in touch with your external counsels. You need to follow the RBI, DGFT circulars, and yes, I mean, that's how things evolve. They evolve like this in the sanctions practice.
That's great to know. I think best practices, that's very relevant, but also updating it all the time, because sanctions lists come out pretty much suddenly, and mostly on a Friday afternoon. So, making sure that on Monday you're still up to date is quite, I think, a challenge.
Absolutely.
I think at GUARD also we have a dedicated sanctions team, and we're just inundating them. So sanctions lawyers, you'll never be out of a job in the near future. So thank you, that was very, very interesting, and I'm sure DP World, everyone's following a similar kind of regime, because you can't survive otherwise. You can't make payments, you can't receive payments, and that's the main thing. That's what it's all about, right?
And Monica, I think one of the points that Chetan makes is that to know your customer and to be compliant with sanctions and understanding your legal risk is actually a leverage today. It's a competitive advantage. The companies that get it right and that continue to innovate and be agile, if the list comes out on a Friday and if your sanctions team is ready on a Monday, that's your competitive advantage. So I think it's really an opportunity to know your sanctions regulations and your customer.
Yeah, no, that's fun. Thank you, Amsha. That's very good. So you have the practices, and then you have the agility to keep evolving.
Yeah. And also the record keeping. This is also a very important aspect. You need to at least have all the records, KYCs updated at least in 1 or 2 years to ensure that the answers you have are the updated ones, and you keep those records for at least 5 years for any kind of internal or external audits.
Yeah, perfect. Thank you very much. Deepak?
Yeah, so one more thing I'd like to add here is though KYC, we do KYCs for all our customers, But what generally is happening nowadays, the regulations are changing so fast, especially when it comes to sanctions. You load a cargo and you are underway, right? Before you reach your destination port, there is a fresh sanction list. And now you have cargo on board and one of your vendors or someone down the line is somehow related to sanctions. And now you are in a soup, right? How you discharge your cargo. So maintaining just doing the KYC at the initial point is not enough now anymore. You have to be updating yourself almost on a daily basis, and then you record yourself that what you did, so that when there is a soup like this and you are in the middle of it, then you have a proof, you have a trail of documentation stating that you did your due diligence. Now it's not the time anymore where you say that I didn't knew. It was a time where it was very simple. Then like I am the owner and I don't know what has happened. Charters failed, or there was something down the sanctions line. But owners very simply could say that I didn't knew. But right now it's not like that. You have to have a very proactive approach, or else it's a big problematic. There was a similar case with where my firm handled the case. We had a vessel, MR tanker, loaded, destined to discharge in an EU port, and when they reached there, nobody knew that they are now associated with sanctions. The port has rejected entry, and vessel was standing at anchorage, loaded condition, over 2 million spent on damages and all. And then somehow our firm assisted them to clear some part of it, but still unable to discharge the cargo, wasted money and time and resources.
No, it's really fast moving, and like you said, mid-ocean, if you get a sanction, what can you do? So yeah, like I said, lawyers, you all have a job, so don't worry about it. So Deepak, since you've taken us to the next stage, you're working in regulatory flux, you're working with policy uncertainty. How do you stay agile and how do you stay ahead of all of this? Tell us from your experience.
Thank you for the question again, Monica. So when it comes to regulations and all, I believe that the maritime industry right now is navigating what I'll call a perfect storm of regulations. It can be environmental, technical, social. The regulations are changing way too fast because let's face it, we started shipping, shipping came into full force in, let's say, maybe last 50 years or so, not before that. So we started whatever we knew, emission, we didn't care about emission, garbage pollution, throwing garbage out at sea, all was a very common practice. And now we are facing the repercussions of what we did earlier, right? So now all of a sudden we are aware what has happened. We have what damage we have already done. And that is the primary reason why we have so many regulations coming in at the same time. Because now everybody knows what is happening. There is garbage all over floating around the sea. There is oil pollution, oil spills. And so all the regulations are hitting it at the same time. But yeah, it's a good thing. It's not a bad thing. It's a good thing. But the pace is there from IMO's carbon emission and EU's emission schemes to India's own ship recycling and crew welfare agendas. So the regulations are changing drastically when we see the last 5 years or so. But yeah, it has to happen. It had to happen. Now is the time that is happening because of the past experience what we have done. So for the legal teams and for the board, the biggest challenge that they face is agility. Because as I said, the regulations are changing so fast, you have to keep a track of the regulations, at the same time making sure that your commercial operation is viable and also commercially profitable, or else what's the use of all this? So to keep that balance, the compliance and the commercial part of it, your team, your legal team and the board has to be agile. So there is...
So always reading, always on top, always awake?
Yeah, of course. You have to be on top, right? Or else if you miss an update, then of course it's a risk. It's a loss that you have to wait.
Absolutely. And of course you're very young, so your mode of communication is like so much faster, right? There's Twitter, there's WhatsApp, there's all.
Absolutely.
I mean, talk to Captain Bhasin over there. When he was younger, not that you're old, Captain Bhasin, but when you were younger, it was only fax and telex. So whole day you could party, and morning you get your information. Today, every minute kind of we are working. Not that you're old, Captain Bhasin, but you know, you're older than some of us on the panel. Sorry, I think the point to bring across is how fast information is coming and how different it is to even 5 years ago, I would say, especially with sanctions. Sorry, I interrupted you, Captain. Any more you want to say?
So to have this agility, I believe the main thing what you need is collaboration. Collaboration with your legal team, with your commercial, with technical, and the mindset, the culture. I'll give you an example of my own firm. When last year, I guess, when the sanctions were just starting out, so we had a very basic, we have clients all over the globe, so we invoice them, we send them money, they send us money, there is a lot of things going on. So yeah, it's all of money, of course, or else why are we sitting here, right? Yeah. So we had a very basic principle. You get the details of the invoices, you make the invoices, you send, you get the money, end of story. And then when sanctions hit, and we had to do, as Chetan before pointed out, we had to do a lot of KYC. You have to be very careful from where the money is getting to you, where you are sending the money. So all of a sudden, we had all these forms. You have to do the due diligence. You're going to C-Searcher, blah, 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 whatever you have the platforms. And all of a sudden, our team were loaded with all this extra work that has come their way, where it was very simpler initially. And now it's like 10 minutes job has got to 1 hour. So initially, it was difficult. Our teams were like, what's going on? So, but it is a mandate. If we don't do this, we don't have a business tomorrow. So we started doing that, and right now the culture is like that. It has embedded into our system. We get, even though it's an Indian customer, we know sanctions are not applicable, US sanctions are not applicable in India, but still now the process has so much been embedded into our system, we go automatically and we do those checks, which are necessary to be compliant. So the mindset of the people is very important, where they see these regulations not as an hurdle. They see this as an opportunity to grow, or opportunity to do a better job what you were doing earlier. So that's what you have to think it not as a hurdle, as a navigational chart. As I'm a seafarer, I'll quote that. As a chart, it is there. You just have to follow it, and you will be ready for the next transformation.
And you have to keep evolving. Thank you. Yeah, I completely understand.
I just need to add a very important point by Captain Deepak over here. What we have done internally is that we've prepared a checklist. So, it's, as he mentioned, it was very difficult in the beginning, how, to navigate, how to find out. But to simply answer, or to some of the important questions over here are, who is the customer? Where does the goods originate from? What's the payment mechanism involved, the currencies? Who is the end customer? End customer is also very important. Which kind of services they're offering. So all of these are not just important from the goods perspective, but from, say, coming from one terminal to another terminal, and then the vessels in between, and there's a complex web. So some of these questions really simplify the procedure.
So the exposure aspect also, not just, yeah. That's perfect. So now we've come from the client side to the legal side, if I may, in that sense. So Kate, you've been working with sanctions for a very long time. And of course, in the UK, we have a much bigger web in a way, UK, US, EU, and where we fall in the middle. So I wonder if you could tell us a little bit more about the main legal risks arising from sanctions facing the shipping industry per se, and what have you seen in your experience?
Yes, certainly. So I think there are sort of three main legal risks that I see clients facing kind of on a daily basis. So the first is that their actions are actually going to be in breach of sanctions. The first, sorry, can you hear me okay? Yeah. The first is that their actions are actually in breach of sanctions, which itself is going to come with ramifications, fines, potential criminal offences, etc. The second is that you can become a sanctions target. That might be as a result of having breached sanctions, but also that can happen without you actually having undertaken any unlawful activity. So you see that particularly in the US context with their SDN listings. You may not be a US entity, you may not have operated in the US at all, but if they think your activity is detrimental to their sanctions policy, you might find yourself a target anyway. And thirdly, there's the contractual risk. And I thought to sort of best illustrate this, we could look at a sort of cautionary tale or a horror story, depending how you see it, which is a current case that I'm involved in for a client. So the clients are Turkish owners. They own a vessel that has been involved since the new year in shipping Russian oil. So this is lawful Russian oil trade. They have been complying with the oil price cap attestation requirements and shipping from Russia to third countries. Nevertheless, in June, their vessel was sanctioned by the EU, and then in October of this year, it was sanctioned by the UK. And the designation criteria is really wide. So in the UK, it's simply the fact that you are operating in the Russian oil sector is enough for your vessel to be designated. So we're engaging with the authorities on the client's behalf, but it's quite hard because they clearly have been engaging with the Russian oil industry, but we are trying to put forward the case that they've done so in a lawful manner. And in that regard, they did due diligence for all their trades. They took external legal advice and checked their counterparties. They took attestations. And the irony is that for one of the trades, they were not satisfied from a due diligence perspective, and they didn't actually go ahead with the lifting. As a consequence, the charterers lost the subcharter. The vessel, they got a mitigation fixture, and they proceeded to India, where the charterers promptly arrested the vessel and terminated the charter. That was in June, and the vessel is still arrested. So the clients, firstly, they haven't undertaken any unlawful activity from our assessment, and yet not only have they become subject to sanctions, they're also facing litigation for having tried to comply with the sanction legislation. So that is kind of the worst case scenario for clients.
It is very challenging because, like you said, and I think all three of you are bringing that out, it could happen any minute, at any stage of the trade, and at any time. So it is a challenge, and I think that's why everyone needs to work together in a way in collaborating.
And it does obviously depend on your risk appetite. They had chosen to engage in a high-risk activity. That was their risk appetite. They were obviously doing so lawfully, but you are sailing quite close to the wind. We've got other clients, that kind of trade would be a complete no. So those are the risks you have to weigh up when you're choosing what to be involved with.
Yeah, and I think shipping quite often is about risk. You always hear about shipping magnates making their money during periods of high risk. So as you said, it is a risk appetite, and you need to see where you sit on it. High money, high gain, high risk. So, but thank you very much for that. Yeah, please, Deepak.
So, Kate, I heard your example. In this one, anyhow, I'm very sure.
Is it your vessel, Deepak? Is it your vessel she's talking about?
No. So, yeah, then just for the record, it was not my vessel.
Okay.
So, in this case, of course, the owners knew what they are doing. They chose to, act and go for Russian trade, of course. But we have seen cases where, the sanctions are now with, I don't know, they are so in a hurry to put sanctions on everyone, where cases have evolved where the vessel have just been in Iranian waters just to take bunkers, or maybe due to, some issues, the operational issues, the engine failures or something, vessel has to linger there for a bit, maybe a few hours. Even in those cases, we have seen authorities sanction the vessels way too quickly. And then the point here is, it's not about that they sanctioned it. The point is, once the vessel gets sanctioned, it's way too difficult for them to get charter or do any kind of activity. It's like an elephant sitting in your closet, right? So it has happened with us. So those are the cases which are way too difficult to deal. The owners are in terrible pain because of this. They have invested huge amounts of money, and once they are sanctioned, there is no going back. As she said, you can file a case and you can try to advocate, but there are so many cases that then the time frame to resolve is way too long.
Yeah, no, absolutely. It's like avoiding sanctions. Once you're sanctioned, you cannot get away from it. It's an uphill battle after that. So yeah. Oh, thank you. Moving quickly on to Amsha. Amsha, can we talk to you about governance and inclusion? You're a lawyer, but you're also president of Vista South Africa. You've been involved with Maritime CEO. You champion hard. Is there a way we can get in more inclusion into governance and ESG? Tell us about that.
Thanks for that, Monica. Actually, I do want to acknowledge, it's just occurred to me, there are 3 current presidents of Worcester, India, South Africa, and the United Kingdom. And I don't know, Sanjam can correct me, are there 2 past presidents, as in Sanjam and Singapore? Yes. So I think that answers the question. We have come a long way with women and inclusion in shipping. But I want to share something that's anecdotal. It's my personal experience. So I've begun as an advocate 25 years ago. And I used to travel, as I mentioned, Cape to Cairo is the expertise that I have. So it's a lot of time in a plane, and in the early days, it was with my boss. And no offense to present company, but of course my boss was male and very pale. And when I traveled with him, I was very often mistaken for either his PA, and I don't have any secretarial skills, or worse still, his girlfriend. And now when I travel, it's different. The landscape has changed. So the story may have been one of challenges and struggle for how women are included in the sector. And Monica, for us, it's not just in shipping, but it's in law as well. The legal profession is time-honored for being, and notorious for being associated with men. So women in shipping and shipping law have 2 barriers to break. But now, as I've mentioned, we have 3 current presidents of Worcester and 2 immediate past presidents in this room. The conversation has certainly changed. And I think we must remember that when we include women in shipping or in any sector for that matter, women bring diversity of thought. They bring diversity of perspective. And when many voices are heard or included in whatever the conversation or the narrative we're having, we will create innovation. When innovation is spurred on, economic growth follows very quickly. And I think we must also remember, when we talk about inclusion in the sector and we talk about gender empowerment, it's very important to acknowledge that equality does not equate to equity. All the women in this room, we had different starting points. We began at different places based on our generations before us, based on wealth in our families, based on access to education. So it's important that the conversation of inclusivity recognizes that equality doesn't equate to equity. I think it's also very fitting, Monica, that we are in India, and I want to quote erstwhile lawyer and former Prime Minister of India, Sri Nehru, who said, "The status of a country can be judged by the condition of its women." I think it's really profound that we're having this discussion today, that we have the platform as Maritime CEO and today AnchorCon to allow us the space to talk about this. And for me, it would be interesting. As I shared, 25 years ago, I was thought to be somebody's PA or girlfriend. Now I head up a legal function in a global multinational. We have a platform like CEO. We have in the Secretary General of the IMO an absolute staunch supporter for our vision and mission for gender empowerment. the IMO is committed to the UN Sustainable Development Goal 5 on gender equality. So the conversation, the trajectory has changed, and we must recognize that. But having said that, there's still a lot of work to do. It's the gentlemen in the room, the gentlemen in our lives that continue to also support the conversation and assist with the trajectory. So we've made good strides, but I think sometimes women are their own barriers. Sometimes we think we can't do it all, and it is difficult to juggle. But ladies, I can tell you that there was no man 50 years ago who thought he couldn't do it all. So even if you think you can't do it all, just do it, and it will all fall into place. So there's a lot to celebrate. We've come a long way in shipping and in our legal profession, whichever jurisdiction we may practice in. But there's a lot of work to do, and we must do it ourselves. We must own our journey. We mustn't give people a choice when we go to them for support. You must get the support from whoever you seek it, male or female. And I think we must support each other, and that's why we have platforms like SheEO and Worcester, because they carry the women in their networks. Thank you, Monica.
Thank you. I'm sure that was... I think that was really beautifully said, and you know, we can see the change in the last decade or so. It's terrible to be able to say this, but we have at least seen the change. And it doesn't happen overnight. It happens because you and I sit and talk and you all support us. So that's why, you know, we have, and it was really interesting because now being a member of Vista is a KPI in a lot of companies. So someone actually said, he did a review and he said, my KPI for my junior was, have you joined Vista? So I thought that was a beautiful thing to say.
That's excellent. That's absolutely excellent. I myself in South Africa have experienced the local MD of one of the international shipping companies approached me to say, what are the benefits for me being a corporate member? There are women in Europe and the UK and Asia. So we wanna support Worcester, South Africa. So you are now seeing male and female executives who realize the opportunity and the leverage, inclusivity, diversity bring to their teams, and they want to encourage that.
Yeah, and I think we all learn when we are doing things. So that's it's nice to see so many men in the room. So that's really good. We have 1 minute left. So if I can go through 10 seconds of future proofing, is there anything we can do to future proof, and what? And then we'll wind down. So I'll start with you, Kate, and then come around.
So it is 10 seconds.
15.
15. From a sanctions perspective, very difficult. Obviously, have all your systems in place, sanctions compliance plans, etc. Basically, if the authorities ever come calling, rule of thumb is you want to be able to hold your head up and say, we did everything we reasonably could, that's the best you can do. So, but very difficult with legislation changing and even the courts interpreting things in ways you might not expect.
Okay, have your systems in place and hope for the best. Deepak?
Yeah, so from a sanctions point of view, of course, you can't do much. So you do your KYC, keep your records, be ready.
Be
Apart
ready.
from that, then other regulation, I feel crew and crew welfare is something that we have to watch out for with the next decade.
Yeah, crew welfare. Okay. Chetan?
So since my fellow panelists have already covered sanctions, I'll not dive into that. But I would say that as far as terminal service providers are concerned, I think the cybersecurity and educating lawyers on technology and how to deal with technology and technological advancements. While we do have all the government initiatives like Sagarmala, like ULIP, but each of these are say potential entry points for cyber threats. because all of our systems, including cranes, automated gates, logistics supply chain, it's all interlinked. So it's very important to know when and where to look out for, who to contact, where to record, where to kind of file your complaints, and that's how the investigation is done. So advancing, or can say for my side, educating lawyers on technological fluency would be the best, and the measure.
So future-proof by educating lawyers. Okay, Amsha, saving the best for last.
I think since we're talking legal risk, future-proofing means spend some money on the lawyers and our teams. You've got to use the OPEX. Use it for legal tech. Get your lawyers trained and upskilled, data analytics, AI, machine learning. But having said all of that, I may want to say something controversial. In this fourth industrial revolution, whilst AI, machine learning, and tech is important and we invest in it and it is future skilling, master the art of communication. That is what will set you apart in this time. People place too much of reliance or dependence on the digital, on some system to do something for you. And what you put into the system and what you get out on the system, our minds have become lazy and our behavior has become complacent. We are not using critical thinking. So master the art of communication. You must be able to articulate what your brain has processed with what the legal tech has done for you.
Fabulous. I think, yes, be ready, use your brains. So fantastic. On that note, can we just say, as always, a big hand to our wonderful panel from lawyers to the terminal. Thank you very, very much. Thank you, everyone. And if you have any questions, they're around to ask later. Thanks a lot. Thank you, Sanjam.
Please may we request you to remain on stage so that we can present you the tokens of appreciation. Thank you, everyone. Before we move ahead, let's rewind a bit and relive once again some of the beautiful moments from the last 2 days of the Maritime Shio 2025. So here we have the highlights once again for those of you who had missed in the first session.
Asia and also here for Japan.
The maritime world isn't just watching us, it's waiting for us. Waiting for leaders who don't just navigate ships, but navigate the future. Because we are the CEOs who refuse to stay anchored when the horizon calls. Thank you for being part of this journey.
Right, hope you guys enjoyed that. Our next session shines light on an urgent issue, which is cyberbullying and social stalking of women seafarers. This panel promises to be powerful, informative, and solution-oriented. Please join me in welcoming the esteemed speakers. Shri Shyam Jagannathan IAS, Director General of Shipping, Government of India. Ms. Suniti Bala, Co-Founder, International Women Seafarers Foundation. Dr. Pathatil Dhanya Menon, Director, Avanzo Cybersecurity Solutions Private Limited. Dr. Rajiv Anand, MD and Senior Psychiatrist, Inner Light Counseling Center. Mr. Deepu Kishan Chandani, President, BW Maritime Pte. Limited, India Branch. Captain Pankaj Kumar, Deputy General Manager, Fleet Personnel, Shipping Corporation of India. May I invite all of you on stage, please? We understand that Shri Shyam Jagannathan, DG, is a little delayed, so he's on his way. In the meantime, the panelists can commence and sir should be joining us shortly.
Good afternoon, everyone present in this room. A very warm welcome to all of you on this very critical topic, having the panel discussion, cyberbullying and social stalking of women seafarers. As we understand that he's already here. Just give me a second. So this topic has been in our importance criteria number one for last 3 to 4 years when we as an International Women Seafarers Foundation have been dealing with various cases with our members who are sailing on board ships. We do know that as we embrace the digital age, we also faced few new forms of vulnerability. And for women working at sea, far from their support system, online harassment can be both deeply personal and professionally damaging. So today's topic, we will try to focus on having the technological challenges, the policy frameworks, psychological impact on the women seafarers, and employers' responsibility. And we will also touch base on a little bit of training needs. Let me briefly introduce our esteemed panelists. So we have in our panel, Shyam Jagannathan, IS Director General of Shipping. He is 1997 batch IS Officer of Assam, Meghalaya. Assumed Office of Director General of Shipping under Ministry of Post Shipping and Waterways, Government of India on 3rd July 2023. He has earlier served as Zonal Development Commissioner, Santa Cruz Electronic Export Processing Zone, Special Economic Zone SES, Mumbai under the Ministry of Commerce and Industry, Government of India at Mumbai. At his earlier assignment with the State Government of Assam, Shri Shyam Jagannathan has served as Commissioner and Secretary, Finance Department and Commissioner North Assam Division. Welcome you here, sir. Thank you very much for coming and joining this session. Our next panelist is Dr. Patatil Dhanya Menon. She is Director Avenzo Cyber Security Solutions. She is one of the special panelists with us. She has been awarded with Government of India as a First Woman Achiever Award. And she has been in this industry more than 2 decades, having the cyber investigations with the Government of India, and now she has his own. She is a consultant specializing in development of security policies for corporations, performing cyber legal audits and information system audits for banks and non-banking financial companies. As a distinguished cybercrime investigator and a leading authority in cybersecurity, she has played key role in numerous high-profile cybercrime investigations and collaborated with law enforcement agencies to tackle intricate cybercrimes. Welcome, Dhanya. Today we have Dr. Rajiv Anand, who is senior psychiatrist and a marriage counselor in practicing since last 45 years in western suburbs of Mumbai. He was honored with Lifetime Achievement Award by AMA. He has conducted more than 45,000 workshops for different groups and companies with audience size of 10 to 800. His television program on various channels have been widely appreciated for his forthright and practical approach. Thank you, sir, for joining us today. Next esteemed panelist we have Mr. Deepu Krishna Chandani. He is president with BW Maritime Private Limited Indian branch he's heading. He has been chief engineer and he has a very long career at sea and at shore. From 2003 till today, he is with the BW Maritime. Before that, he has been fleet manager with IMS Ship Management. And his past career also include being technical superintendent with the Sunday Ship Management, and of course, sailing on board as a chief engineer from 1984 to 1999. Thank you very much for joining us today. Our next in line for the panelist, we have Captain Pankaj Kumar. He began his shipping career in, he's Deputy General Manager, Fleet Personal Shipping Corporation of India. Captain Pankaj began his shipping career in 1995 as a cadet in SCI. After serving aboard different type of vessels, including tankers, bulk, carrier, and containers, he was promoted to rank of master in 2005. He completed his economic degree in MBA. He also has passed his PQ by Institute of Charter Shipbrokers, and he also has LLB from KC Law College. Welcome, sir. Thank you very much. And I think we will start with the question because this topic has been very important. As I discussed that we have been dealing with these cases as an International Women Seafarers Foundation where our members have faced. And some of the cases have been very, very serious of its nature. And that's what we will try to understand today, that how severe is the problem, what are the impacts on the human side, and how we can deal with a policy framework as needed. And at the same time, what could be the training to various stakeholders in the industry. That would be our framework. So I will start with Dr. Dhanya, with you.
Thank you very much. I think I've been called in to establish the problem statement. So,
yes,
the moderator introduced, I've been in this for the last 2 decades and more. There has not been much of a difference on the social aspect or the individual aspect of the crimes that people face, more so what women face on the social media or on the internet platform. It has mostly been because of identity theft, it has been because of fake profiles, because of bullying, harassment, relationship issues, and it just goes on. The platforms probably I started working on was Orkut. I don't think the new generation has even heard about it. So we started working on Orkut, but now it's more on the latest platforms that you see. It is Reddit, it is Discord, it is Facebook, it is Instagram. Every time there is an issue which comes up which hurts a female, a woman, it is always emotionally related to her and the people around her. And most of the time, this lady or the woman is alone to deal with the situation. More so with seafarers, I would say, because they're away from the land also. But even when they are with the family, what I find is that the youngsters are not able to communicate what has happened exactly. Because I've dealt with issues that relate to women and child under the Ministry of Women and Child. Children definitely go through this problem because they're not able to justify why they are on the platform. First thing. Second thing, if you're not on the platform, then you're out of your peer group. You're looked at as if you don't belong to this world. So justifying why you are on the certain platforms is one of the things. Second thing is to judge and to understand what kind of information we are ready to share on this particular platform. Most of the time, yes, the ownership of the information that goes out is on the owner of the profile itself. I have to decide what picture of mine goes online, what information of mine goes online, because primarily this platform has something called addiction, which pulls us along to share anything and everything, like from the itinerary, what I do the first thing in the morning, what I eat, what I wear, what I like, etc. So is this information actually needed? Are we ready to share such information online? Is a very personal choice that every individual needs to take, and a very conscious decision as well. Once it is on internet, it's forever there. There's nothing called deletion, please. There is nothing called deletion. You may delete it from your profile, but it doesn't go out of internet. That is a fact. So if somebody comes and promises you saying that they'll take all of your data that you don't want from the internet, it is not possible. My experience says it is not possible. It may be possible to take it down from certain sites, but not from internet totally. So I think I have opened it. I'll leave it for the others.
Thank you very much, Dr. Dhanya. It was really important. And just to add there that this is not only, because this is a very common trend also on the land. But then girls or anybody else have a support and they have someone to go to. But this becomes a very special case when girl is alone on board ship and now she doesn't know where to go and how to even tell this is a issue, because very first question, like you mentioned, it will be pointed back to her. So then it becomes very challenging that even sharing this kind of information, who she should share to. We are glad that they had the confidence in us and they could come to us and seek help. But that is also something we need to look into, how we can support the girls, not only with the right guidelines that what do's and don'ts, but at the same time how we can do it. So that is something we will try to find out in this panel discussion.
Sure, thank you.
But thank you very much. Moving forward, I would like to go to Shri Shyam Jagannathan. And sir, we would like to ask, because this is something we have seen a kind of elephant in the room. Everyone is aware. But when it comes to deal with it, from the policy making side, how do you see that this can become a point of at least discussion and later on a policy making from the government agency, and especially when we talk about the women seafarers, how it can be done?
As you said, it is very pertinent. The government has recently legislated the DPDP Act, that is the Digital Protection of Personal Data. Now, this is a start point. The second point out here, which I would like to mention is, we don't have this as yet, either in the maritime domain or as a mandate on the corporate side, which I firmly believe is a standardization on cyber security compliances. So whatever networks you're using, be it if you're on board or in an office environment, unless it is an independently accessed network, would need to have a central information security officer and a cyber security firewall, which basically occludes certain aspects in social media in terms of cyber stalking or in terms of misuse of data. And this needs to be mandated. It's still a work in progress. The third aspect is every concern which is professionally engaging a lady professional, not only for seafaring, but also for onshore support services or for any professional occupation, they need to mandate how the digital identity of that employee, at least in the workspace, is sacrosanct and is not abused in any manner. This naturally will have a mirror reflection in the personal digital space. As ma'am had very rightly said, as an individual, you choose to what extent you would want to take exposure on a popular social media platform. And it has its negatives in misuse. How we check that in the professional space is what I submitted earlier. Now coming to the personal space and as an individual or as a citizen, the DPDP Act applies to you too. The Information Security Act and the rules thereof apply to each one of us. 1930 is essentially something where cyber fraud is reported to. That now needs to be deepened into sub-verticals where you have issues such as cybercrime related to cyber stalking, misuse of profiles by creation of profiles, use of obscene or abusive language, or any manner of vilification which undermines your digital identity needs to have a criminal deterrent. That has to be brought into the policy. It still is a work in progress. And I firmly believe, as presently say in the maritime domain, we keep reiterating we are less than 2% of women in basically maritime. But unless you ensure a secure digital environment as a workspace, it will be difficult to allow, because this is a particular platform or a via media where one's own identity as a perpetrator can be concealed much, much easier than in a physical act.
Physical one. Yeah, that's why it is more challenging because it's so difficult to get, and even if you get it, then it is difficult to prove because immediately the chats will be deleted, pictures will be deleted, and now you have to go in backhand of the system to figure it out if you have not taken the screenshot. So even dealing with this matter becomes pretty challenging once it is established, everyone knows it, but how to get the perpetrator to the real just conclusion and giving justice to the victim here, that becomes an additional challenge.
Essentially, the cyber domain doesn't have national boundaries.
That's, I was going to say, thank you for mentioning that. Being seafarers and ships, this is another biggest challenge we have. Yeah.
So I firmly believe, and this is again as an individual, not that I am incumbent in the office of the Director General, because conventionally, institutional, regulatory, compliance authorities such as the Directorate General of Shipping, if you look at, are always post facto. They are never preemptive. But in the cyber domain, you will need a preemptive offensive counter-strike. Meaning, for instance, if an identity spoofing is there, or a mirroring of a particular cyber identity is there, or an IP address is dynamically being utilized for basically either inserting malware, because here we are only looking at a very smaller subset of cyber risks, which is individual centric and specifically for a woman. It becomes much more nastier, say for instance, the commercial part. You may be an employee in, say, a major company. That company's entire logistics could be brought to a standstill. Now, imagine what happens if you are mid-sea, not having your basic input as to where exactly to report because your ports have been realigned mid-voyage.
Yeah.
Extending your contract on board while you are undergoing a similar subset of personal hardship with probably a different crew member or a difficult cyber stalker who's toying around with your public profile.
Yes.
And you're in the confined space of a vessel and not really having anyone. This is where I believe the conventional statutory response of registering a complaint, thereafter acting towards it, because the perpetrator would not be confining to national boundaries.
No.
This needs to be addressed. I myself don't have a policy paradigm for this because we are all contending with this globally.
We do understand, and that's why it becomes more and more important. But what we have seen, the cases we have dealt, so we had to go to the police station to actually get the perpetrator in place. But what kind of support the woman seafarer gets from the employers, from the administration, and what kind of support on the mental health part, because the damage is being done. So maybe I would like to shift to Dr. Rajiv. Maybe you can throw some light that how does this digital harassment can impact a woman's mental health and maybe a willingness to pursue this career further, because it's maybe on shore side, on land side, woman is fine, and maybe she gets all the support from the family and friends to deal the matter in a way that she is not so damaged in her mental health. But considering she is on board and she's still maybe having 2 months more left to continue with her work, how it impacts, and in your opinion, touching the human side of this conversation.
Thank you, Suniti. It's a pleasure to be in the company of the experts, Mr. Shyam Narayan, and thank you for inviting over here. In fact, sitting over here, I was thinking that how much progress we have made over the thousands of years of oppression, suppression of the female, stereotyping of the role. तुम्हें खाली खाना बनाना है, बच्चे पैदा करने हैं, बड़ा करना है. Last 30-40 years, we have so many people, so many women working in Air Force, working in Navy, working in Army, working in police, working as a scientist, working teachers, and bank job was traditional earlier too. Now the seafarer, I was just gathering the basics from Suniti that so far only 2% women are there among the whole number of seafarers or the engineers on that. She's the first women engineer, women chief engineer, am I right? Women chief engineer in the merchant, in the Navy. So great. Now, what I was looking through, that traditionally women had been injected with the notion that you are a woman, woman, woman. I feel what you are inside the cloth is nobody's business. When army says we are the same uniform as everybody else, when Navy says the same, when police says the same, Air Force says the same, scientists says the same uniform. Why not in the Navy also? The women should first forget their own gender. First, they should forget they are female before they make others forget. I think they carry that sensitivity, self-consciousness, I'm a woman. And that's why they invited glances, comments, so on and so forth from the male colleagues working on the ship with a limited 20. I inquired how many people work on a ship, 20, 200. So the female remain that I'm a female, I have to save myself. Now save from whom? If you are equal, I don't have to save myself, any one of them, if I'm equal. But if I feel weak, then I have to save myself. Let this notion be done away with by the female themselves primarily, that they are in any way less than a man. No. They are taking equal duty, they are discharging equal responsibility, and that would go a long way. I also wish that somewhere when their training is imparted, wheresoever and whatsoever platform, some kind of sensitization should be done about that, how you would interact. Like in the flying, I have many friends in the aviation industry. They have some called CRM codes, that interpersonal relationship. When two people are on the flight for 8 hours, 12 hours, they should get along gel with each other. They shouldn't have any kind of friction so that the flight or the few hundred people life should not be endangered. Similarly here, they carry, I was inquiring how much weight the ship carry, how many tons, how many containers they carry. So their psychology, they carry the huge ship, the huge container, but little mind here and the emotions here can create a havoc to the price of what they are caring about. So I'm sure that with little sensitization, orientation, and great discussion, these kind of platforms, you would generate a new awareness, more and more women would like to follow your footprints. Thank you.
Thank you very much. And just to add added question there, how do you think that we can still encourage what we as a stakeholders in the women seafarers career, being an employer, being a NGO, being administration, can help in certain instances when she's going through this cyberbullying? So she needs the mental support. It is impacting her mental health. So how to keep her momentum, that how to deal with it?
Are you asking me?
Yes.
Okay. I would appeal to gentleman next to me who is Director General of Shipping Corporation, am I right, sir? That each one of us have a need to talk to near and dear ones.
Yes.
Including you and me. Unfortunately, ever since the media has expanded its wings everywhere, including to our bedroom, one TV, 4 phone calls, so phone, laptop, we are falling distance. We are falling apart. Now, we have posted women on the ship on a particular assigned duty, particular training. But do we have someone whom she can talk to without being identified, without being judged, without being criticized? No, we don't have any system. Now, if over the last 30, 40 years, many of the big companies have opened their own in-house counseling center. Now, I'm not soliciting work over here. Me and my team are handful. We are having handful of work, whatever way we are having it. No, that's not the agenda. Agenda is that each person working on a ship should have access to someone, may not necessarily be 24/7 on the ship, but now with the internet, anywhere in the world, one can call up. I want to talk, unjudged, uncriticized. And that would be a great catharsis. मेरा रोने का मन कर रहा है, मैं किसको बताऊं? शिप पर जाके बताऊंगी, 10 को खबर हो जाएगी. मुझे मम्मी की याद आ रही है, मुझे हस्बैंड की याद आ रही है, मेरे बच्चे की याद आ रही है. किसको बताऊं? सब लोग तो जजमेंट करने के लिए बैठे हुए हैं. तो एक ऐसा विंडो बनाइए आप. That she can send 2 hours advance, 6 hours advance notice, and she would be listened to.
So this is how we can
That would
support.
go a long way.
Yeah.
And secondly, just one more example I would like to use, like the nail cutter, like the scissor, like the knife, which has multiple purposes, multiple helpful purposes. But side by side, we also know that that is to be shut off till we use it again. Mobile, laptops, camera, any social media platform is like that. We keep it open 24 by 7. And by now, we all know that we are being snooped. Be it the mobile, be it the laptop camera, or be it anything. Why we should not learn to shut it off like the knife or the scissor when we are not using it? Let it not harm us. Social media is going to harm in innumerable number of unexpected way, which we would realize it very soon.
Yeah, and coming to like we are actually discussing the negative impact of technology, but like you mentioned, she should have someone to talk to. Maybe this technology can still helpful to talk to that person, so that it is up to us how we use the technology. Thank you, Dr. Rajiv. Now I would like to go to Captain Pankaj, and Shipping Corporation of India. I think this is one company who has really long history in having the women seafarers. And at least I believe Shipping Corporation of India has seen how time has changed and how the dealing and problems related to seafarers, and especially the women seafarers, because at one point of time, SCI has been having the maximum number of women seafarers. So Captain Pankaj, please throw some light that what kind of cases you have been dealing, and what, out of all those harassment cases, cyberbullying and social stalking, how much you see that it is impacting women seafarers?
Ms. Sunita, first of all, when I saw the panelist, it was like a child sitting with stalwarts. You have the senior most regulators, you have a senior psychiatrist, senior cyber expert. So initially, I was thinking, what is my role? But then I realized that I'm the only one who is having experience of having women on board, sailing with them. There are quite few here who know me very well. In fact, I was chief officer when SCI decided to take the first batch of women seafarers. They were from 12th standard ITJE extended list, and all three of them are master mariners. And Captain Anuradha Jha, I would mention Captain Tarkar. So that brings me back to the thing which Dr. Anand said, that when it started in 2002, we have come a long way, We have many seafarers. I met one of them, many of my sitting here. So we have come a long way. But as Jagannathan Saab said, it's a work in progress. So there are a lot of things which we have to do. As we all know, the recent STCW convention amendments which are coming in January talks about educating the seafarers about, the harassment and bullying. There is no special mention, although there are guidelines by ICS and ITF, which I have gone through, where they say that how to define the cyberbullying, and DG Saab has covered some part of it. As we know, the company's responsibility is to have this part of their SMS, and the MLC also talks about how to deal with harassment. Now, if you ask me honestly, there has not been any reported case of cyberbullying, because before that, we have to understand what cyberbullying is. I mean, some of the seafarers, probably women seafarers, they keep it to themselves. But I have had experience of women working with me where they had a sense of self-doubt that, whether what I'm doing is right, or whether I'll be able to do it. And as I said, they're all captains now. We need to work on that self-doubt. And as a company, we have been the leaders in engaging women seafarers. Recently also, I had a case of a lady who had not sailed for 4 or 5 years, and SCA, as you know, we tried to help her, and she is sailing as second engineer of one of our vessels. She had her own issues. So in India, as sir has rightly said, regulations are not there to deal with it. On ships, there are guidelines by international body. I was going through European Trade Federation also. They have come up with a lot of guidelines how to deal with this. As a company, you have to have a policy. And there has to be zero tolerance to this. As a CI, we have zero tolerance to this. we have a system in place where we deal with harassment cases, and we allow them to express. There are different channels. You have to give them, if the person whom they are reporting to is the one creating issues, then she has to have a different line. So you have to open, and she also needs to have a feeling that there will be no retaliation of her complaining. As an organization, when there is a fear of retaliation, sometimes the
It
female
is huge,
officer...
actually. It is huge.
So what I feel is there should be a policy and a framework of how to do. We need to have protocols in place. And also, when there is a reporting, we must have a system in place to carry out investigations and support the women seafarer for any kind of bullying, including the cyber bullying. And the cyber space, of course, we have to exercise restraint also. When we are going on the social platform, it is the responsibility of the women seafarer also of what to post, what not to post. Because sometimes, we are ourselves not sure. I was reading about, when you told me about this, I've gone through a lot of research papers. I was surprised to see that there are many research. In fact, I found a research paper which talks about the various research done on this field. And it talks almost 100 research have been done on
It's
the...
a much needed research,
Yeah,
actually.
so what I'm saying is they should also understand, uh, I read about a red face test. When you are trying to put something there, you see that if your boss sees it, whether it will make you red-faced or not. So I think you have to have, the both sides have to work together. The seafarer side have to have little responsibility, and as the newer generations are tech savvy, you can't have restraint, because I'm sure that is not going to work. And as a responsible company, you should have protocols in place, you should have procedures, and I'm sure it is something which can be easily achievable. But we have to necessarily train the people ashore also, that you train them how to deal with this, and you train the seafarer also how to deal with this. And if both these sections are working together, I'm sure we will one day achieve it.
But that's a long, far-fetched future, so we need to start working towards it. But continuing with the policy, I would like to ask Mr. Deepu Krishnachandani. The Hafnia, they have done a tremendous good work, awesome work in last 3 years, where they have increased their participation of women seafarers on board to 10%, which I came to know. It is really amazing. And I was congratulating him that in 3 years period, that's really good work. But with that, it comes with a lot of responsibility and policy and framework. So I would like to ask you how Hafnia is dealing with policy framework in this regard, focusing on the cyber incidents and the social stalking.
Thank you. Good evening, everyone. Yes, Suniti, we started this project 3 years back. When you see, it was decided that we want to engage with more and more women seafarers. Hafnia also is an oil tanker company.
Yes.
Your 2% that you are talking about is more with cruise vessels. We are a pure oil tanker and a chemical tanker company, and we have achieved 10%. It's 9.8 to be precise. I would say 49% of these are Indian women. Of course, it's a mixed nationality that we have. Now, how we planned about it was, when you start slowly, we believed that you have to develop strength in numbers. So we said, let's get women and put them on one ship. So we start increasing the concentration on that ship. Today we have 9 ships running with 50% women on board. On other vessels where we always make sure there are at least 2 women on board. As Dr. Saab was saying, they need to talk. There should be a buddy kind of. We have various policies in place. Now, we call these 9 ships our culture labs. So we are doing a lot of research on it. And we have engaged a project with the Southern University of Denmark, where we had 4 researchers who traveled on board these ships, interacted with both women and men to see how this is working. Is it working well? Then they went on ships where there were just men to have a comparison. And we expect the report any day, and I've been told this will be put into public domain so that everybody can learn from this project that we have. Interestingly, in my office also, since we are talking about women, I have 51% women and 49% men. So
That's amazing, yeah.
I mean, it wasn't planned, it's coincidence or whatever, but on this forum, I thought I would talk about it.
I think you're setting the example that this is possible. Because
Yes.
initially when we talked about 10 years back, this was considered almost like an impossible thing. So credit goes to the good work to the management.
Absolutely. And strength comes with numbers. Now you're telling me cyberbullying, you have 50% women on board. Where is the bullying? I mean, it's
On
equal
those
now.
ships, yes. But
Yes.
don't forget that we have more and more girls who are
Yes.
maybe 1 or 2 only on board ship.
Yes.
So
For others, you have to have very strong policies. As Sir said, you can have regulations, but at the same time, you need continuous training, as Pankaj was talking about. For example, for us, we have very strong social media guidelines, anti-harassment and bullying policies. Basically, you come down to small examples, as to what you can post, what you can't post.
correct.
Let's say I'm having a birthday party and me and Sunitya are together, we are cutting a cake. If I have to post anything, I have to ask Suniti, can I post? And then that's where we have gone down to training.
The very basics of it, which
Yes.
is mostly forgotten.
Though I have myself learned, I'm old school. Earlier days, people used to take pictures and they used to say, can I tag you? I said, go ahead and tag me. I didn't even know what is tagging me at that time,
Yeah.
Now we've learned a lot about what it is, and we need to be mindful of what we post.
True. Thank you very much. I will move with Dr. Dhanya with this policy making only. Dr. Dhanya, can you highlight that how our existing cyber laws in India and how they address such issues?
I would say that we have adequate laws. We are not far behind or lagging behind on the laws. But it's basically about using the laws or regulations properly. Largely, I have seen that it is either being misused or not used at all. Even issues that come to our NGO, primarily, less than 6% of people are willing to go to the police stations.
That is so true.
The reporting system definitely is lesser. Now, see, I started my career with 8 issues coming to my organizations in a month. But now we are on 200 plus issues coming every week. The numbers are increasing. It doesn't mean that, we are living in a cybercrime or criminal world completely surrounded. But it's basically that, we are all exposed to this particular platform so much that we have not realized how much we are into the system already. Whether it's on your work side or on your personal side, the prime underlying rule everybody needs to think about is data hygiene. Just like your personal hygiene, data hygiene is very important. Compartmentalize every activity that you do online. Otherwise, yes, we have a problem. With AI also coming into picture, you don't even need somebody to come and send you, or long ago we needed to have a physical access to the system to infiltrate your system and to get some information out of you.
Correct.
But now we don't need to. Somebody is calling me, there is a call which comes on waiting, and I just need to merge both calls and my bank account vanishes if I have every financial data on the same gadget. So data hygiene is something which is very important. Now, the challenges that we face when we go around investigating issues that come to our office, one is technical and of course the other is the legal challenge. Technical challenge is basically because people who handle this technology are unaware about how to do it. They get into a panic mode, they delete everything possible from their end. So we need, see, every investigator, every person who looks into it needs a starting point. And most of the courts don't just accept screenshots today. They
Okay.
need to be produced. I'm talking about it on a global scenario. Most of the courts don't accept just a screenshot. In India, we need to submit evidence under Section 65B, which is a complicated process. And slightly, yes, it's high time even that got evolved, because it just means that somebody prepares the entire document, signs it under 65B, which can be manipulated again. All the attachments can be manipulated. If you ask me, on the technical front, it can be manipulated. So there has to be, since technology is evolving every time, we also, every forum or every stakeholder that comes with this particular cyberspace also needs to be evolved every microsecond, if you ask me. It's that fast that the technology is moving. But technology is a little more reliable, because once we have a start point, it has no two different answers. Whether it's the investigator, the legal system, or the culprit, the answer to the same technical question will be the same technical answer. So technology is a little more stabilized and standardized in that way, unlike the legal system. Now, as far as seafarers are concerned, another challenge that we find is the jurisdictional issue. Now, they are on sea. They face this issue. They call back or they report back to India. They have to come here because it's a criminal complaint.
Again, the
They
national
have
laws
to
and the
come.
international
National
laws.
laws are different. It depends on which country that particular jurisdiction or the particular seafarer is at that moment. So that challenge, I still have no idea. I don't know how to go about with it. Probably regulators will have to think about how to go about with the whole thing. But technically, yes. And one more point, sir, one of the panelists was saying, we should be on guarding ourselves that, something that we post, what if the boss sees? It's just not your boss. We have to train children young. Post only such things that you would like to see and hear about yourself and of yourself much later too. The policies of an organization come into place after you start working in the organization. But once you start working, what has happened during your younger days still has a
Remains,
footprint.
digital
It
footprints,
comes back, it surfaces back. During COVID, we have seen issues come up for litigation, come up for investigation, which has happened 7 years back, 12 years back. So it all surfaces. That's why I said once on internet, there's no, you're forever on internet, there's no deletion.
Coming to the point that now what I hear from you, it is very difficult to prove anyway. So in your experience, how many times, percentage-wise, roughly approximation, you have seen the victim getting the justice by the law?
No, I'll again take it in two different ways. Justice is very different from law.
Yeah.
So justice is something, if you ask me, it's a little far off, because see, if I'm hurt today, I need a recourse today. You don't get that anywhere in the world. It takes time. So you go through that mental agony, whatever is there, you go through that trauma or trial process or whatever. So there is something called time which is lost.
Yeah.
So I doubt if there could be any kind of a justice. Personally, in the last 24 years of my career, I have not been able to go back to even one of my clients and say, everything is fair, good, grounds are cleared, start from where you stopped. No. The only thing I could tell them is that forget what happened. It's an accident. Whatever has happened has happened. Start from now. That's it. You cannot go back and start from where it stopped.
So prevention is better than cure.
100%
Cure
prevention
is very difficult to
better
get.
than cure. 100% training is important. Educating every human being about what to do, how to do on this space is very, very, very important.
I understand, but at the same time, can we leave it to what you are talking about is the current scenario, that yes, this is how it is being done, but maybe we all should work into the future where cure can also happen. But with the law enforcement, because you are talking about on the land based, I would like to now come back to the maritime here, that when this kind of incidents happens, how the stakeholders from the industry, especially from the administration, we can actually at least get the cure first, and of course the prevention is very important.
I'll take the cue from Captain Pankaj Kumar. There's just two words: zero tolerance. That's how you start. And it starts from the first step for the maritime domain as in training. So in training, as was mentioned, you have a very extensive module which is basically briefing the individual about digital hygiene, about social media use, abuse, and instances that are perceived. Say, for instance, in terms of gender harassment or gender based discrimination, we have extended modules of how you prevent instances of sexual harassment. A similar kind of a session would have to be there in the training, and it has to be imbibed. So the second thing is all maritime crewing on board is essentially through recruitment, placement, service licenses. They need to, under the RPSL rules, have a dedicated engagement with the shipping companies on their manning policies. For instance, as was mentioned by Captain Pankaj, that it's a work in progress. However, the pull factor has to be created by ensuring from administration that these are the mandates which need to be complied with if you are signing on not just women, but in terms of their digital identity, digital personal data protection, and adherence both from the employee and the employer in terms of the digital ecosystem in which they are working. Use of social media, as I mentioned, would need cyber monitoring, and this would be essentially, as was mentioned here, the need of a counselor, because the first balm is to address the emotional stress generated out of such an instance. That needs a counseling interface. While you're doing the counseling interface, a very close documentation of such instances, and that should mandatorily include privacy. I may not be very comfortable if I have been cyber abused or cyber stalked in, in disclosing these details. So alongside the counseling, which again is a person-to-person private interaction with the employee institution, you will need to have this kind of a discretion where the person has the space to express oneself without fear of being lampooned or being spoken about. And this has to be done again by administrative mandate. The last part out here is the Chief Information Security Officer should essentially, because if you, as Madam had mentioned very pertinently, how many of you would like to actually visit a police station? Or on the lighter side, the Directorate General of Shipping? That this is how government is. We're very intimidating. You wouldn't want to come and interact. And I think that is for a reason. We keep things at arm's length. But it should be the role of the institutional Chief Information Security Officer to provide that protective layer and insulation to the individual who has gone through such an instance and follow it up legally to its logical conclusion, irrespective of whether the perpetrator is within national boundaries or otherwise. There is also what is not largely spoken about, but is there as a covert offensive methodology. For instance, when you do cyber audits, or when you look at cyber forensics, you look at the audit trail as to where, from which particular ID is basically the issue originating, or from a particular domain. Either you counter-attack, otherwise if you don't have a good cyber offensive, and this has to be covert, it can't be basically administration based. And that of course is just for 2 to 3% of very virulent or very malefic kind of repeat offenders who would need that. And here a parallel in what is the Whistleblowers Act. If somebody is giving specific information, that so-and-so individual or so-and-so entity is indulging in this kind of a nefarious activity, using the disguise or the garb of a cyber front. The Whistleblowers Act, protecting the identity of such an informant, should then get into the legal process of prosecuting and persecuting such maligning quarters. This is what I have. But as I mentioned, everyone in the room here is a stakeholder, and you have to basically build up the necessary pressure consistently over a period of time to have these aspects institutionalized. Unless it's institutionalized, you do not have that mandated, and it would only be efforts which are, some would be way ahead in terms of leaders and demonstrations. I was amazed that there are more women in the workforce than men. Now, this is more an exception than the rule. We need to basically fix that institutional framework that universally fits everyone and ensures compliance.
I think that's a very, very important point which you added. And to add and give a little bit more picture to that, the cases we have handled, we already talking about that women's seafarers participation is only 2%. So most of the employers sitting ashore, they face challenge in dealing the cases because it's first time for them. But what we have faced in this cyber harassment case, which we dealt, where we had to go to the police station also, they were the pictures. The very first handling of those cases is very, very important so that you curb the case there and then only. It is not getting circulated. So having those first-hand measures implemented in each employer's guidelines, policy framework, of course, it is not a common case, but there should be a standard guideline that when such incident occurs, what would be the first measure to deal with it? We found that all of us were not aware of that. It was completely lacking. And this is already 3 years or 4 years since that incident, but if I may ask, these guidelines are still might be lacking into the policy making from the employer's end or even the administration, because when such an incident happens, all the stakeholders are getting involved, which increases the risk of release of information which has to be confidential. And then dealing, like sir mentioned, the emotional impact, the traditional way of investigation is collecting the evidence, and it passes through many hands. So in our opinion, if it is through the mobile, maybe the mobile should get absorbed first by the master of the ship on board itself, so that it is not getting circulated further. But do we have that kind of policy and guidelines, or at least recommendations that how to deal with it? Yes, Dhanya, I can see that you are trying to
the
speak on
point
that.
is, when you go out with a complaint, the first thing that any organization or even the legal system asks you is to represent your gadget.
Yeah.
But the problem there is that your gadget may by itself have lot more vulnerabilities than the issue that you're bringing up there. That is one of the reasons why we cannot push our clients also to just go to the legal system as well.
It's a challenge itself.
It's a challenge
through
itself,
the system.
100%, yes.
But how to
That
deal
is,
with it?
No,
Yeah.
that is precisely why I said data hygiene is everybody's responsibility. It cannot be enforced on somebody. See, how can somebody come and tell me how many gadgets I should have? What all can I record? Unless it is an official gadget given by my company to me,
Yeah.
nobody can tell me what I should have in my personal gadget. So at least for that company's gadget to be clean, the company or the organizations, the employers can insist on that. That, this is the company provided gadget. You cannot do so and so, so and so, so and so things. Or easier, so you can only do so and so, so and so things, which makes life simpler. But on the personal front, this is very difficult to implement. Especially for a country like India, it is very difficult.
And that's why we are talking about the policy, because these cases in normal scenario being handled by the crime branch or investigators, but when it comes to the ships, it is first hand is the employers,
Absolutely.
then the administration.
Yes.
But we are running out of time, I can see that. So maybe we have to definitely close, but I would like to see if there are any questions from the audience. Then we would like to address before. when you are asking, please also mention who you are asking this question to. Can somebody please pass the mic?
But they also mentioned that start behaving like them and forget that you are a woman. So my question is, do I really have to forget my identity just to work on board? Why can't there be a respectful way or a boundary uh, so that we can coexist and work?
Very good question. Thank you.
I wanted to talk about it. I didn't know I'll get time. And fortunately, you asked that question. I've written it here. When I was in Malmo doing my master's in World Maritime University, there was one International Women Day where I happened to meet a captain who started as a rating in Sweden. So on their website, on the government website, which we have DG Shipping here, it was written Women 2.0. So I just happened to ask her, why 2.0? The answer was when they started this program in Sweden, they realized that the women who were being trained or those who were working on board were not behaving like normal women after some time. They were actually behaving like men. So they thought that we will not increase the number on board, but we'll work on this so that when they go on board, they remain women. So I'm sure you have the answer of your question. It is important to remain women, and it is also important to, believe in yourself that being women and working on board is okay. I mean, you don't have to start behaving like men.
Young lady, you don't have to worry about what you mentioned, that you may lose your identity as a woman. Your identity is so strongly enmeshed in your personality, you would never lose being a woman. But when you are at the work front, because you identify yourself with being a woman 24/7, also you would like to be identified as a woman at the workplace, which need to be reviewed and fine-tuned. A naval officer, an Air Force officer, or a pilot is pilot on the duty, not a good looking. I have plenty of people whom I know closely. Similarly, when you are working, you have to believe that you are just seafarer, not a woman with good looks, with good makeup requirement, with good hair, with good dress, so on and so forth. I'm not going to those details. So don't worry about it. You would never lose the identity of a woman, whatever role you may take it, and celebrate that you are part of a new culture globally where women and men together are working at equal empowerment and taking the society and the country and the world far ahead in the last 50 years. Celebrate yourself. Thank you.
Thank you so much. And
Suniti, if I may just add one
sure.
thing, it's a very nice question you asked, but I will put it very short. When we employ you for the rank, whether it is fourth engineer or chief engineer. In that contract, there is no mention of male and female. So the identity is an identity, and nothing needs to change there.
Thank you very much. In fact, that's what I was going to add here, that when I started my career, I think even in my flight tickets, it was mentioned Mr. Suniti Bala. They didn't know that, it's a woman. And on board ships, what we have been fighting for, that we should not be treated as a woman, but the rank, as rightly has been put by Mr. Deepu. So it is the rank, it is the chair which needs to be filled. It should not be the gender. But invariably, like Dr. Rajiv also mentioned, biologically we are women. We also feel women, and I'm a proud woman. And I think we all should be proud that way. But others also see that. So there is a very fine balance. But when it comes to the work, it should be the chair, it should be the rank. Thank you. Do we have more questions? I see a hand raised there.
Thank you. Myself,
representing the port sector. And I would like to ask the DG sir. Captain Pankaj Kumar has said, and my sister also said, but I believe that who are the superior than the he is the she. I think all of you will agree with it. You don't require to prove yourself, I am she. The second thing the madam has said, because I'm also closely working with the seafarers women from last many decades, madam said, as the right she has pointed out, that if she report the complaints, then she has come back to the India. So may I request DG sir that can we not make some legal frame that she can make even a report to the Indian embassy wherever she is? Because I have seen, and sir, I'm really, this is very, you said in beginning that so far there is no cyber bullying case reported. So the same thing happened with the sexual harassment cases also, because I think there are no sensitization. So they are not aware that this is a cyberbullying case. So I would like to request to the DG sir that we can make a more sensitization to the, especially the women seafarers regarding all these cases. And I'm sure that many cases will come up. I'm 100% sure. And the second thing regarding this legal frame, I think we need to change some, and DG can play a most important role in this. Thank you so much.
Yeah, I think very pertinent suggestions, ma'am. What we will do is, number one is I have been working for this for the last 2 years. Maybe in another 3 to 4 months, things will fall in place for the first ever 24/7 grievance redressal system. Now, this is for seafarers or otherwise maritime. So the first thing would be privacy of information. The second, which you mentioned, is if the instance is happening on board, say a foreign flag vessel is anyhow deemed foreign territory. So we take it up with the embassy to whatever extent we can. But let me assure you that the RPSL that has essentially ensured the sign-on contract, the company to which the RPSL has signed on the seafarer would also have to equally ensure that in these cases, due diligence is done to ensure no repeat and zero tolerance. This is how we will have to go ahead. Thank you for the suggestion.
Thank you. There is one more. I think we are already time up, but yes.
This question is to the DG Shipping. Yes, I am a maritime lawyer. My name is Jimmy John. I'm also the president of Vista India. So I just wanted to ask, like, what role do organizations like Vista play in balancing out the women's role in the maritime sector?
I'm being a maritime law domain specialist. You see, government institutionally has a lot of inertia. We're not very prone to change. And shipping is changing drastically. You're having technology, you're having gender inclusion, and you're having multiple things happening in crewing and manning. All of them in the panel will agree to me. Because Madam started by saying she was handling Orkut, and that's basically phased out, and now you have a plethora of social media platforms. Vista and yourself as a legal professional can give us that eagle's eye input as to what is necessitated in the policy framework and the implementation. Say, for instance, advisory on if a case is reported, the methodology of handling it, privacy, what should be the mandate. Or as was mentioned here, that they give detailed social media advisories. How do we standardize a social media advisory which fits across the industry? These are the things I would appeal to Vista to basically engage with. And you've got a lot of expertise, like ma'am has been there. So on the cyber forensics part, or on how you basically prosecute a cyber crime, specifically in this context, how do we do it? So that these are the things I think you would have to engage.
Thank you very much. We'll work on that.
10 seconds. I'll just add to what DG Saab said. The research says the best method in these cases is case studies. He has experience, you have experience. make case studies for the others to know and learn and improve on.
Consider that. Thank you.
Thank you very much. It was really, really very constructive discussion. And just to conclude what we have seen during the discussion, that definitely it's women seafarers who should be really mindful, careful what they are doing on their digital space. At the same time, how something of that sort which is not desirable happens, how to deal by the different stakeholders of the maritime industry, especially the employers, because they are the first ones, deal with it, the first handling of the cases, the guidelines, the recommendations, and as we discussed that in current scenario, the cure is very difficult. Prevention is there, but we should definitely target to have the cure also, so that the one who is doing should not feel free that, okay, nothing happens if I do. Because right now, if you see, this is the outcome of the discussion, that anyone does something, it is very difficult to prove and prosecute. That encourages them. So we need to have hardline policies, guidelines, recommendations, framework at all levels, so that this kind of mentality cannot exist anymore, that anyone can do anything on the digital space against someone. It's difficult to prove I'm free to move. So with that, I would like to definitely thank our all esteemed panelists for taking the time out and having such an insightful discussion. And hope we have more to do together in the future for the prevention and, of course, for the cure of cyberbullying and harassment. Thank you very much.
Thank you to the moderator and all our panelists. That was indeed a very enriching session. May I request all of you to stay back on stage for a bit, just so that we can present you with the tokens of appreciation. May I request our moderator, Ms. Suniti Bala, to please present the tokens of appreciation to all our esteemed panelists. All right, now we have had some truly enriching discussions this afternoon, and now it's time for a bit of a celebration. We are pleased to present the award of the Maritime Legal Leadership and Advocacy Award to Ms. Amsha Gengan, Advocate and President, Vista, South Africa. Many congratulations. Uh, Ms. Amsha, please may we request you to come on stage. And please may we invite Ms. Monica Nagelgaard, Consul General of Norway in Mumbai, to kindly do the honors, ma'am. I think you have to go a little in the middle. A little. Congratulations, Ms. Amsha. Thank you, Ms. Monica, for doing the honors. Okay, up next is our next fireside chat, which brings a global diplomatic lens to advancing women in maritime. Please join me in welcoming once again our moderator, Ms. Samsha Gengan, Advocate and President, Vista, South Africa, and Mr. Frederick Björk Abdul Magid, Trade and Export Specialist, Royal Norwegian Consulate General, Mumbai. Please may we welcome you on stage.
All right, everybody, we're ready to start the next session. So request you all to gather your juices, fresh juices from the back and samosas to fill your tummies, and come back to the front, please. Thank you. Yes? Isn't working? Okay, I'll get
Sanjam, Frederick and I didn't quite have this in mind when we decided to get up here. I'm just wondering if we could start. Ladies and gentlemen, please. Good afternoon, ladies and gentlemen, once again. This time round, I am delighted to have the Consul of Norway, Mr. Frederick Abdul Majid, with me this afternoon. Frederick, welcome.
Thank you very much for having me here.
And it's great to be at AnchorCon. As I've said, this is a new platform, part of the Maritime CEO's stable. So I'm looking forward to having some interesting conversations and hoping that our audience members, as well as myself, can get some insight as to what you are doing here in Mumbai. Frederick, I recall last year at Maritime CEO, the new Consul General of Mumbai mentioned she had just moved to the city. So I'm trying to figure out, how long have you been in the city?
So, yes, I've been here for a very long time. I was arrived just a week before Monica. So, I've been here for about a year. So.
Okay, all right, about a year then. And what's the verdict? The sights and sounds of Mumbai? Is it truly incredible, India?
No, I really enjoy it, and I just must say that it's kind of, I'm just being a bit, I'm honored to be here on stage and being part of Maritime CEO, and it's kind of a bit intimidating as well, being almost 50 man and going to talking about women's empowerment. But yeah, Mumbai, I like Mumbai. It's the hustle and bustle of Mumbai is great. There's a plethora of restaurants to choose from.
Okay, so I'm definitely going to be talking to Frederick after this. I need some recommendations for tomorrow. Frederick, you know, when we talk about advancing women and gender equality and female empowerment, it's more than a job. So you're not only here because you're part of the Consulate General of Norway. All of us who do this, we're fueled by a passion. There's something in our DNA that hardwires us to make the time to further these conversations. For me, it was having a father who didn't discriminate between his daughters and his sons. That's my personal context. I was always raised to believe I could do anything. So what fuels you? Where's your passion for advancing women in the sector coming from? What's your story?
Yeah, so I guess I was an adult before I realized that was actually an issue, because I grew up with 3 older sisters. They grew up believing they could do whatever they wanted, and they've done it whatever they wanted. They're all highly, they're well educated, master's degrees, and doing and leading positions in all their professions. And so I was well into my 20s before I realized that this isn't the case in all the world, and it's not even the case in all of Norway in all industries. So so to me, it's something worth fighting for, that it should be a natural thing, right?
That's awesome. So we've got the right man for the job. He was raised with 3 sisters, so he's the right guy, definitely. Frederick, I would imagine that, you know, one of the primary goals of the Consul General is supporting, obviously, Norwegian commercial interests in the region. And a significant portion of those interests would be related to the maritime sector and the blue economy. Would you say that is fair? And would you share a bit of insights as to, just on the commercial front, what it is that the Consul General supports and advances?
Yeah, so you're right. It's trade promotion is a very big part of the presence of the Consulate General in Mumbai, and and maritime is one of the biggest industries and sectors for Norway. So I would say that perhaps 80% of my time is spent on work promotion, at least. No, trade promotion, not work promotion, but trade promotion. But we do cover Maharashtra, Goa, and Gujarat, so naturally the maritime sector is big. But we do also cover energy and circular economy as part of the India strategy. So also big sectors, yeah.
Okay. And in 2022, I remember that the Norwegian consulate was a platinum partner for Maritime CEO. Can you give us some insights? 22, 3 years down the line. Can you share with us the collaboration and the initiatives that have been forwarded in the sector here in Mumbai and in those other states that you've mentioned?
So this is kind of ingrained in the policies of Norway, that gender equality and everything. So and the long-standing partnership with Maritime CEO is just strengthened this. And of course, this wouldn't happen without Sanjam. Her enthusiasm and engagement. This is important, right? But it's also important for Norway in general that gender equality creates. It's not just fair, but it also makes sense business-wise. So it's ingrained in what we talk about when we do policy, and even it's part of Chapter 11 in the TEPA agreement, the trade agreement between the EFTA and India. So and it just made sense to collaborate with the Maritime CEO on this and keep working on this. I would like to say that we were here from the start, but I am not sure if we actually were sponsors here in the beginning, but for many, many years at least. Okay.
Right at the start, okay.
Yeah, very good.
As my recollection serves me, that is correct. So Frederick, I mean, that's on a broad level, the collaboration and the framework for which the Norwegian Consulate General bases what they do and their program for advancing women. But practically, can you tell us and maybe share with the audience, practically, what are the tangibles that we can see that stem from this collaboration? I mean, one of them is us being here and you being here and the Consulate General being here. That is the active participation. So it's not a talk shop. We see the participation. But, I also don't have the foresight of living in India and in Mumbai. So can you share for people like me, what's the practical outcomes of this collaboration?
Well, so as I mentioned, it's not just fair, and because it actually creates business, it creates value, and yeah, we see this today. We have Norwegian companies present here at Maritime CEO. Gard is here. We had Kongsberg at yesterday. Birgitte Lioden was a conference here, and it just makes sense. And what we're actually the funding we use to support this is actually business promotion funds, so it makes sense business-wise. In addition, it's ethically the correct thing to do.
Right.
But it's hard to measure in the short run. You have initiatives. You see a slow increase that in the maritime sector, that there might be more and more women, but it's slow in overall. But some sectors there's more. I guess in law it's quite balanced, or even tipped over, that there might be even more female lawyers than male. But as seafarers, it's still very, very low, and
it's
even
incremental.
in Norway.
It's incremental, though.
Yeah.
It's increasing, but it's still very low. And I think I just want to pick up on the point that you mentioned about the Norwegian companies that were here. So whatever your efforts are and your program to advance women empowerment in the sector, you're not doing it alone. You are taking other people on the journey. You have support from your commercial organizations, which is great, because normally these programs and the framework is pushed out from a government perspective. And it's very difficult to convince corporates as to why this is the ethical or the right thing to do. So maybe just a little bit more on how your partners come to support you as a consulate in this journey.
Sure. And of course, we do have this maritime strategy that was released in 2023, I guess. And actually this year, in March of this year, there was also a collaboration declaration to actually get the policy into action. So a lot of companies have signed up to this declaration so that there's more tangible efforts. They are measured, they have to come together twice a year at the minimum to discuss their progress. So, and there are other initiatives that we did discuss earlier today about, like the Wista 40 by 30.
Yes.
Which, although it's not a government project, but it's something that, of course, the government looks at. It's positive because it creates a peer pressure that everyone is working against tangible goals in the short term. It's 5 years.
Yeah, and with 40 by 30, which is a pledge by Wista Norway, it's a question of watching what your competitors do.
Yeah.
You hope that that will fuel other organizations to follow through. Frederick, the gender strategy or the equality strategy for the maritime sector, which your Minister of Trade and Industry published, now that strategy has 4 key pillars. Would you mind sharing some of your perspectives on those 4 pillars and how it is executed in practice?
Yeah, I have to look at my notes a little bit because it's all in Norwegian, so now it's translated to English, so make sure they have the right terms because they translate quite similar. So
it's literal, it's a literal translation.
Yeah, I don't know if it's literal or not, but it's similar at least. But recruitment and role models is important, right? You need, and that's what I've seen today. It's so great to see at India Maritime Week and yesterday at the Maritime CEO as well that there are so many students that are brought in to see the opportunities in the maritime sector. You need to know that it's happening there. And of course, yesterday you also had the opportunity for the female sailors and cadets to meet these successful role models, easy access to talk to them.
Absolutely.
Yeah, so that's only point 1, role models.
Okay, all right. So that's the first pillar of that strategy, okay?
And then an inclusive working environment for all. I've talked a little bit about this with our interns, and it's just the maritime sector is a business that was created by men for men. So I think many of the work environment has to change to adapt to actually be suitable for both women and men, and not make the women adapt to the male work environment.
So I always say that, and Monica is here, and there's a couple of lawyers in the room. It's like when lawyers go to board meetings or to court, we are told to only dress up in black and white. And even in the boardrooms, you find all the female lawyers, nobody wants, and here I am as proof, wearing black and white. Nobody wants to wear color because we want to conform. We don't want anybody to be distracted by your pink dress in a board meeting, right? Yeah. So I think it's about finding, and the other panel, that was a little bit of a contentious discussion before we came on. That was the thing. You have to find the balance.
Yeah.
You want to own your individuality. You want equality, but we also want the time to come where we stop saying a female shipping lawyer, a female chief engineer. We should reach the stage where we can just say a chief engineer, advocate. We shouldn't have to put a female because it should become status quo.
Yeah.
Okay, so that's important.
Yeah. No, absolutely, and I did listen into the last panel discussion, and that's the third pillar. It's
Okay.
harassment, right? So no,
We
a
didn't,
life
we
free of
didn't plan
harassment.
this, by the way. We didn't ask those guys before us to say anything.
No. So, and as you see on the picture behind me, I actually like to wear color a lot. So, but today I'm wearing
Pink.
pink and
Frederick's
blue.
wearing pink. Okay. So are those the two interns from your office?
Yes, that's Kaya
And
Philippa.
Monica. So now I see you've got another three
Yeah.
sisters in your life.
Yeah, yeah.
Oh, and
And
another.
Shubhra, yeah.
Okay, there's four. Okay, well done, ladies. You all got him. He's on the right track.
Yeah. So, and then in this translation, there are four pillars, and
Yes.
but 2 and 4 translates kind of to the same thing. It's an inclusive work environment and also a tailored workplace. So it's very similar.
Frederick, they can't see it, but we can. You see the big red screen there?
Yeah.
So I'm going to ask you the last question. What do you think we will be saying about advancing women in maritime in 5 years, right here in Mumbai? What will the conversation be?
So I want to focus on perhaps what I want to hear, maybe not what will happen, but
Okay, I'll allow you that. I'll allow you that.
No, and I listened yesterday as well, and we talked about there's an incremental growth in the number of women. I would like to hear that in 5 years there's an exponential growth. So that we actually see that all of these measures and talks and everything really increase the amount of women in the maritime industry. And we just have to keep on working and creating an environment that people can jump on this wave that is slowly building. And it's like the wave on the stadium, right? It starts slow and then it builds up, and it creates a lot of fuss. So, and eventually it calms down and everything's normal. And I think when it calms down, everything is equal. You can be an engineer. There's no female. There's no male.
I think he said it best. I'm going to allow him the last word. Exponential growth in 5 years. That's what we're going to say.
Yeah.
Ladies and gentlemen, I want to thank the organizers of Maritime CEO for all their hard work and for inviting me to moderate this fireside chat. Frederick, thank you, and thank you to your team for their support. And thank you, Monica, as well. And I think we all appreciate the support, and we all are committed. It goes a lot beyond our day job. It's a passion to do this every day and to believe that you will create the exponential growth. Thank you very much.
Thank you, Amsha and Frederick. That was really inspiring. Please, can we request you to stay back for a bit? We'll just present you the tokens of appreciation. Thank you so much. Up next, we have a session that addresses one of the most complex and human sides of maritime law, the criminalization of seafarers. Please join me in welcoming on stage our moderator, Ms. Sapurva Mehta, partner, A&B Legal, and our distinguished speakers, Mr. Hari Narayan, partner and maritime lawyer, United Maritime Law Chambers, India, and Ms. Kate Manley, partner, Preston Turnbull, LLP, London.
Hi everyone. I hope everybody's feeling refreshed. I'm Advocate Apurva Mehta Ponerkar. I'm partner with ANB Legal. And our discussion today is going to be on the burning topic of criminalization of seafarers. And my esteemed panel here is Mr. Hari Narayan. He's a partner with United Maritime Law Chambers based out of Kerala. And Catherine Badley, who is a partner with Preston Turnbull. She has come all the way from London for us, and we will all be discussing the cases on criminalization and the guidelines that have come into force, which talk about various aspects of how this sensitive issue has to be handled. So everyone is aware that shipping is not without incidents, and fault or human error is always the focal point of such incidents. Presumption of fault is more often than not always presumed, and unless you prove it otherwise. Unfortunately, for seafarers, it takes the color of criminal prosecution and harsh penalties. And that is where the topic of criminalization of seafarers and their treatment during these criminal prosecutions takes the forefront. I think what more often than not happens is that people, they tend to forget the difference between actual fault of these seafarers, which has to be proved only through a long drawn trial. And meantime, the seafarers have to face rigors of the criminal justice system of the country in which they're undergoing such a situation. So everybody knows nobody wants to meet or have a taste of the police machinery of any state. And we lose sight of the fact that these masters or crew members are just professionals who are doing their daily jobs and unfortunately have to undergo a lot of stress when it comes to criminal prosecution, and they may not be mentally or physically be able to handle this stress. We have a lot of laws already in place, including our Indian Penal Code that talks about criminalization and imposes penalties on seafarers. But this has been there for ages. But how it is executed is something that has been taking center stage for quite some time now. I'll hand over the mic to Kate now, and for her to share the cases that she's handled and her firm has handled, and also how English law, what penalties and what offenses are available under English law for seafarers and the protection as well.
Perfect, thanks very much for that. For those of you that were in the talk earlier, I set out my background. I'm a lawyer, dry shipping lawyer predominantly, at law firm Preston Turnbull. We're London-based, just deal in shipping litigation matters. But whilst my background is dry shipping, I've got some brilliant colleagues on the wet shipping side, and they're regularly instructed on cases that arise out of maritime incidents. We've also got a number of in-house master mariners, and those are our colleagues who, when we're instructed on a collision case, say they're first on a plane, out helping clients, evidence gathering, investigating, if they're acting for owners, taking early witness statements when everything's fresh in the mind. So I've spoken to them about various cases that the firm's handling. By way of example, one involves an incident in Taiwan. The vessel got into trouble outside port. It started listing, it wasn't clear why, and taking on water. So the master sought refuge in the nearest port, but was denied access, presumably because there was concerns that the vessel would sink and cause an obstruction. Salvors were appointed, but they weren't allowed to go and attend the vessel. And as a consequence, she subsequently sank. All the crew were arrested. And it took 3 months to persuade the local authorities that a number of this crew could not have had any fault at all. So the likes of the cook was detained for 3 months. And even when the majority of the crew were allowed to go home, it was a year before the master and the other senior officers were allowed to leave. Obviously, that's an incident that occurred outside the UK, but incidents do occur in UK territorial waters as well. And there are offences in place that are aimed at seafarers specifically. And this isn't new. They're currently consolidated into Merchant Shipping Act of 1995, but that is a consolidation of the previous act from the 19th century, and that itself kind of sweeps up offences that were already in place. So criminalisation of seafarers isn't new. The section 58 of that act provides that it's an offence that for certain acts or omissions to preserve that arise from conduct which endangers ships, structures, or individuals. So where the seafarer hasn't acted or has done an act and there is a loss or there's likely to be a loss, and the act was deliberate, or it was a breach of duty or a neglect of duty, or they were under the influence of drugs or alcohol, that's an offence. And that can carry up to 2 years in prison, there's a fine, or you may face both. But if you're in the UK, then you are subject to all UK laws and all UK criminal laws. So you may be familiar with the collision earlier this year of the Salong and the Stena Immaculate that happened off the northeast coast of the UK. That happened on the 10th of March this year. Unfortunately, during the collision, a seafarer was missing. He's presumed dead from the Salong, and the Salong captain, 4 days later, was charged with gross negligence manslaughter. So that's an offence that carries a maximum imprisonment life, although the usual is kind of 1 to 18 years. The trial for that master is due to take place in the new year, and we wait to see what happens.
Thank you, Kate. India has also seen a fair share of maritime casualties and thereafter criminal prosecution of the master, crew, and of course the owners. I'll let Hari speak about Indian laws and his experience in handling criminal prosecution of seafarers.
Hi, Apurva. Good evening. As you all know, criminalization can happen for two reasons. One, when the seafarer does something intentionally. That is something which we cannot do anything about, and the law will take its own course. The second is when a maritime casualty occurs or an environmental disaster happens. So even the crew, without knowing anything about the incident, they are implicated in a criminal action. I will give you an example of a case which we conducted a few years back. You can see the trauma that is faced by the seafarer in pursuing litigation in India. This was a case which went all the way up to Supreme Court, and then the entire crew had to face trial for almost 4 years in this country. This vessel was intercepted by the Coast Guard near to Tuticorin port on getting information that the vessel was carrying arms. Immediately the vessel was seized and all the crew members, including 25 foreign crew, were arrested and charged for the offense under the Arms Act and also for the Essential Commodities Act. Fortunately, all the crew members were released on bail, and then they had to face the trial. This vessel was actually a floating armory or a anti-piracy vessel, which is involved in anti-piracy operations. So how they operate is, they have two vessels, one on point A and one on point B. And those merchant vessels which require armed guards, security guards to be deployed on their vessel, will take the guards from point A, and once the vessel passes through the high-risk area, they will disembark at point B. So this is how they do the business. And most of the time, the vessel was in international waters. It so happened that the vessel ran short of fuel, and it started drifting towards the shore, and it touched the territorial waters. So that is when the Coast Guard intercepted and arrested all the crew for holding arms. This was an American vessel of course, flagged. The owners are Americans. The vessel was flagged with Sierra Leone. So in America, there is no need to have a license to hold arms. So they were carrying these arms and engaged in the business of combating piracy. So the first argument that we raised for the owners as well as the crew was that the act of the vessel and the crew was intended to fight piracy, and which is protected under Article 100 of UNCLOS, which says that the state has to take necessary steps to combat piracy. And since the vessel was in a distressed condition, it coming to the territorial waters was also something which is protected under UNCLOS. You all know Article 17 permits innocent passage. So if a vessel is stopped as part of its passage, that is also saved under UNCLOS. So both these points were argued before the Madras High Court, which found in favor of us and quashed the entire charge raised against the crew members. But the state government took up this matter in appeal to the Supreme Court, and Supreme Court reversed the finding of the High Court, holding that these are all questions of fact. Whether you're holding arms with some intention to fight against the nation or something is something that can be realized only after going through a trial. And on that basis, the Madras High Court judgment was reversed and it was sent back to the trial court for fresh trial. And then the crew had to wait for another 3 years, and ultimately they were all released, holding that no charge will lie against them. So what I tried to point out is, even the highest court of the country was not able to understand the concept of fighting against piracy. Just because of the fact that charges were framed under the Arms Act and the crew were having arms on board the vessel, they thought that is something which has to be established by undergoing a full-fledged trial. So this is a trauma which the crew can face, and in this 4 years, most of the foreign crew members lost their job. To a certain point, the owners were supporting them, but beyond the stage, they also stopped providing any kind of assistance, and therefore, they were jobless, and by the time they reached back to their respective countries, they were finding it extremely difficult to manage their lives. So these are situations which crew can face even without their knowledge.
Thank you, Hari. So this just shows the domestic nature of all these criminal prosecutions, and it all depends upon the law of the country where the seafarers facing such a charge. There was a case recently which I handled where the seafarer he was stopped at the airport because he was carrying air gun pellets, and he wasn't aware that that is prohibited under Chinese law. And that led to a lot of detention, and of course the club and the owners are assisting him. But the struggle that a seafarer has to go through because of the unknowns of a foreign legal system, and especially the criminal justice system, is something that requires a lot of attention. There is also an issue of the media or the criminal prosecution not understanding the complex mechanics of the shipping industry. It's not just the crew, not just the master who is the decision-making authority. At times, machinery, the equipment might abandon the crew. There might be other management and ownership issues that can lead to an incident, and which is more often than not overlooked. At least in the beginning, it takes time to present evidence and take the prosecution through the entire gamut of evidence that they may have. I'll let Kate share her experience on this and the cases that she has handled.
Yeah, so as Apurva, I think, has said both in the introduction and there, maritime incidents, seldom are caused by one factor. They tend to be caused by a combination of factors or a chain of events. If you take one of those events away, perhaps the incident wouldn't have happened, or it wouldn't have happened to the same severity. And there is usually a human element somewhere along the way, often right at the end. It might be deliberate, but it's often an error, sometimes a negligent error, sometimes a criminally negligent error. But I think the focus of this is those cases and the perception that there's a risk of overemphasizing the human elements at the expense of examining the range of causes that caused an incident and the learnings that the industry can take from that. So firstly, why does this happen? Again, as Apurva has said, there's a real media spotlight when these incidents happen. And firstly, we all know that investigations into these causes can take a very long time. So you might not get the full picture for a year or even two if the matter ends up in litigation, you have experts, until well after the event and the spotlight has moved on. In the meantime, and sometimes with good reason, it is easier and it's also more impactful for the local authorities to take action against the crew. They're in the jurisdiction. As I set out before, if you're in the UK, there are specific offences aimed at seafarers that they may well be in breach of. And on the flip side of that, it is harder to pursue an owner for a criminal offence. Now, in the UK, we have the corporate manslaughter charge, and that actually enables offences to be brought, or charges to be brought against individuals who are in control of companies that have corporate failings that have led to death. However, if the company is outside the jurisdiction, there's an issue of enforcement, and there's also an issue that the industry ownership and control of vessels is quite opaque, and it's quite hard for people outside the industry to understand. And I think, lastly, there is an element of human nature here. We quite like a simple explanation when these media events kind of kick off, and we quite like having someone to blame. And I think it'd be remiss if we didn't talk about the Costa Concordia, which is, I think, the event that brought this kind of to everyone's attention. In case you don't recall, this was a case of a grounding of a large cruise ship off the coast of Italy during nighttime. The immediate cause was that the vessel did a sail-by salute of a small Italian island, actually because the maitre d' came from that island. They didn't have charts, it was a deviation, or they didn't have charts in sufficient detail to be that close to shore. But this was kind of a standard procedure, and it was something that it is reported that the owners quite encouraged. Now, it caused the loss of the vessel, 4,000 people had to be evacuated, and very sadly, 32 people died. The master did not cover himself in glory. No one is suggesting that he wasn't at fault during this incident. And what he's most famous for were his actions after the event. He appears to have gone into shock. He got changed, left the vessel, and refused to get back on. Spent the evening with a priest, inconsolable. So not how anybody would want to react in that situation. But he wasn't actually the only crew member that faced criminal prosecution. 5 others did. They were all allowed to plea bargain, and so on a technicality, they never served any jail time. The owner, after the investigation, which obviously took some time, was fined. They were fined €1 million, and I'm sure you've all got a view on whether that's a large amount of money or not for an incident of this nature, like relative to the cost of the ship. The master ended up being in jail and still in jail for 16 years. So it was this incident that caused some disquiet as to whether or not seafarers were perhaps taking the blame for everyone. And again, I say in this case, the master virtually put his hand up and said, I will take the blame for all sins, because his actions were quite unique. So why does this matter? Well, from a crew's perspective, it obviously matters from a personal point of view. There's huge professional, potentially financial and emotional ramifications and impacts if you're caught up in this kind of incident. Depending where it happens in the world, you're also at risk of not having a fair trial. It really depends on the jurisdiction. We would hope with the case of the Salon, that's a Russian master who's facing criminal prosecutions in England. I think it is, there are good grounds to say he will probably have a fair trial. However, if the situation was reversed and it was an English master and this had happened in Russia, there would definitely be concerns that perhaps that master was not going to get a fair trial. And as a consequence, there are reports that junior crew are actually reluctant to take on more senior roles because of the perceived responsibility, personal responsibility you could have if you're involved in an incident of this nature. And it also, I think, adds to a culture where people are unwilling to put their hand up and say if they see something going wrong. There was a case in 2021 called the UBC Savannah, and that was a vessel that was carrying out cargo operations in Mexico. The master became concerned that drugs might be being loaded on board. He alerted the authorities, they came and investigated, and he was correct. We need to call it a day. I will be very quick. He was detained for 18 months, which hardly encourages the type of hand-in-the-air culture that you want.
That just shows, the blame game theory that goes on after an incident. I think MV Dali was a very recent case which showed the same pattern. Quickly, I'll just take a minute and I'll hand over the mic to Hari to speak about the jurisdictional aspect of criminal prosecution.
I think Enrica Lexi is a classic case which dealt with the issue of jurisdiction. The incident occurred 20 nautical miles from the coastline, and therefore the flag state raised the argument that the coastal state does not have jurisdiction to proceed against the mariners who were involved in the incident. The matter was taken up before the International Tribunal of Law of the Sea, and the tribunal passed an order that until the jurisdictional issue is resolved, the criminal prosecution should be kept in abeyance. But ultimately, the matter got settled and the victims were paid compensation by the Italian government. But such an action was possible because of the strong efforts put in by the flag state. So flag states plays a very important role when it comes to criminalization of seafarers. If it is a flag of convenience state, there isn't much they can do about it or to save the seafarers. But since Italy was involved in it, they were able to repatriate the two mariners when the trial was going on in the country and then ultimately settle the matter. So as far as jurisdiction is concerned, any incident which all of you know, which happened in high seas, it is only the flag state which has got jurisdiction and not the coastal states. And I think in India, in contrast to the provisions of UNCLOS, we have the Maritime Zones Act, by which the penal jurisdiction of the country is extended up to 200 nautical miles. So that is how the Indian authorities took action against these mariners.
Thank you, Hari. This was quite a popular case in, I think, 2013 or so. But I think what comes out of the panel discussion is that due process of law obviously always has to be followed. And there has to be accountability of the owners, the crew, and I think a lot of cooperation from the owners as well is required to ensure that the criminalization aspect of seafarers is not really taken down the wrong path, and there is fair treatment given to them as per the legal process of the country where they are facing such charges. On this note, I'll end the session, and thank you so much for listening in.
Thank you for the deeply informative and empathetic session. May I invite you to stay back briefly, just so that we can present you the tokens of appreciation, please? Thank you so much. Up next, we have a session which explores a vital intersection of industry, law, and sustainability, the evolving frameworks in the ship recycling, shipbuilding, and repair. Please welcome on stage our moderator, Ms. Jacqueline Zalaba, partner, Campbell Johnston Clark, London, and our expert panelists, Mr. Paul Aston, certified English lawyer, CEDR accredited mediator, and FCIARB arbitrator, Asia Legal LLC, Singapore, Mr. Arjun Mittal, counsel, Hemsman LLC, Singapore, Mr. Rohit Agarwal, CEO, Guideship Consulting, India, and Ms. Ruchika Nair, Group Head Legal, JM Bakshi, India.
Can everybody hear me okay? Yes. Okay. Good evening. We are almost at the graveyard shift. There's somebody coming just after us. I believe there's a member or two on the next panel that is due to catch a flight out of Mumbai. So we're going to do our best to shorten this a little for them. Right, so we're here today with this panel to talk a little about ship recycling, shipbuilding and repair. A world without the shipping industry would look very different, wouldn't it? The effects would be felt immediately. Countries that rely upon imports for essentials, whether it's food, medicine, energy, machinery, they would face shortages within weeks. Export-dependent economies would crash. In other words, the global economy, as we know it, would almost certainly enter depression. So, if the world, at least as we know it, cannot survive without shipping, then we cannot survive without two important industries that sustain shipping. Firstly, shipbuilding to create the ships, and secondly, ship recycling to safely recycle the ships. A ship's life, as we know, will begin with its construction, and it generally ends about 25 to 30 years later. By that time, the ship's destiny is to be recycled because she'll become too expensive to operate and may well put human safety and the environment at risk. Now, we have here today 4 colleagues to help look at these 2 issues, and I'm going to ask them to introduce themselves. Paul.
Hi. Well, by that definition, I've been recycled twice, and I'm on my 3rd birth, so to speak. It says behind me, certified English lawyer. I am actually an English solicitor, but it's meant to read certified foreign lawyer because I practice in Singapore, and I'm a consultant with the excellent Singapore firm Asia Legal, having spent 40 years mainly as a partner at Holman, Fenwick and Willan. I had the distinction of not only starting life in their London office, but I was able to work in the Hong Kong office, and then I was asked to found the Singapore office, and I was in that office on and off for about 24 years. And I had 4 years in Shanghai, so you can call me a nomad solicitor in a way. I was also born outside of the UK, so I've spent most of my life actually outside the UK. My started life as a typical shipping lawyer, but in the 90s I was lucky enough to get into the first generation of FPSOs. That led me into an interest in offshore construction and resource development. And of course, when I went to China in 2008, the world was collapsing except for China, where shipbuilding was a massive thing, and offshore development, rigs, flotels, that sort of thing. So I've been very fortunate to go into a lot of shipyards, ship repair yards, conversion yards, terminals, and travel around the world at other people's expense. I am based in Singapore. Singapore is my home. I do some arbitration and mediation. I'm a qualified CEDA mediator and an arbitrator, as are so many others. Thank you very much. And by the way, it's a pleasure to be here. I'm amazed that so many of you are here at Dead Man's Slot, and thank you.
Thanks, Paul. Ruchika.
Hi, good evening to everybody. I'm Ruchika Nair. I'm the group head legal for the J.M. Bakshi Group. So J.M. Bakshi is the 108-year-old business conglomerate which is involved in the business of shipping, ports, logistics, and marine services. And I have approximately 3 decades of legal experience working in various industries, including infrastructure, energy, real estate, and now working with J.M. Bakshi in ports and logistics. And very happy to be part of this panel. Thank you.
Thank you. Rohit?
Good evening to all. Good evening to all. I am Rohit Agrawal. I am the CEO of Guideship Consulting Services. I have been associated with the ship recycling industry for more than 2 decades. I was pursuing my master's in Mumbai, and during 2008, after the Lehman collapse, I found I found myself in the ship recycling sector, because this sector is inversely proportionate to what the global economics are. If the world economics do well, the recycling sector doesn't perform well. So in 2008, there was a boom in the ship recycling, and I started my journey in Darukhana in Mumbai, where recycling was done. And now I'm working with the ship recycling. I was working with the ship recycling yards in development and compliance with ISO standards and HKC compliance. We also provide assistance to the ship owners in vetting of the yards and post-delivery, the compliance and compliance monitoring on behalf of the ship owners. And we work with the authorities as well in policy formation. So this is just a brief of what I am doing, and I am advocating for green recycling in the sector. Thank you very much.
Arjun?
Hello. Hi, everybody. I'm Arjun. I'm a counsel at Helmsman Law in Singapore. It's a law firm which is specialized in shipping and commodities. And over the years, it's now a full-service law firm doing also corporate banking, finance, and commercial disputes. Before my time at Helmsman, I was the legal counsel at GMS in Dubai. They are the world's largest cash buyers of ships and offshore assets for recycling. So we did a lot of sale purchase transaction and for recycling ships, including all the environmental and regulatory issues. And before that, I was a lawyer at Bose & Mitra in India, which is a shipping and trade law firm. I'm quite happy to be here and look forward to an interesting discussion with the panel.
Thank you, Arjun. Okay, let's jump into ship recycling, one of 2 topics that we're going to be looking at. Ship recycling statistics from the IMO show that about 85% of all ship recycling by gross tonnage is conducted in Asia. That's Bangladesh, India, and Pakistan. Global ship recycling volumes are predicted to double by 2028 and quadruple by 2033. So what that means is it's important that we take steps now to ensure that the growth in demand for ship recycling services is met by ship recycling yards with responsible practices. And it's been the lack of responsible ship recycling practices and the unnecessary risks, including loss of life, which has placed the ship recycling industry under the spotlight and considerable scrutiny. Now, beginning with you, Rohit, particularly given your background, whilst the Hong Kong Convention was adopted in May 2009, it's only been recently, in June, earlier this year, a few months ago, that it's entered into force. Now, its aim is to ensure that ships, at the end of their service lives, are recycled safely without unnecessary risks to human health, human life, or indeed the environment. Do you think that the Hong Kong Convention is going to meet this objective, or will we just see incremental change?
Well, we have seen a lot of change in the ship recycling. And I would like to say, like, as you rightly mentioned, that the convention was drafted in 2009 and it came into force in 2025. So it took 16 years. 16, it is long duration. But leaving the timeline apart, it took time, and the gestation period was good enough for the ship recyclers to adopt to this international convention, adopt slowly, steadily, and be compliant with the recycling, with the international convention. So India, I remember this process had begun in 2013 onwards, and in 2015, there was first set of 4 ship recycling yards which received the statement of compliance from class NK. And getting it from a Japanese company, a statement of compliance, is in itself an achievement. So from 2015 to 2025, it was 10 years, and all the yards voluntarily had adopted to ship recycling, and it was nothing in haste, slowly, steadily, small steps, and the compliance was met. So we don't say that this is just like any other convention which was ratified by unanimity, but it took time. People understood it because the recyclers or the ship recycling workers, they had to adopt to a lot of changes. It is not just on documents, on paper, but the behavior-based change. And it is very difficult to adopt to this macro scenario. So it took time. So, and I see, and we have seen, and we have been hearing that this was a very positive thing which happened in the industry. So the industry, what it was named for, today everyone is talking about it. This is the need of the hour, and also this industry has found itself in the mainstream maritime industry, which earlier was not so. It was not recognized in the maritime industry, but now it is an integral part of the maritime chain.
Thank you. Arjun, would you like to add anything to that?
Yeah, I mean, you said it correctly that it was recycling. Earlier used to be called scrapping, was always seen like a side product, and now recycling. And that transition, even from the word scrapping to recycling, was such a ideological change to make people realize that at the end of the day, a recycled ship, you're recycling 98, 99% of the vessel. It's not scrapping, it's not. In India, Bangladesh especially, there's so much requirement for recycled steel for infrastructure projects. Jacqueline, you mentioned the issue of capacity, right? That's such an important thing when determining recycling, right? There's this Western bias that Asian subcontinent yards have had to face for so long about, oh, European yards are good, Asian yards are bad. But at the end of the day, HKC is the only convention which is really, that holds the field for recycling because it covers cradle to grave. It covers everything right from every vessel that is built throughout its lifestyle, through its lifetime must have inventory of hazardous material on board, right from ship recycling plans, right from covering labor issues. By comparison, the European regulations will probably come to it later. They only concerned with when is it a waste and how are you moving it, not actually about how the process of you recycling and everything is. So the HKC is quite important, and recycling is, especially in the subcontinent, is the only place which can meet the capacity, like you said, right? There's 1,000 vessels going for recycling every year, out of which 900 are done in the subcontinent. So even if you were to consider that, okay, the subcontinent is not according to European standards, Europe just doesn't have the capacity. So,
Sorry, I was just going to jump back to you actually.
And just to add,
Yes.
that the Indian government is also very proactive and in doubling the ship recycling capacity from 4.5 million to 9 million tons. So we are also gearing up for the upcoming demand in ship recycling.
I'm going to jump back to you, Rohit, again, a question about Alang. And I don't think there's anybody on the panel. I'm happy to be corrected, unless it's by my husband. But I think you're the only panel member that has the most experience with Alang. So as we know, Alang is home to one of the world's largest ship recycling yards. It employs thousands of workers and supplies large volumes of recycled steel. Now, historically, it's faced quite a bit of heat, a bit of criticism over working conditions and environmental impacts. Now, given your experience working specifically with Alang yards, what improvements have you observed over the years, and what are some of the challenges that remain with Alang working towards compliance with the Hong Kong Convention?
So thanks, Jacqueline. So I think the regulations which are there are under the Hong Kong conventions and all are, very path-breaking in the sense it provides for a safe and sustainable way in which the ship recycling can be done. But still, I think the main challenges, if you call about, is that the beaching method by which the ships are recycled, I think that is the main concern for the NGOs and environmentalists, where they say that that is the process by which a lot of waste is put into the soil, to the environment, and to the water waste. So that is the main concerns where I think maybe the government should also look at, and also the ship recyclers should maybe try some new methods where instead of doing the initial recycling at the beach level, they could do it like kind of a dry dock kind of a thing where earlier it could have been done.
Thank you, Richika. If I could circle back to you, Rohit, in light of your specific experience with Alang, do you have anything to add?
Yes. When we are talking about Alang has drastically changed over the period of time. What you have heard from your husband was right, but those are the images of 1990s or early 2000s. But the things have been changing. Yes, what I believe is that the industry collectively have to come and showcase itself of what it is today. And Alang is very transparent today. Like there is international community which is being visiting the ship recycling yards. There is a lot of change in the behavioral aspects and the ship recycling techniques. Earlier, the focus was on steel generation, on generation of steel, and on efficiency. But with due course of time, also health, safety, environment, the human aspects, the labor welfare, all these things also rose up to that level where it is treated that every person who comes and works in this industry goes back happily. So these things are changing. There is a lot of change, and also with the employment when we are talking about. Today we have got people from naval architect also employed in the ship recycling. So this recycling sector is opening up to even the educated people, like with the environmentalists, like in handling of hazmat experts. There are hazmat experts now, those who deal with it. There are naval architects who do the weight calculations. There are many ship recyclers who have moved out of the gravity method to the lifting method and using more mechanized and crane and machinery. And like what Ms. Ruchika said about recycling on the beaches. It is a quite a wide topic, but which is misunderstood. Ship recycling is cannot like we cannot say that it is not sustainable if done on beach, but yes, very important thing is that if it is done in an effective and a controlled manner, if things protocols are met, then definitely the beaches are safe there. And also I'll come back to your question, like with the HKC, many things have been answered. And HKC plays a level playing field across the globe rather than the regional regulations who demand a certain compliance. And what we see that in the regional regulations, it is like which regulation is superseding another one. So that is something which is happening. That is I don't want to get into that, but HKC provides a level playing field in the market. And yes, everyone with taking of time, with a lot of people, a lot of stakeholders involved, the industry adopted to ship recycling. HKC, sorry.
Just to wrap up, in one or two sentences, Rohit, before we move on to shipbuilding, if you could give me one or two sentences. You mentioned the beaching method. NGOs' main concerns arise from the beaching method. Now, and for obvious reasons, it should be familiar to everybody in the room, the risk to human life, health, and the environment. How would you respond today to those concerns about the beaching method, bearing in light the NGO's key concerns? Just if I can ask you to limit it to one or two, because I'm watching a clock in front of me that is moving faster than those little taxis in London, the black cabs. So one or two sentences, please.
Yes. Beaching, it is just a mindset. It is a very vast topic which needs to get in detail on how beaching is, and it is an effective method, and it is a geographically blessed situation where a beaching occurs and bringing a ship on this beach. India has large coastline, but only 10 kilometers belt is feasible for this. So this is something beaching, but it is not about the beaching or non-beaching. It is about post-beaching, how the vessel is demolished, how it is recycled, how the blocks are lifted. I can lift this without any spillage. I can lift it with spillage. So it is as simple as that. But how well I'm treating the environment, how well it is the operations, if I would say in one word. It is the operations, and don't look at that at like you see individually things are doing, they are developing, and yes, this is something which is also being addressed. There are various innovative solutions being found out, how minimal interaction with the intertidal area is being done. So this is something which is being worked on, and sooner we'll see a lot answers to this.
Thank you. We're going to jump on to shipbuilding and repair. Before a ship's life cycle ends at recycling, which we've just discussed very briefly, the ship's life cycle will begin with construction. Now, China dominates the global shipbuilding industry. In 2024, China was reported as producing about 70% of all new builds by tonnage. Now, this figure's even higher, just shy of 80% for alternative fueled ships, the green market, for vessels running on LNG, methanol and ammonia. Now, today, the industry faces evolving challenges. Contractual risks in shipbuilding are particularly elevated due to the ongoing geopolitical risks and instability, not to mention increased pressure for decarbonisation and volatile supply chains. Now, whilst the Office of the United States Trade Representative's proposal, commonly referred to as President Trump's tariffs, have presented major concerns for owners and operators of Chinese-built vessels, it's been reported today that the US is close to reaching a trade agreement with China that, effective immediately, the tit-for-tat port fees between the US and China will be suspended. And I thank a colleague sitting in the second row for bringing me up to speed just before I came up here that that was unfolding today. However, and the key issue here commercially, obviously, for ship owners calling at US ports is it's going to be a damn lot more expensive for ships to call at a US port that's going to be captured by it. Now, I'd like to know your thoughts briefly, Paul, in terms of the chartering market. How would you suggest a ship owner best mitigates their commercial risks arising under charter parties from the US tariffs in respect to port fees on their Chinese-built and Chinese-operated vessels? Now, I appreciate, hopefully, we don't have to look at this. I know I've been advising a lot on it of recent times, but if we have press pause, but trade agreements do not come through with US and China, and we're looking at this again in a year, and an owner gives you a buzz and says, listen, what do I do with my fixtures? What would you suggest?
Thank you. Well, I've got 4 minutes to deal with shipbuilding and ship repair, including conversion contracts, which is what I was invited to speak on. Nevertheless, they are two huge subjects, and they're very different. They can't be lumped together. Very simply, the answer to your question is, anybody who's building a ship, it's a 3 or 4 year process. Often it takes 3 years before you take delivery. Nobody on earth knows what's going to be the situation in 3 years with the gentleman in the White House. All signs seem to be that whilst he causes disruption, he then backs down and things move on. I don't think Chinese builders are worried at all about Mr. Trump. We are in a seller's market and have been since COVID. And actually, that's a very interesting point. When you are deciding as a buyer to build a ship, you need to know whether it's going to be built in a seller or a buyer's market. I don't have time to drill into detail, so I'm just going to make bullet points like that. If you want to hear more, I'm very happy to take questions later. There has been a slight dent, a slight wobble in the market because of these tariffs. I've spoken to container operators and some bulker operators, and as far as they're concerned, they're not going to let the US tariffs affect them. They will simply go to other ports. We've seen that already with soybeans. People are simply just going down to South America and other places. So I think it's very much a wait and see. And as for building ships, I think, I mean, it's more a question for the traders, the big agri-grain traders, than it is for shipbuilding.
While I have you, Paul, a buyer of a new ship under construction is paying for that ship to meet a specific design, quality and schedule. A buyer's going to face commercial exposure if the ship has defects or it's delayed. When you're advising a buyer of a new build vessel under construction about their specific concerns with defects and delays, what key things would you tell them to keep in mind?
First of all, I would remind them that something people do forget. The purchase of a new build is a sale of goods contract. It's not a construction contract. A repair contract is an infrastructure, more like a construction contract. There's an excellent textbook, Keating, on offshore construction, and their a very well-known construction lawyer and a very well-known shipping QC, have edited that book because there's a lot of similarity, obviously, between construction and shipbuilding. Technically, it's sale of goods, and you have to explain what those differences could mean. I've mentioned you have to know what the market is, because if it's a seller's market, it may be that the yard space is really too full, and priority may be given to a buyer that's got 4 ships, and you've only got 1. So you need to work on that. You need to find out, is this a turnkey contract? Are you just buying a container ship or a standard post-Panamax, or is it bespoke contract? And I think you have to realize, are you building for a specific project, like an LNG vessel or a tanker or a rig that may be going into a specific project, in which case liquidated damages is not really an appropriate remedy. You're going to lose a very profitable charter, so you need to build in other safeguards. And finally, you need to make sure that your liquidated damages for delay is incentivized. You don't have to take the standard 120, 180 days at so many dollars a day. Why not load it up front so that you really make it entice the builder to finish as quickly as possible? And also, it's up to you and your technical people to make sure that the builder's construction schedule, when he says a year, he means a year. He doesn't mean a year plus 9 months of permissible delay and then some more. And there are various tools, time tools, Primavera. You have to make sure that his construction schedule is actually correct and it's not aspirational. Very quickly, in order the points I would advise him on are guarantees. You get refund guarantees for paying installments, fine. They're pretty standard, but you're also asked to give a guarantee as a buyer for your obligations, mainly in respect to the final installment. Do not issue an on-demand guarantee by your parent company. It should never be on demand. Again, I can't go into that in much detail, but it's a warning. Design is a big thing, not so much on turnkey projects, but if you start fiddling about with the design as a buyer, or you want to have buyers' add-on items put on, you could affect the responsibility over design. Always make the builder 100% responsible for design. On offshore contracts, it's often the case that the builder will have a basic design, and for a rig, semi-sub, flotel, and you will have do the detailed design, and you will have buyers furnished equipment. It could be the processing, it could be the helicopter pad, it could be all sorts of things. However, you shouldn't take responsibility for that design. You should say to the owner, the yard, here's your basic design, this is what we're doing, make sure they're compatible. You've got 60 days, 90 days to study it, make sure it works. If it doesn't work, come back to us and we'll fix it. But at the end of the day, you've got to be responsible for the design, including the integration design. So, for example, fit this pipe, one's 14 inches, one's 21 inches in diameter. They don't fit. There's not only integration design, there's installation design. I've heard shipyards come back when we've said this, and they've said, oh, but you're responsible for the concept design. There is no such thing as concept design. It's a wormhole to get through. Somebody has to be responsible for design. It should be the builder, even if he's accepting yours. Otherwise, people are just pointing fingers. Next thing, KPIs. Well, everybody knows that sea trials are meant to work out speed, performance, calculations. Can she go at the speed warranted, plus or minus? Does she consume more or less? All these other things. The problem is, the engine is built outside of the ship. Most shipyards don't build engines, they're built by well-known manufacturers. So you never really know what the effect will be on performance and consumption until the engine is actually in the ship in a sea trial. The problem is, in most shipbuilding contracts, in nearly all shipbuilding contracts, the actual power warranties for the ship are on the main engine testbed trials. It's not on the sea trials. So you've committed to the trials, engine testbeds, before it's even been put in the ship. And I've been informed by a very good friend who's a naval architect that the maker's shop tile tests are often somewhere between 7 and 10% underperformance when they're in the ship. So that's a big thing to look at.
Okay, just to wrap up, sorry to cut you off, Paul, but
Not at all.
I have someone waving their finger at me. Closing reflections, Ruchika, tell me, to bring matters to a close, what's the one thing that we should be doing now to improve the legal and regulatory framework for ship recycling in the world?
I think the best what we can do is, we have this Hong Kong Convention, which is, very good, but proper implementation and, regularly and doing it properly, that would be the one thing. If it is implemented properly, then I think it will have a good effect. That's the one thing which should be done.
Thank you. Rohit?
Sorry to interrupt. Can I just, somebody, again, a very well-known naval architect, said to me recently that the only innovation which has actually helped the environment massively is wind and sails, and wind-assisted sails on even the big ships. And it's brought down the fuel costs and the fuel consumption by 7 to 10%, which is an enormous amount, a huge saving. Everyone goes on about green fuels, and they should, like ammonia, but don't underestimate the power of wind and steel sails. They seem to be making a contribution.
Thank you. Rohit, would you like to add something?
Ship recycling had been the champion in the circular economy right from the beginning. In the maritime industry especially, ship recycling had always been more sustainable and more towards the circular economy and what we are today discussing about ESG, green, recycling, reintroducing of materials back into the system. So ship recycling had been doing that. The main concept of ship recycling was that. With the regulations, yes, HKC was drafted in 2009, today 2025. There is a lot of changes in the scenario. So definitely that also needs to be upgraded. But yes, with changing times, it needs upgradation. But also with the regulations are set, regulations have to be, IMO regulation have to be accepted worldwide rather than the regional regulations over or superseding than IMO regulation. And we should give time for this because this is just 25th of June 2025. So it is just 4 months now. So we should give some time for this regulation to be adopted worldwide and then come up with any kind of amendment which require.
Okay, well, perhaps we can revisit this time next year. And Arjun, for you, if you could wrap up, please.
Yeah, just taking on that. The most important thing we need for HKC to successfully be implemented is Europe needs to change its regulations, the WSR, Basel Convention. Right now, you have a conflict where, according to Basel and Europe, as soon as an owner has decided or even thought that the vessel should go for recycling, it's waste. So you have a situation where under the HKC, it's still a ship. Under all IMO regulations, it's still a ship. But at the same time, it's waste, which is so contradictory to each other that it's just unsustainable. So you have that clash. And that needs to, recently Basel Convention, they had the COP where they said that yes, HKC satisfies the whole regime, but they still fail to make that one change. So you have so much implementation issues only because of the conflict that you have on the Basel Convention, the ban amendment saying that vessels from Europe can't go to non-OECD countries. So that whole kind of that Western whitewash and what the NGOs have been doing for a long time, that's the biggest challenge. Once those kind of the Europe and the West change and adapt and recognize that the HKC is the IMO's main convention, it covers everything, then we are moving to actual sustainable recycling practices, not with the whole the European side of it.
Okay, I know you want to say something, Rohit, and I'm sure Ruchika and everybody here wants to talk more, but there is, I know, one gentleman in the audience whose family really want him home tonight. So on that note, thank you all for not falling asleep. And I'm going to hand you over to the next panel. Thank you.
Esteemed panelists, please maybe request you to wait back for a bit so that we can present you with the tokens of appreciation. Go. Thank you, everyone. And now, as we near the end of day 3, we bring together seasoned professionals to share real-world experiences. Please welcome our moderator, Mr. Manas Ved, Head of Marine Claims, Treasury and Risk, Maersk India, and our distinguished panelists, Mr. Dimitris Serenakis, Managing Director, the American Club, SCB Management Consulting, China, Mr. Siddharth Ranga, Director, Binnacle Legal, Dubai, Mr. Ruchir Goenka, Associate Partner at Bosan Mitra & Co. India.
Check. Good evening, all. Thank you. I still see the audience, which is a great thing. I know we have been asked to be conscious of time, so I will directly kick into our session for the evening, which is the last session for the day. I have a very esteemed panelists with me, starting with Dimitrios, who is working with American P&I Club and with us today, followed by Siddharth Ranka from Binnacle Legal Services, Dubai, and Ruchir Goenka from Bosan Mitra. With that, we will kick our session for today, and I will keep it into questions, starting with Dimitris, with you first. What, in your view, are the key risks looming with the potential to impact or continue impact maritime trade and business in the coming days? We know it's been uncertain days and uncertain times, but what is your insight on that?
Sure, thank you. Thank you all for sticking around. My thanks to the previous panel for accelerating their discourse for my benefit as I have a flight to catch. And my thanks to Maritime CEO for yet again an amazing event the last 3 days. The topic I feel presents the biggest risk at the moment is a topic we discussed earlier, and that's sanctions. With that said, because we do live in interesting times, I should start with a disclaimer, which is that even though the American P&I Club has American in its name, we're not affiliated with the American government. So people have strong opinions about sanctions. I'm here to neither defend nor promote the American government's actions. That said, as a Greek, I feel I owe everyone a small apology on sanctions because, like many things shipping, it appears sanctions are also a Greek invention. 2,500 years ago, my city, Athens, passed a decree effectively sanctioning a neighboring city, Megara, for their alliance with Sparta. Allegedly, that led, or was one of the causes of the Peloponnesian War and the end of the golden era of ancient Greece. So, query whether sanctions work. But 2,500 years fast forward, the last 3 years, we've seen increasing sanctions and an even more ramping up in the last few weeks and months. We have a situation where allegedly about $450 billion of Russian money has been immobilized. We have a situation where the EU, the UK, and the US are becoming more coordinated and are implementing stricter and stricter sanctions. I think everyone knows that Lukoil and Rosneft were the latest targets by all. Effectively, that means that pretty much every Russian seaborne crude oil exporter is now sanctioned. At the same time, there are increasing concerns that the shadow fleet, which now numbers about 1,700 vessels, 1,000 of which are aging tankers, is leaking oily discharge as it's passing through waters. We've had an incident just the other day where a sanctioned vessel grounded as she was passing the Suez Canal. Mercifully, it was a minor incident, but interestingly, she was only one of 4 ships in the same convoy that was one of the Dark Fleet vessels. So the EU, the UK, the US are responding as they see fit. And I think for me and for us here, one of the biggest questions really is how this affects India and how India will react to what's going on. So we know that historically India did not really purchase that much Russian oil. That happened really very much after the war in Ukraine. And I should be very clear in saying that this was with the explicit blessings of the international community. And it has benefited India, of course, as it would, buying cheaper oil. But it has benefited, frankly, all of us by keeping oil prices low. So India and the rest of us, but India in particular, because we are where we are, is faced with a very serious dilemma right now. There is no question that anything that India is collectively doing is illegal or sanction busting at the moment, but we don't know what the reaction will be. The US alleges that as a result of its pressure and increasing tariffs, India has drastically cut its its Russian crude oil imports. I have not seen any official statement from India at the moment. But the dilemma is this: risk retaliation from the US, or try and buy, if India can, oil from somewhere else. The difficulty with that, of course, is that the Ural oil that India buys works for its refineries. To buy lighter crudes from other sources, even if it was available, because it's committed long term, even if OPEC reverses its stance and opens up the spigots, the question is that it will increase the cost for India. There will be huge outlay for the refineries to adjust their operations to those oils. And perhaps more importantly for India itself, this will lead to higher domestic prices of oil. So what does the Indian government do? Do they risk retaliation, or do they risk the discontent we know comes in every country when when oil prices go up?
Indeed. In this context, what do you think? Is there any preparedness which comes to your mind? Do you think if you were taking Indian administration's hat on, what do you think would anything help or benefit?
Sure. I mean, check your emails every day and twice on Sunday. I mean, it's, I think both this panel and previous panels had to scrap half of what we had to say because of what happened in the last day. On a more serious note, I think the sanctions environment now is so complex and fast evolving that unless you're operating in a substantial organization, it is impossible to keep up on your own. As a P&I club, you as a member or any member cannot delegate that task to us, so you have to look to an increasing array of external providers who will assist you with doing those searches, and it's a growing cottage industry.
I fully understand there is no right or wrong in this equation when we look at it from all the angles. But I will then also check with Siddharth if you have any comments to this sanctions as a risks.
I mean, yeah, sure. I mean, sanctions as a risk, I mean, it's a age-old story for a long time. But the recent trend shows that more than lawyers, compliance officers in companies are the going after job, maximum vacancies there. I mean, sanctions has direct and indirect impact, especially on India and countries outside the EU, US, and UK. And people seem to sometimes ignore the fact that the world is so interconnected that a bank in India would still have to do a compliance check. And it will be red flagged if there is a company which is sanctioned, UK or the US. So India may still say that we do not follow sanctions, but the banks may have a branch in the US which has exposures. So I think this is sometimes not overlooked if you're looking to do international business, which I think most of us in this forum are interested in. It's something to be mindful of. I think invest in a compliance software maybe. Start with at least.
Oh, oh, thank you. Richard, do you want to add anything to what has been said?
Yeah, I mean, it's definitely changing because in the recent past, we've never really had to do sanction checks. We just gave the advice. It was pretty easy dealing with money and everything. But we have noticed that things are changing now, and clubs are more careful about who money is being paid to. Even when trying to enter into settlement agreements, there are sanction checks being conducted on them. But from an Indian firm perspective or an Indian law firm, we generally do not get that opportunity wherein we are required to do sanction checks as such. But I can see that, that it's the near future wherein that market is going to grow in India as well, where Indians will be running sanction checks to see if they can transact or not.
Oh, that's great. Thank you for the inputs. And Dimitris, thank you for highlighting that as a pertinent risk, which we should continue to see in these uncertain times. Turning you to now, Richard, I would like to kind of, you being working as an external counsel for the ship owners, what in your view brings that dimension which needs to be kept in mind while dealing with any vessel casualties, especially in the Indian territorial waters?
Yeah, so today I'm going to tell you guys about basically the Indian perspective of any ship, foreign flagged or Indian flagged within the Indian waters, coming across an incident or a casualty. So there are a number of authorities that would be involved depending on the kind of casualty. If it's a fire, an explosion, listing, the vessel is going to sink, it'll be an emergency response, which is generally given by the Indian Coast Guard or the Indian Navy, depending on how far the vessel is out in the sea. There's a statutory authority called the Director General of Shipping, which generally oversees everything water-related, which will basically be overlooking at what the Coast Guard is doing, if there's any oil spill response that needs to be conducted, crew safety. They're just the overlooking body. Then you have the Mercantile Marine Department. Each area in India is divided into nodal MMDs, which basically will conduct the investigation, will go talk to the crew, take the crew statements. Now, by chance, if the vessel has an oil spill or there's an explosion, there's a fire, and there's some kind of pollution, then the State Pollution Control Board or the disaster management authorities will come into play. If, for example, the vessel has come into collision with another fishing boat or there's a loss of life, then the coastal police gets involved. And the coastal police in India has the jurisdiction till 200 nautical miles. So they similar to the MMD, they also have nodal offices dealing with it. Now, coming to the investigations, there are two types of investigations that you need to look out for. One, like I said, is the Mercantile Marine Department, which will be conducting the civil side of investigation as to what went wrong, ways to prevent it. And then there's the coastal police. If, for example, there's a collision with another fishing boat, and we've seen that happen more in the southern states, where basically off the coast of Kerala and off the coast of Tamil Nadu, I guess it's because there's a lot of bottom trawling that happens over there. So the fishing boats go out deeper in the sea, and they tend to collide quite a bit with what you call ships. And it's also seasonal. Like we've seen that there's a rise just around monsoon time, and then it falls down again. When the MMD is conducting an investigation, it's basically a preliminary inquiry that is conducted. If there is some wrongdoing or there's some further investigation, formal investigation that needs to take place, then you can approach, the MMD approaches the court. It may approach the central government, and the central government may also direct the for a formal investigation to take place, and the court will conduct the formal investigation, commit a person for whatever crime or whatever they come across. Then after that, you will come across criminal proceedings. Now, Hari in the last talk already mentioned it, so I'm not going to cover it in too much depth. But the idea is that, like I said, the coastal police has the jurisdiction up to 200 nautical miles. So even if there's a collision far out of the what do you call 12 nautical mile limit of the territorial waters of India, the Coast Guard will act and bring the vessel in. And then after that happens, they are going to basically conduct their investigation. So there will be a parallel investigation being conducted by the MMD and a parallel investigation by the coastal police. They will take their own crew statements. They will have their own procedures to be followed. And the MMD will also take their own procedures. Now coming to the claims. So I had the experience of dealing with a vessel that recently sank off the coast of Kerala. In that situation, there were a number of claims. Before we get into the claims, there were a number of litigations that came into being. One was a public interest litigation where a lot of parties filed proceedings trying to protect the environment because they were worried that, oh, you know, because of the vessel sinking, there's oil, cargo, etc. on board the vessel, and that's going to be a problem. So they filed public interest litigations to get the state to act. Apart from that, there was something called the National Green Tribunal, which took suo motu cognizance, which deals with basically the environmental aspect of the country and environmental laws. And they also took cognizance, and they have basically served the owners, and that proceeding is still to happen. Apart from that, we came across a lot of cargo interests which were making their claims. We came across a lot of fishermen who have filed claims for both loss of earnings, whereas damage for their fishing boats, because they're saying that the vessel or the containers have caused damage to their fishing nets. They're unable to fish in that area because it's been blocked out. And interestingly, then we had this massive pollution claim from the state, a $1.2 billion claim from the state, out of which about $1 billion was towards pollution, and more specifically oil pollution. And this is where I guess Dimitri would have a couple of things to say, because the entire reason or the rationale behind the $1 billion claim was that the club cover for oil pollution is up to $1 billion. So it's not like a blank check. You need to definitely, under Indian legal proceedings, you need to prove your claim and prove your damages. But this is a big claim that came in, and it's still in court, so I'm not going to mention much about it. But that's something that we need to look into, wherein you are exposed to these wide gamut of claims, and it causes a lot of problems. Apart from that, there are conventions that do govern Indian proceedings, especially in case of casualties. It's the Civil Liability for Oil Pollution, CLC Convention, and the Limitation of Liability Convention. We have the up to the latest protocols in place in India, but we don't have the Wreck Removal Convention or the Bunker Convention in force in India. The new Merchant Shipping Act is trying to bring that into force, and hopefully that comes into play. So you can limit your liability in India, and for some reason there was, the Indian government did not incorporate Article 4 of the Limitation and Liability Convention, and therefore you get an absolute right to limit liability. There's no way you can break limitation over here.
It's interesting.
And yeah, now coming to just some things that you would want to keep in mind in case something like this happens, like what do you do? Operational risks, and how do you deal with the emergency? So the first thing that I would recommend, and we came across this issue, was that you should have a one-stop shop team for communication. When a casualty is happening, more than exchange of information or trying to find who's liable, it's more about trying to give information to the authorities so that they can act and assist. So communication, a good communication channel should always be there. Secondly is collecting vital evidence and information. You have to have the ECDIS data, the VDR data, any CCTV footage, getting crew statements, all those when it's all fresh is really important, because later on there are multiple authorities meeting people, there's multiple discussions, people are talking to each other, and then the information disintegrates. So that's something that's really important. You need to make sure there's some kind of media level management, depending on the kind of and nature of casualty it is, because if it's a collision with a fishing boat, the fishermen community get agitated. So maintaining a good image and communication is key. Apart from that, you should prevent the crew members actually from posting things on Facebook, posting things in the social media, because the moment a casualty happens and the investigators are involved, it's an active investigation, and you don't want random information being disseminated into the open media. One very important thing that you should do is call a lawyer, because they will help you understand what are the regulations, what are the requirements, intimations that you need to give, how do you protect the owners, the crew members, and just a base to explain to you how things go.
Thank you very much, Ruchir. I think it was very insightful, and it gave a lot on how you could be more prepared in order to proactively deal claims if they arise in the jurisdiction and the territorial waters. Thank you for that, and then there's always lessons to be learned at the end. Coming to you, Siddharth, from what has been already been covered, what do you think, if there are any other risks which you still see are out on the horizon or keeps you thinking over the night?
I see that we got 3 minutes, 18 seconds.
Yeah, that's fine.
I mean, I think since 2020, we've had like this surge of issues in the shipping industry. Started with COVID, and then we had the Russia-Ukraine war. It kept lawyers busy. And then the Suez Canal crisis, of course, where you had the Houthis attacking ships, unfortunate deaths of crew members. And then we had Trump and the tariffs. And I came in today thinking I'll speak about Trump, tariffs, and yes, as Jacqueline mentioned just a few minutes back, that they've suspended the tariffs, especially in the shipping industry. I think, but that is important to bring you back to regulatory changes in shipping. Geopolitics is the epicenter today, ever-changing alliances, new alliances. And in that context, I think I'll just keep it brief and just say that when chartering teams, business people are going out in the markets, they need to be conscious of the fact that the markets can change against them. And the sensible thing would be to have clauses which take into consideration that there could be regulatory changes, which then allows them to come back and negotiate terms some way. You have the hardship kind of clauses, for example, in French law, which are very common. You can have clauses like bunker adjustment factors, but you just change that for tariff adjustment factors. Those kind of solutions are there. But I think it's very important to have clauses which allow you to pass the liability to your counterparty. That's all. I'll keep it short.
No, that's very insightful, and I understand even from the lawyer's hat, you have to be innovative. Is a great thing to be. Dimitris, do you think you have to add anything to what Siddharth mentions?
Very, very quickly. Just on maritime casualties, I think two concerns, one clarification. First concern is the increasing criminalization of seafarers. We spoke about that earlier, so I won't go on it again, through it again. In terms of the clarification, I think when we talk of maritime casualties, roughly we can see them as salvage operations or wreck removal operations. A reminder that, from my perspective, the P&I Club is almost entirely responsible for the wreck operations, but before a wreck becomes a wreck, it usually is a salvage operation, and in that regard, it tends to be a hull and machinery obligation to deal with it, unless there are pollution risks, environmental concerns, in which case the P&I Club kicks in through a scopic clause. And then very, very quickly, my big concern right now is that there was a recent incident in a neighboring country where, for all intents and purposes, despite the club in question complying with its obligations under the various IMO regulations, we have seen the state in question effectively requesting an exorbitant uplift in fees, which does not be substantiated by the by the conventions, and that creates a risk for the involvement of insurers in these instances. That's it.
Right. Oh, thank you. Um, Richard, do you want to add anything to what Siddharth mentioned or anything from your side? So no, that's very good. So if I have to summarize the key takeaways from what we have spoken, then I think we have to understand that A, there might be a need to keep balance overall, and I think that sanctions will come and then things will change, which means there will be uncertain times. I think, and the trick will to keep the trade moving is about finding the right balance, probably. Um, Lastly, when it comes to casualties, I think if I have to summarize, if I have correctly understood, it's call the lawyer or call your club as and when things happen, and do not delay your notifications of the claim. I think as if we're there, it's very important to do proactive claims handling rather reactive to ensure that you can preserve your evidence, get your investigations correctly documented, and show the cooperations which you will have to do with all the authorities in the equation during the crisis, keeping your media also appraised. Okay, that's very good, and I think that is all from our side in order to sum up the session, and I hope I kept the time. And thank you very much to Sanjam and Maritime CEO for inviting us all to talk on this evening, and also to India Maritime Week and the authorities for taking the interest in taking the maritime industry forward. Thank you very much, ladies and gentlemen.
Invaluable lessons. Please, could you wait back for a bit so that we can present the tokens of appreciation? Thank you very much. Before we wrap up, it's time for one last celebration as we present the CEO to Watch Out For Award to Ms. Ana Clara, Senior Legal Counsel and founding member of Vista Brazil. Congratulations, Ana. Please may we request you to join us on stage. And also, please kindly invite Ms. Magdalene Chu, Director, Asia Legal LLC, to do the honors, please. Thank you so much. And as we now dock the end of day 3, I'd like to thank all our speakers, moderators, and the audience for keeping the conversations alive. Before we close, once again, a heartfelt thank you to all our sponsors whose support has made AnchorCon 2025 possible. And now to bring the day to a meaningful close, please join me in welcoming back the founder of Maritime Shio, Ms. Sanjam Shahi Gupta, for her closing address.
Thank you everybody for being so patient and staying back with us. So as the first edition of AnchorCon closes, I want to thank you all for being here and showing support to us. I'm confident this is the start of something very special in the years ahead, and I hope to see even more participation and engagement and a stronger collective voice for more women within the legal community. We've talked about laws and logistics, yes, and also about leadership and the kind of legacy that we want to leave behind. And today reminded me about why I love the industry, because behind every ship, every regulation, every policy, there's a story of people who care deeply about the ocean and about doing what's right. And as I close, I want to say this: anchors are not symbols of stillness, they are symbols of stability. They remind us that we can hold our ground even as we prepare to move again. Until then, let's stay anchored in integrity and sail forward with purpose. Thank you, and see you next year at the Maritime Shio 2026 and AnchorCon. Thank you so much.